integration challenges related to integration. At the end of the day, how the European Union handles this responsibility will have a significant impact on security, migration management, internal cohesion of the European Union, and its position of the European Union on the international stage. In any case, it's a real pleasure to have you all here. I wish you all an inspiring, productive, and rewarding meeting. And as I said before, your house.
Thank you, Andrea.
Bona tarda, benvingut a tothom en nom de l'Observatori de Dret Públic de la Universitat de Barcelona i del grup d'estudis sobre drets dels migrants. Good afternoon. Welcome to everyone in behalf of the Observatorio de Dret Públic of the Universitat of Barcelona and the Grupo de Estudios sobre Derechos de los Inmigrantes. In fact, I'm not Laura Wizzi, I'm Diego Boza, and I would like, first of all, to apologize to the director of the observatory, David Moya, because due to the flight issues, he has not been able to participate in this presentation. I will not afford the content of the project. I will say some things from the institution I represent today. In this sense, we are very glad to have given support to the shared project, whose final event we are opening. And we are very glad because the shared project unites a large part of the objectives that as an academic and research institution we have. First, it delves into the issue of the European immigration regulation and addresses one of its most relevant issues, the situation, the regulation of the EU's external borders, a very important question in the justice activities. Second, if I may so, it also makes possible to contribute on the rejuvenation of this type of initiative. It's one of the programmatic lines of the observatory. And in this sense, having predoctorates among the promoters is an added value, even more so when many of the speakers are also young researchers. And last but not least, another essential point in observatory's objectives, going beyond the academia, and the project aims to go beyond and influence, or at least try to influence, European policy. Therefore, I can only thank the organizers, Professors Moreno, Jordana, and Salzano, the other institutions that support this initiative, the speakers, and the rest of the attendees for their efforts, and hope that the conference is as fruitful and interesting as it seems before. Thank you.
Thank you very much to Professor Olesti and Dr. Boza, representing the Faculty of Law of the University of Barcelona and the Institute of Public Law and the Group of Migration Studies. I am Violeta Moreno-Lax. I'm the principal investigator of the shared project, and I'm representing the third leg, institutionally speaking, that has supported this initiative alongside a number of members of the European Parliament, which I'm going to be citing in a bit. So I represent the Borders Center of Queen Mary University of London, as well as University of Barcelona, as a current Ramon y Cajal investigator. But I also wanted to extend my thanks to the offices of the MEPs from three different political groups. From the left, Cornelia Ernst and Mariel Biok. From the Greens, Tineke Strik and Eric Marquardt. Tineke is going to be delivering one of the keynotes that we're going to have later today. And Birgit Zippel and Juan Fernando López Aguilar, who are both from the SMT, the Social Democrats. Juan Fernando will also be here with us today, delivering one of the keynotes tomorrow. So it's a pleasure to welcome you all physically and online. Thank you for joining, everyone, in what we hope will constitute an important and interesting exchange on the notion of shared responsibility. The purpose of this final conference, with which we're going to be concluding the shared project, a 1-year-long initiative that started several months ago already, is to discuss and disseminate the project findings in different but related areas in which we have been working in 4 thematic groups that constitute the panel division that you find in the program. The main objective is to determine the meaning and the implications of shared responsibility as referred to, for example, in Article 7 of the Frontex regulation, but not only. There are different conceptualizations that we're going to be delving into and unpicking as we go along today and tomorrow. And we're going to be looking at this in relation to integrated border management of the EU's external borders. And we're going to try and do this from a legal, political, or policy and operational perspective, which we think are complementary. And this with a view to identifying adequate approaches, definitions, and arrangements, particularly when the European Union or its member states, typically with assistance from the Frontex agency, collaborate with their countries or private entities in territorial, also extra-territorial settings, with the potential to interfere with fundamental rights and other legal obligations under EU and international law. So the end goal is to collectively identify good and bad practices that we have summarized in a joint guidelines document that has been collaboratively produced by all project partners. So not only the academics, but also the stakeholders that have very generously cooperated with us all along. And our hope is that this provides direction to future policy and legal developments at the EU level and makes concrete recommendations and proposals for the way forward. Our keynote speakers, Tineke Strik and Fernando López Aguilar, will comment on the guidelines, which will also be discussed at the stakeholder roundtable tomorrow. The guidelines, we hope, can inform practice, but also influence the legal reforms that are currently under negotiation as part of the new Pact of Migration and Asylum package of instruments. And also the evaluation of Frontex that the European Commission should be preparing and release before the end of the year. So as you can see from the program, and I already mentioned, we have organized the discussions around 4 thematic areas covering what we think are key topics, key issues regarding shared responsibility and its relationship to integrated border management. The final version is available in print and online for those joining us from Zoom. The expectation is that our academic experts deliver their papers in about 10-15 minutes, and that then we hear the feedback from chairs and discussants in another about 10 minutes before we open up for general discussion and debate, both online and in person, see how it goes with the hybrid format. This is all for now. Welcome all very much to the final conference of the shared project. Thank you for coming from quite far away in some cases. I hereby declare the session open and pass on the floor very quickly to the chair of panel 1, Professor Elspeth Gilt from Queen Mary University of London, who will be joining us online. So we'll make the transition in a few moments. Thank you for your patience. Thank you very much again and welcome to the conference. Dear Elspeth, the floor is yours.
Thank you very much. It's a great pleasure to be here. And Violetta, I want to congratulate you on bringing together so many excellent scholars on an issue of tremendous legal, political, and humanitarian importance. I have followed your work in this field for many years, and we have worked together on a number of occasions in respect of it. And I must say, I think this is a very timely moment to look at the questions, the legal questions, and the how they impact on the political choices which are being made about humanitarian intervention, the law of the sea, and the title of this particular panel, Action on the Ground, the Day Today of Joint Operations of Frontex. I have four panelists on my list, and I hope I have the last version of the program, because I intend to call first on a lecturer at the University of Barcelona, Laura Salzano, to present her work on the concrete content of fundamental rights obligations of actors involved in Frontex coordinated joint operations. Laura, can I hand over to you? And you have 10 minutes to present your terrific outline and recommendations, which you have set out in your paper, which I have had the pleasure of reading before the event.
Thank you so much to you, Professor, and to everyone here and online joining us today. Sorry. Of course, this is happening. Okay, so I will present today my article titled Charting the Course of Fundamental Rights Duties, Disentangling Obligations in Frontex Coordinated Maritime Joint Operations. And I will use as a case study the shipwreck that happened in Steccato di Cutro in the southern coast of Calabria in Italy. No? No? Yes. So I will first present the responsibility regime of the agency, then start the analysis from Eurosur, understand which are the consequences of the detection at sea of a vessel in distress, outline which level should be informed and how, step by step, and then I will draw some conclusion. So the responsibility regime under the currently enforced 2019 Frontex regulation as this kind of civil line formula, as I called it, because the agency and the national authorities share responsibility for the implementation of the European Integrated Border Management, the main task of Frontex, whereas national authorities remain primarily competent and responsible for the management of their section of external borders, but at the same time, under 7.4, the agency is fully responsible for the decision it takes. So in my understanding, also concerning the European Integrated Border Management, and the activities it is solely responsible for under the Frontex regulation. Understanding how this concept applies from time to time, it's not so easy. And what has happened in reality is that if an unlawful event or a tragic event happens, usually national authorities and Frontex engage in a ping pong of shift blaming, making it difficult to understand who is responsible for what or who should be responsible for what. So going to our case study in the shipwreck of Cutro, in that moment, there was an aerial asset of Frontex called Eagle One, deployed under the Joint Operation Themis, that is the one operating at the Italian external borders, that saw a vessel that was approaching Italian coasts. And Frontex communicated to Italy that there was no distress sign and that the vessel was proceeding in good conditions. There were 200 people below the deck and no life jackets, and Frontex duly informed the ICC about the presence and location. What then Italy did was launching an interception operation and therefore deployed the Guardia di Finanza, which is the Italian custom police, which is not equipped to start a search and rescue operation, and due to the adverse sea conditions was not even able to reach the location where the vessel was. So Italian Coast Guard was not even alerted. And for this reason, at the end of all these chain of events, almost 100 people died, and it's not clear at the moment who was responsible for that. And there is a case pending in Italy. So the starting point of the analysis is the Eurosur system that has been used in the last 10 years in Europe, it's managed by the agency that is responsible for the management and accessible also by the member states. So Frontex and the member states through Eurosur exchange information on whatever happens in all the pre-frontier and frontier area, not external borders, mainly concerning the detection, prevention, and to combat irregular migration and also cross-border crimes, and contribute to save lives. This is actually the way it was presented by the European Commission as a contribution to the prevention of the loss of lives at sea. It operates always like 24/7 and offers near real-time information on whatever happens at external borders. So it guarantees that everyone is always informed at the same time on whatever happens at external borders of the European Union. So claiming that some kind of authority at any level is not informed of an event, it's very difficult, if not impossible. So the information flows. So when the deployed officials, that in this case will be Frontex with the aerial asset Eagle One, if there is an important event that should be communicated under the Eurosur regulation, is organized by a joint reading of 3 different pieces of legislation. So the deployed official have to communicate to the International Coordination Center that is established under the Seaboard Regulation, and the National Coordination Center that is established under the Eurosur regulation, and then also the National Contact Point that is established under the Frontex regulation. Should the object of the communication be a SAR event that they need to launch a SAR operation, then also the Maritime Rescue Coordination Center established under the SAR Convention has to be informed. In this case, the MRCC was not informed, and therefore a SAR operation was never launched. Just one parenthesis on the Seaboard Regulation is a regulation that was enacted in 2014 and covers, as per its objective scope, exactly Frontex-led maritime joint operation. The issue posed by this regulation is that it was enacted in 2014. So when the agency was running under its 2011 revision, which was only amending the possibility of processing personal data. So basically it was the very first Frontex with the amendment of 2007 concerning the rapid operations. So the agency was very different than the one that we know now, because it was before the 2016 revision, marking the shift from Frontex to a fully fledged European Border Coast Guard Agency. So it was an agency that was merely offering support and coordinating member states' activity. And for this reason, the regulation, the Seaboard Regulation, only identifies member states as main actor and responsible, but it depicts a situation that does not exist in reality anymore. The notion of distress that, according to Frontex, was not a situation unfolding in Cutro is not, however, subject to much interpretation, because the Seaboard Regulation that takes verbatim the SAR Convention gives us some very useful elements to interpret. So, of course, the notion of danger, so the vessel must be in danger, or it has been impossible to establish some contacts, or it's likely, the likelihood that there is a distress is enough. And in order to understand if there will be a distress, there are some elements that the deployed officials need to take into account. Again, that's the Seaboard Regulations that takes verbatim the SAR Convention. The request of assistance, that is not our case today, but often happens in the Central Med, and the seaworthiness of the vessel, thus contradicting the executive director of Frontex when heard by the LIBE Parliamentary Committee at his first hearing. He said that the seaworthiness is not an element to be taken into account, but the law says otherwise. The number of persons on board, this is relevant to us because there were 200 people on board, of course, in comparison to the size and the quality of the vessel, and some other elements that could not have been noticed by the Eagle One, but also the weather and sea conditions, including weather and marine forecasts, which were easily noticed also because the Italian custom police was not even able to reach the spot due to the weather conditions. The weather conditions also were noticed by Frontex itself. This is an extract of the communication between Frontex and Italy that was leaked by an investigative news outlet called Lighthouse Report. So Eagle One was not able to conclude its operation due to strong winds, which is underlined. I'm not sure you can see that from there. And so that is surely an element that they could have taken into account. So to conclude, because also I believe I finished my time, starting from the premise that ignorance of what happens at sea is to be completely excluded or very likely to be excluded, and trying to allocate responsibility in this specific case, the European Border Coast Guard Agency was responsible for not communicating all relevant details to the national authorities, and therefore is responsible under EU law, and namely the Eurosur regulation and the Sea Border regulation. At the same time, national authority, in this case Italy, could have nonetheless launched a search and rescue operation because it was aware of the weather conditions, and thus is responsible as well under EU law as well international law under the SAR Convention. As speaking of policy solutions for the way forward, allocating ex ante responsibilities from time to time is urgently needed in order to prevent these shift blaming tactics that we always witness. And the EU regulations should be updated to reflect the everyday reality of joint operations at sea and of land borders. Thank you.
Thank you very much, Laura. When we come back to the discussion, I will ask you to explain a little bit more of what you put in your paper on the ambiguities of the chain of command. That was something which I thought was particularly revelatory in your written paper. And I'm sure that our audience would like to hear more about that in the Q&A. But let me move to the second paper, which is Sissi Katsone of the University of Bochum. And you're going to talk to us about the insignificance of operational plans in the determination and apportionment of shared responsibility. And once again, I was very impressed in the written work which you produced for this event with the pertinence of the proposals you made for how to deal with the problems. You have 10 minutes.
Thank you very much. Thank you very much for the introduction. It's a great pleasure to see everyone again, and I'm happy to see that with you I'm getting a clearer understanding of what this shared responsibility, this reference to shared responsibility in the Frontex regulation is about. As you may remember, my contribution centers on operational plans and their contribution to the determination and apportionment of the EU's and the states' shared responsibility. To be more precise, my presentation will first highlight how operational plans contribute to the identification of situations where both the EU and the states share responsibility for their contributions to violations that take place in Frontex coordinated operations. And it will also highlight how operational plans contribute to the assessment of which responsibility share or which portion of the overall responsibility each side bears. Ultimately, it will recommend ways for the enhancement of these contributions to the operational plans. Operational plans contribute to the determination and apportionment of shared responsibility in two ways. First, when the provisions of an operational plan are per se incompatible with the relevant law, which was arguably the case in the rapid border intervention that took place in the Turkish-Greek borders in March 2020, the actors involved in the operational plan's conclusions, that is the EU through Frontex and the host state, will have agreed on the implementation of an unlawful operational plan as equal parties among which a horizontal relationship exists. In such cases, the operational plan evinces that the parties will have knowingly engaged in a concerted course of conduct for the achievement of the unlawful goals that are set out in the operational plan. Of course, concerted action itself is not a widely accepted basis of international responsibility, neither under the EU law nor under international law. So it would be wiser to assess the contribution of operational plans in the determination of shared responsibility against the background of a more solid basis of international responsibility, such as the one of aid or assistance. Even from this viewpoint, operational plans are important for shared responsibilities determination, as they evince that the EU, through Frontex, will have knowingly assisted the host state in the commission of the wrongful conduct. Precisely, the operational plan, that will be entailed therein will constitute proof of Frontex's knowledge, and arguably the same could be noted with regard to the consultative participating member states. Even though the secrecy surrounding the drafting and conclusion of operational plans does not allow for certainty on this state's knowledge about the host state's intention to misuse the members of the teams for the commission of wrongful conduct. Alternatively, if the parties conclude a lawful operational plan, this plan will be evincing that any violations occur at the stage of the implementation, and thus that the parties share responsibility, as the state will have implemented the plan wrongly, potentially being incompatible with the operational plan instructions to the team members, and the EU, through Frontex, will have assisted the state by inter alia monitoring the operational plan's implementation improperly and by allowing the continuation of the operation. In this context, the operational plan will be evincing Frontex's knowledge of which terms were agreed upon between the parties, and given its broad coordinating competencies in the execution of the operational plan, it will further know that these terms were not implemented as was agreed, and hence it will be knowingly assisting the state in its wrongful conduct. Here, since the terms of the operational plan will be lawful, it cannot be said that the participating member states knew of the host state's intention to issue incompatible with the operational plan instructions to the team members, and thus they cannot be seen as also aiding or assisting the host state. When it comes to the apportionment of this shared responsibility among the responsible actors, operational plans, when their provisions are unlawful, can be seen as revealing a causal link between the parties' conduct, which was based on their agreement to cooperate for certain wrongful goals, and the eventual wrongful outcomes. If the operational plan's provisions are lawful, the operational plan will be evincing the causal link between the Frontex's inadequate monitoring of the implementation of the operational plan and the eventual wrongful outcome that would otherwise be seen only as an unlawful conduct attributable to the host state. How this could be translated now to into responsibility shares is a reasonable question. Given that the host state's responsibility will be primary and Frontex's responsibility derivative, and considering Article 7 of the Frontex regulation, which seems to be envisaging a shared responsibility whereby the host state bears the primary responsibility share, the state could indeed be seen as bearing the primary but not the sole responsibility share. However, although the contribution of operational plans in the context of shared responsibilities determination and allocation could theoretically be significant, various parameters lessen their usefulness in practice. Precisely, operational plans are rarely accessible, and when they are, so much information is classified that what is left is actually too little for any external criticism to be raised. Moreover, the internal assessment of the operational plan's lawfulness by the Fundamental Rights Officer or the consultative fora established by Frontex are evidently either not objective or insufficient to ensure the operational plan's lawfulness. Most of all, these assessments give operational plans a guise of lawfulness and make it even more difficult to establish the assisting party's knowledge of the operational plan's documents. Against this background, enhanced transparency and external assessments are needed. Transparency in the deliberations prior to the operational plan's adoption is crucial for a clear understanding of whether and when the participating states knowingly assist in the commission of the wrongful conduct. Similarly, if provisional operational plans as agreed on between Frontex and the host member state were published before their implementation and a brief time frame was given for external feedback on their lawfulness, then violations relating to the implementation of unlawful operational plans or the misimplementation of lawful ones could decrease, while it would be also easier to verify the parties' knowledge of the operational plan's unlawfulness. Moreover, the publication of the operational plan's final version would enhance the operation's legitimacy and enable constructive criticism. In light of the foregoing, Frontex's excessive secrecy towards operational plans publication, as well as the failure of its internal legality assessments to prevent wrongful conduct in operations, should be investigated. The introduction into a revised version of the Frontex regulation of an explicit obligation imposed on Frontex to publish operational plans and to restrictively identify the operational plans provisions that shall be classified could be helpful. Moreover, the Frontex regulation would benefit from provisions introducing the external legality assessment of operational plans by external experts on the enhancement of independent oversight of Frontex, and the same would hold true for provisions clarifying the term shared responsibility in the Frontex regulation. Additionally, efforts for the EU's accession to the European Convention on Human Rights should be reinvigorated so that the forum would be actually competent to determine and apportion the shared international responsibility of the EU and the involved states for violations that take place during Frontex coordinated missions. Thank you very much for your attention. In the interest of time, I will stop, and I remain at your disposal for any questions and further discussions if that's of interest. Thank you.
Thank you very much, Sissy, for a very interesting presentation. I will want to ask you when we come to the discussion about the very interesting part of your written work, which was regarding unlawful operational instructions and lawful ones, and the consequences of a lawful or unlawful operational plan for the responsibility of different partners. And I thought there was some particularly interesting issues and particularly interesting international law legal issues about member states who are participating in a project, who are being given orders to participate in what is obviously an unlawful operational plan. But we'll come back to that in due course. I want to turn now to our third and final presentation, which is by Dr. Mrnexu Jordana. And you're going to look at interagency cooperation and responsibility implications of Frontex collaboration with the EU Asylum Agency and Europol through joint operations. Can I give you the floor, please?
Buona tarda. Thank you very much, Esther. The external border and migratory flows management is one of the AFSJ main objectives. In this area, Frontex, the European Asylum Agency, and also Europol play a significant role. Part of the task of these agencies is operational in nature. And the system is characterized by overlaps in the mandates, the opacity in how the coordinated tasks are carried out, and consequently the difficulties in determining the final responsible of a concrete action. This reality is especially problematic when fundamental rights are affected. Frontex, the European Asylum Agency, and also Europol are identified as decentralized agencies. There is no common regulation that defines and delimits their operations, management, and accountability. And even the adoption of the common approach in 2012 did not cover this shortcoming. And in practice, each of the decentralized agencies have been established and strengthened in an ad hoc basis. Besides, these agencies have operational functions, sometimes developed on the field, and there is no unified definition of which activities are included in operational work by these agencies or how they must work together. A review of the regulations of the agencies, each regulation does not clarify this issue. For instance, in the case of the fight against smuggling, it is supposed that both Frontex, according to its Article 1 of its regulation, and also Europol, according to its Article 3, are competent to obtain and analyze information. These overlays clearly appear, for example, in the external dimension of these agencies when working with third countries to achieve the EU goals. According to Article 68 of the regulation of Frontex, Frontex and Europol shall cooperate within the framework of working arrangements. The negotiation and the conclusion of these soft law instruments depends on the agreement of the two agencies. A first revision of the provisions of this arrangement shows a poor and excessively flexible cooperation scenario. And also Europol, for instance, has no any kind of arrangement with the EU Asylum Agency. A special reference deserves the presence of the agencies in the hotspots. This approach lacks of a legal definition and provides a clear and detailed definition of what a hotspot should be and how it should work. The maintenance of fragmented, not coherent, and diffused legal framework, at least from my point of view, adds to the fact that the hotspots were conceived as a political response to address an emergency situation, allows to question the whole system. Despite the lack of definition, the European migration agenda aimed at the involvement of the EU agencies, in particular Frontex, Europol, and the Asylum Agency in the hotspots. The explanatory note of the Commissioner of Justice and Home Affairs showed to clarify that the approach main objective was to provide a platform for the fast and integrated intervention of the frontline agencies to face a specific and disproportionate migratory pressure. According to this document, the activation of the hotspots requires request for assistance by the affected member state. However, the note describes the role of the agencies, but only in the flowchart. It doesn't not exclusively attribute none of the tasks to an agency. So it's always appearing in the flowchart. It always appears paired with an state. So it's the agency and the state who is doing the task according to the flowchart. The development of both EASO and Frontex to offer operational support at the hotspots is based on their respective regulations. This is characterized by a preeminent role of Frontex. For instance, the remission to Frontex regulation made by Article 16 of the European Agency of Asylum. Despite being approved after the hotspot approach, the Europol regulation does not mention the hotspots and does not specify the functions to be performed by the agency there. Therefore, Europol's goal of playing a significant role in the fight against smuggling and trafficking of human beings would be the justification of its presence in the hotspots. Even if Frontex sometimes said that it's very complicated, for instance, to identify victims of traffic or fighting trafficking in the border. So sometimes it's complicated to understand why is Europol there. And it makes me think that if it is necessary, because if the working arrangement would work, maybe it was not necessary. Maybe we can later discuss it. In any case, the operational work of Frontex, the European Agency of Asylum and Europol cannot consist of executive or enforcement activities, which should only be assumed but by competent authorities of the member states. Sorry. The action of the agencies cannot exceed what is strictly necessary in accordance with the treaties. And according to Article 4.2 of the TEU, the EU action must respect essential functions of the state, such as the responsibility linked to the maintenance of law and order, the safeguarding of national security. So, and this idea is reinforced explicitly by Articles 72 and 73 of the Treaty of Functioning. And in the context, especially in the context of the area of freedom, security, justice, the evolution of the Meroni Doctrine accepts that the EU level agentification. However, the court states that the constitutionality of the delegation of powers of the EU agencies depend on certain conditions, such as the limitation of powers and the existence of the judicial control. In other words, the existence of agencies remain compatible with the democratic and legal system based on the rule of law, as long as their activity is subject to control. It is the degree of discretion that the EU agencies might have in practice, but there is no justification to certain tasks and powers attributed to the centralized agencies that are commonly associated with the state's agents. For example, in the case of Frontex, the possibility of starting operations or participation in arrests and interrogations, or their agents on the ground carrying weapons, being able to use them. So the impossibility of determining who assumes each of the tasks in an interagency context reinforces the idea that operational work in the field can translate to impunity. In fact, which are the solutions that I propose given this scenario? My idea is that there is the need to increase the transparency in the operational activities of the agencies. It's also necessary to establish an ex-ante with functions of each agency responsible to discharge, and with a specific delimitation of responsibilities. Also, the cooperation framework between the agencies of the area of freedom, security, and justice should be detailed enough to allow for the attribution of each operational action or omission to the corresponding agency and avoid accountability gaps. So the policy recommendations that we present in Brussels and are in some way included in the guidelines are to adopt a general regulatory framework, kind of regulation maybe, for EU agencies, establishing their functions, management, and accountability when they intervene in operational settings, in order to ensure a proper delegation of powers, right, in line with EU constitutional norms and principles, also the Meroni Doctrine, and establish a legal framework for cooperation between AFSJ agencies based on a binding instrument, maybe regulation also, that delimits the capacity of action of each agency concerned, clearly determining who should do what avoiding the use of soft law instruments, which are unenforceable. And last, provide a detailed distribution of tasks between the member states and the agencies in the respective legal instruments of each agency, Frontex, Europol, and also the Asylum Agency Regulation, in accordance with the provisions of the treaties, in particular respecting the limits imposed by Articles 72 and 73 of the Treaty of Function. And that's it. Thank you very much for your attention.
Thank you so much, Mirextu. That was it's a very interesting paper and a very interesting presentation. And I must say, when I was reading it, I was very impressed at how you had drawn out the ad hoc nature of the allocation of powers and the expansion of powers, with the complete lack of a proper treaty basis for what is going on. And I wondered whether there are any comparisons with other areas of EU law where there has been an equally astonishing lack of attention to the constitutionality of the way in which powers are distributed. But I'll leave that for the comments. I just wanted to come back 1 minute to Violeta. I believe that we do not have another presentation. Is that right? That's correct. Okay, perfect. Then can I ask Mr. Tsioukas from Frontex Fundamental Rights Office, who's going to give some stakeholder comments. And I think we're very much looking forward to them, in no way in a combative mood, because we're absolutely delighted that you're here and ready and willing to speak to us. We have lots of time, so I would happily give you 10 minutes if you want to expand a little bit on the answer from a human rights perspective from within Frontex on the presentations we've heard.
Thank you. There's no now. Okay. Thank you, Chair. So let me start. I have 10 minutes, right? So I'm tempted to speak a lot. So I mean, but okay, I will respect the rules of the panel. So please interact. So, but I suppose that we will have also time. So I want to start by first of all to thank you for this invitation, and it's not just a typical thing for me to say. I really enjoyed the reading of this thesis and of this article. So, lot of food for thought, very rich documents, and very, I would say, tempting ideas to start to engage in a very rich discussion. I will start with Laura's paper. I mean, two different things here. One about some, I think, crucial factual element as regards this particular incident, the secret Cutro, and then a few thoughts more on what are the issues that fundamental rights, not fundamental rights, but the Frontex operational staff are facing, and by consequence also us as well, as an internal monitoring mechanism. But first, the factual elements. In the case of Cutro, as in all cases, the team that is responsible for this sighting, because you have a drone or a manned plane, and they record something. So the established procedure is to inform ICC if it is in the context of a joint operation, or the National Coordination Center if it is in the context of the Eurosur. Okay. So they inform them who is the coordinator of the International Coordination Center, always an officer of the national authority. So in that case, an officer of the Italian authorities. And at the same time, the relevant research coordination centers are in system. So they get the information also of the research coordination centers. And this is the case also with teaching. So, I mean, they were all aware. And why this is here, not, let's say, the main number is other three, because this is the agreement between the national authorities in context how the information should be shared, right? So one could say, okay, let's have RCC also as the main addressee and not ECC, but I don't know if it will change much in time. Okay. So the authorities were informed about that incident. And what else Frontex operational staff are doing in such cases? They send this email with the report, the information, the sighting, so a visual, and also information that they have at their disposal. What they don't do, and this is also again in the context of this agreement with the member states, they do not qualify themselves the incident if it is because emergency, if you think the international rescue, there are three phases, right? There is alert, there is what else is it? And the third stage is there. Okay, so they don't qualify because Frontex and the EU, neither Frontex nor the EU as a whole, they have by international law any role in search and rescue. If you think about this service that Frontex is providing to member states, this multiple aerial surveillance service, the name is telling it is a multiple aerial surveillance. It is about cross-border crime, but also to support safety. So they put together all the information that they have. In that case, and actually, if you have seen the picture, it is only one person. All the rest, they are under the bed. So nobody knows how many people are there. What they see is some thermal activity. And they suppose, but this is an assumption, that something because someone is behind the bed. And given that this boat was coming from Turkey, the assumption was that, okay, probably we are not talking about something machine, right? We are talking about cooking. So it is an assumption that Frontex staff did, and they informed the Italian ICC, so the Italian coordinator, and having also informed the coordination center. So this about the facts. Now, it's good that also Italian fiscal authorities are looking. Also, to my knowledge, they are also asking questions from Frontex to provide. Yes. Okay. Sorry. It is, I mean, for me, it's very positive that the Italian judicial authorities are looking into the case and also asking questions and information from Frontex, because this also shows that Frontex is indeed accountable also to national judicial authority when it comes to liability, right? Of course, one might say, and this is maybe something that one should consider in the context of your papers and the guidelines, the issue of immunity, right? So I think this is important, especially when we talk about activities in member states, because the discussion about immunity when it comes to third countries might be a bit more, let's say, complicated in the sense that you might, I mean, things that in EU context might be considered as legal, in a different context might be considered as illegal. I have in mind, for example, LGBTIQ rights. I have in mind consumption of alcohol or other substances. So one has also to take this into account. But anyway, this is but now coming back to the more legal questions that the operational staff are facing. First, I agree that the sea borders regulations needs to be revised, because when you look at the provision defining what is a participating asset, context is not there. So one could say, if we take the interpretation very narrowly, since context is not mentioned, then the sea border regulation applies only as regards assets deployed by the national authorities of the coast state and by participating member states. Okay, so definitely this will need to change. Then there is another issue that it is a different responsibility when we talk about services that Frontex is providing, and in the context of Eurosur, and it is a different legal framework when we talk about operational plans and activities in the context of joint operational activities. The accountability of Frontex, I think, is higher when we talk about operational plans than services. And then, yes, as I said, Frontex is not a search and rescue actor. And I mean, to change this, probably this would require not just changing some EU regulation, but probably also having a broader discussion at the international level as regards who are identified as actors. Can non-state actors, in strict sensu, be search and rescue actors, meaning declaring an incident as a SAR event, right? And the last point, which I think is very crucial, but it's not directly related to your paper, Laura, but I think it is of critical importance, is this, as I qualified, and I've done this before in the past, as a sort of dilemma that Frontex operational staff are facing. I see Timothy here as well, and I think that Hans Leitner was also referring to this dilemma the other day during your hearing, is that, okay, you see a boat, right? And this boat is in distress, or you assume that there are good reasons to consider they are in distress, which means that their life is at risk. But then, if according to international law, you have also to inform the Libyan authorities about it, because they are under, in the context of the Libyan search and rescue zone, what do you do? In order to avoid violating the principle of non-refoulement, you allow these people to continue going, right? And then who will be held accountable if there is a shipwreck that, and people could have been saved, I mean, their lives could have been saved by a Libyan boat, and we didn't do it because for reasons that we all understand and we all discuss. I mean, it is not linked to your paper, but I mean, reading your paper, I thought that this is something that I would like to mention during the discussion. So now coming to Sisi, I know that I'm talking too much. It's already 10 minutes. It's already 10. I can stop if you wish, but okay. So Sisi and operational plans. Well, something that it is important, I think, is the concept of Frontex activities and Frontex participants. And why I'm saying so? Because, okay, you say Frontex operational plan. If you have an operational plan, if you have a joint operation, then Frontex is by default somehow accountable as well, together with the member states. Okay. But look what is happening in practice in the field. You have certain people who are identified as Frontex participants, and these are people that are deployed by Frontex, and also a number of people allocated by the national authorities. To do what? Do a list of activities. This can be fingerprinting, can be debriefing, can be screening, can be registration, can be border surveillance, land border surveillance, patrolling, can be sea patrolling. Okay. Not all these activities are performed in every operational area, and not all the national officers who are acting in the area that is also an operational area for Frontex, they work with Frontex, right? So practically, what does this mean? You might have a situation where a Frontex patrol is patrolling a certain border sector, and then a national patrol, to use the example of my country, I'm from Greece, a Greek patrol is patrolling, is doing surveillance, border surveillance to the next border section. Okay? Frontex has no contact with the border patrol of the Greek authorities. Their staff is working with some Greek officer in the defined border section. So, can Frontex be held accountable for the activities that the Greek patrol did in the next border section? And I'm referring to accountability in terms of legal, criminal, or non-contractual liability. I'm not referring to Article 46. We can discuss about it. I'm not referring to, okay, what are you doing in Greece? Take a decision not to be there because, okay, maybe you are not involved in fundamental rights violations, but next to you, things are happening. So, and I think that this is a distinction which is quite important to make. Also in terms of identifying what we are discussing here, who is accountable for what. And then activity. So in many cases, you have Frontex who are doing only what we call border management activity, let's say screening, fingerprint, and they are not involved in border surveillance activities. The border surveillance activities are only with the national authority. So if I'm there taking fingerprints, am I responsible for what national border guards are doing 10 kilometers from where I work? So I think these are elements that, and this brings me to the other topic, which is the causal link, which is after the recent decision of the General Court is quite relevant here. So what is the causal link between the fingerprinting and the border surveillance of the national authorities? What is the causal link between, and then we might get closer to the causal link, but still, what is the causal link between my border patrol, which is here, and a border patrol 10 kilometers from here, where I'm not involved at all? So these are things I believe that one should keep in mind. Article 46, I'm also looking forward, to my knowledge, that there have been a couple of cases before the General Court again, and I would like to see also how the General Court will assess those cases. On Article 46, and what does it entail for the Executive Director of Frontex, right, to take a decision. And we are very much interested to see, because there have been cases, it's no secret, that we have been suggesting some measures under Article 46. And I'm not referring only to withdrawing totally from an operation, but you can also suspend funding, you can stop a certain activity, so no border surveillance, only fingerprinting, for example. That's now for the ideas. And the last point on transparency, yes, it would help, But keep in mind that Frontex operational plan, I'm referring now to operational plans. Frontex operational plans are not Frontex operational plans. These are agreed by member states. And for Frontex to disclose or to start sharing this operational plans with other stakeholders, member states should also agree. And believe me, I don't think that this will ever fly unless if there is a change in the regulation obliging member states to do so. Otherwise, this will never happen. And last but not least, Mirenki, actually, here, two things. Yes, I wanted to say more, but I will stay in the interest of time. First of all, the Fundamental Rights Agency role, I think it has to be strengthened. Also, in a context of establishing an external, I don't want to call it monitoring, we can call it monitoring or whatever, an external independent monitoring. I'm not suggesting, and I think that our role as internal mechanism is very important, and we should, should stay. I'm not now defending my role and position. I mean, I might not be working for Frontex at some point, but it is important to have an internal mechanism. It helps. 1 minute. But we should consider yes, enhancing the role of the Fundamental Rights Agency and also establishing national monitoring mechanisms. What we miss right now is a complementary mechanism at the national level to do the work that we do at the EU and Frontex level. And the very last point is about Article 70 to 73. I mean, if I agree with you, that would mean less accountability for Frontex, and that would be so. Yes, member states they are right. Say, Frontex, okay, you're here just to coordinate stuff, and this is exactly the argument that some member states are using. That actually we don't need more Frontex because this might be also against the treaties. Okay, my personal opinion, but this is my very personal opinion, and in a way a political opinion, it's not so much a legal opinion, is that instead we need more Frontex. And why we need more Frontex? Because despite the discussion that we are having concerning accountability gap, I think that public scrutiny, especially coming from the European Parliament, for example, is something that we have not seen in the national. I don't know any law enforcement structure in any member states being scrutinized so much as Frontex. And this is my personal point of view, and it's not so much legal. Thank you, and sorry for your time. Sorry, Elspeth.
Thank you very much. I must say, listening to our stakeholder is a rather frightening activity because one has the sense of an incredibly chaotic scenario within Frontex and operations about terrible siloing of responsibilities and compartmentalization. I must say, I was quite astonished. And I was also a little bit astonished by the suggestion that non-state actors have no role in SARS events, whereas we know in almost all SARS events around the world, it's non-state actors in the form of the commercial shipping sector, which is responsible for notifying of potential SARS events. But I'm not supposed to be commenting on our stakeholder. I'm supposed to be commenting on our presenters. And I have one sort of additional question for each of our speakers before I hand back to you to respond, both to what one another have said, to what our stakeholder has said, and to my comments. And the first one is to Laura. When I was reading your paper, I was particularly interested in the Frontex director's response to the European Parliament about the question of who defines distress. And as distress is a concept inherent in SOLAS, I wondered whether there is whether you have any comments about what is is there a common standard of what distress is and what its content might be? Sissy, I just wanted to go back to the question of the operational plans. And I was very struck in your written paper about the way in which you said, well, an operational plan may foresee an unlawful event in the context of fundamental and human rights operations. And the participating member states may have expressed concern that they did not want to participate in such an operation, and yet were nonetheless part of such an operation to carry out those commands. And this led me back to the very, very long and rich jurisprudence from 1954 onwards about the duty never to comply with an unlawful order which will result in a human rights breach. And I wondered whether that line of argument is relevant here. And finally, I wanted to ask Meiretsu, you use the example of the hotspots in your paper, which I think is a particularly illuminating one in terms of the kind of chaotic scenarios that I think our stakeholder was talking about, where nobody seems to be responsible for anything. And the resulting chaotic situation for asylum seekers on the ground results in a lack of legality in the ways in which they are treated and their capacity to seek judicial review. And I wondered whether you wanted to develop on that in any extent. Can I ask you to respond? You can probably have about 10 minutes because we've got quite a lot of time left. And we'll go in the order of your original presentations, starting with Laura. And I imagine that our stakeholder will probably want to make a few comments at the end as well, but I will give the speakers the last word in any event.
Thank you, Professor, and thank you, Gregorios. I will comment only on the things that I do not agree with, leaving all the others for settled. I will start with Italy investigating the issue of Frontex. Italy is doing that because criminal proceedings have a mandatory nature in Italy for whatever happens in within the jurisdiction. But when I was living in Lampedusa, for example, I witnessed many instances in which something similar happened outside the jurisdiction, and the public opinion was not informed of that because of these, and there was no investigation whatsoever about it. And just one comment about Libya. I remember the hearing that you were referring to. The fact that there is a SAR zone does not allocate an exclusive responsibility to search and rescue. The pivotal aim is rescuing and preventing the loss of life. And then whoever can go and do that is not only very welcome to do so, but also is bound by international conventions to do so. And about sea border regulation, the fact that that indeed part of my presentation was that it should be amended, but the fact that the definition of participating unit does not include Frontex is indeed because it was enacted when Frontex was operating under the very first regulation as amended in 2007. And there is an explicit reference to that regulation in the sea border regulation, and then mutatis mutandis, the regulation, it should be directly applied to the new, because otherwise we can say that the whole sea border regulation does not apply. So it cannot apply to the European Border Coast Agency when it comes to the objective scope, and not apply to the very same agency when it comes to the subjective scope. So either the two of them are applied, either they're not. And since we know that it is in force because the coordination centers established under the sea border regulation are still running, so we know that that regulation is still considered as operative. then mutatis mutandis, it should refer to the agency as well, even with all the amendments that the agency received at legislative levels. Then replying to Professor Guild. So I'm not sure I'm the right person to answer to the question of the executive director anymore, because the executive director was answering to a question that Professor and the member Strick posed actually during that hearing, when you actually immediately after Putro asked him what is his definition of distress, and he said the worthiness of a vessel is not relevant. Otherwise, every unworthy vessel in the Mediterranean Sea would be as amounting, to triggering a distress situation. And he said, and I'm quoting, "I believe the threshold is higher than that." The point is that we have not only guidelines but rules. And so the seaboard regulation is a regulation, so it's binding in all its elements under 288 of the treaty, and it's also self-executive. So it applies to the agency as well, of course, also because it names the agency, and the objective scope, it's the operational activity of the agency. And therefore, the opinion of the executive director is really interesting, but legally speaking, I'm not sure it's so more relevant than the regulation that he should actually be complying with. And and the first question about the chain of command, and then I will pass the floor to all the others. Yes, I comment the chain of command in my paper, referring to the coordinating officer as the expression of this opaque way of the chain of command, which is something that I also commented in more than one occasion with Grigorios. It's an exemplification of how difficult it is to identify who took which decision, because the coordination officer is described as the representative of the agency on the ground, and it is identified as someone that offers views and not orders to the member states, but these views must be complied with by the member states to the extent possible. But if it's not possible, then the coordinating officer can be provided with the power by the executive director to overturn the decision. So there is this ambiguity underlying in the figure of the coordinating officer, which I believe is the expression of the agency that is described as offering mere support, and then all the decisions are taken by the member states. But when we see the coordinating officer as a figure, then at the end, it can decide what he or she feels is best for the operation unfolding in a very specific moment. And I hope I was clear and I answered to all questions, and I will pass the floor. Thank you.
Thank you. I will also try to respond to the comments and the questions. First of all, thank you very much for the comments and the questions, which very indeed very helpful, and I hope will help me clarify my arguments better. I think there was some, at least as I understood, some overlap regarding these questions. I mean, I understand at least that I must have given a wrong impression regarding the member states' responsibility, the participating member states' responsibility. So I think if I have understood correctly, that the participating member states' contribution to implement in my paper was perceived as something that would happen in the context of any relevant activities such as fingerprinting, etc. But I try to refer to point to is their involvement in the drafting of the operational plan, which at least given the fact that this process again is not transparent, I'm not sure exactly what's happening there, but in this context, supposedly they have they can they are consulted and they can express concerns, I guess, regarding the lawfulness of the operational plan. So if they do not do so, and if Frontex and the host state agree on an operational plan that is unlawful, then and these participating member states cannot avert this operational plan from being implemented in practice, I'm arguing that they can be held as having a responsibility share in this context, because either we can view them as acting in concert with Frontex and the host state for the purpose of fulfilling this wrongful conduct in practice. So for the purpose of implementing this unlawful operational plan, or we can at least see them as aiding or assisting the commission of the wrongful conduct in practice through I don't know, through perhaps the omission to stand on their role as being consulted in this context, and trying to bring the unlawful operational plan in line with relevant applicable law. Of course, in practice, if they don't stop from contributing the deployed staff, for example, they will be actually involved in the implementation of the unlawful operational plan. So they will be involved in practice in its implementation. So I think their responsibility share becomes kind of evident in the end. So at the end of the day. So yes, when it comes to other, for example, activities such as fingerprinting or other roles, of course, then in this at this stage, I do not see any responsibility share they may have. Although, of course, situations could also happen. These problematic situations could happen at this stage as well, because you mentioned human rights violations or other issues. But yes, not in the context of shared responsibility as. I analyzed it at least in my paper. And coming back to the issue of the transparency, which I remember we discussed also at the parliament, the previous meeting, it is indeed a very difficult goal to gain. I'm sure it is. I believe that member states participating in this situation will not indeed agree on this, but maybe if this finds its way into a revised version of the regulation, then more transparency would be.
Can I intervene just a second? Because there is an intervention from Marc Montagne, who is an activist at the Alliance with Refugees in Libya, and has a comment on Sisi's discussion with Grigorios, with reference to the misleading Frontex dilemma between calling the so-called Libyan Coast Guard and leaving them to drown at sea. Border forensic studies by Human Rights Watch and others have widely documented how actually in most situations when Frontex identifies a boat in distress, there are also commercial boats and NGO boats in the vicinity, but Frontex systematically chooses to call upon the Libyans rather than the other actors in the area. So that's maybe something to bear in mind when discussing these issues. Now we can pass the floor to Mirenchu.
I will try to give some answers, maybe not everything, but first of all, I really agree with Grigorios that the plan needs to be strengthened. In fact, there is a proposal also in my paper that I wasn't explaining, but the idea is giving a little bit more the strengthening of the plan, monitoring the situation, at least at the hotspots. We were discussing when we were in Brussels that hotspots were not ready to be regulated, but at least I think that they are ready to be monitorized by the plan, maybe. maybe. This not means that I said that the FRA has to substitute the other controls that it could be regarding human rights. I think that it's never enough to protect human rights. So we need all these different monitoring mechanisms. So also an independent monitoring systems, and also what's going on at Frontex is a good thing. And this is linked to the scrutiny idea. It's true that if there is Frontex, and we were arguing about that also in Brussels after the presentations, having that Frontex maybe could mean some guarantees. We can discuss about that, but more Frontex cannot be translated in impunity for states, or sublet for states to elude some responsibilities. So if we want more Frontex, we must redesign the system, because at least from my point of view, and this is my opinion. I think that there is a lot of things that are missed in the entire system. So. And this brings me to the hotspots and the comments of Professor Guild, and this idea of chaotic. When I started to check what's going on in the hotspots, really the decision was that it was a chaos. And the idea was, okay, I'm going to try to study how is it regulated, and then try to figure out what's going on there. And it was very, very complicated. The fragmentation is high, and it's really complicated to get information on how does it work. So, and the thing is that usually they are using some soft law instruments, which is very, very difficult to be controlled by the court. So this escapes sometimes, of course, it escapes the judicial review, and I will and my perception is that sometimes the idea that, okay, we must be in the hotspot. Okay, maybe nobody must be in the hotspot. My idea, for instance, when I was checking one report was published last year from Eurojust about how is used information which is picked from the briefings carried by Frontex at the hotspot. I realized that only 2 cases were brought in front of courts against smugglers. So they have thousands of debriefings, and they only at the end, this only translates to the prosecution of only 2 groups, criminal groups. So why do they have to stay there? I don't know. It's some reflection that I was, okay, is it needed that all this information? Okay, and this kind of information, this information is collected without informing the person who is being debriefed and how it will be used. So the idea is, are you doing this interrogation because he's a victim of trafficking, or because he's a perpetrator and is going to be, then there will be a judicial cause against him or her. And I think that this is directly affecting the defense, the right to defense of this person, because he's giving information that you don't know how it's going to use. And I am not sure that it is used for the fight against criminal smugglers, because then they don't prosecute the cases. So I don't know, something is missed here. And that's why I pick the chaotic hotspots for that. And also those exchanges of information are based on memorandum of understanding that said, okay, we're going to exchange information. I know that there are some checks for sure, but okay, you don't know how it's going to be used to your information, why is it being picked, and also what's going to happen with your information. So come on, I think that this should be at least solved. Sorry for my extension.
Thank you very much. Violetta, do we want to take questions from the floor at this point? I can't see the floor, so maybe you can ask for the mic to be passed around.
Yeah, we can do that. So there are some hands up. Unfortunately, you would need to come to the mic. Really sorry, but we don't have a route. Or if you formulate your question from there, I can then reformulate it so that then the people online can hear it.
Thank you very much, Salvo Nicolossi from Utrecht University. I have a question that can be articulated for the three excellent presentations that also actually put this shared project up to our expectations this final round. So I think that apart from the issue of responsibility, if I follow your presentations, there are some other problems that are linked, perhaps even to the problem of responsibility. Because if I listen to Laura's presentation, I think that a problem that can be linked to the allocation of responsibility is the fact that these agencies have been creating a super administration which might delay the stream of communication between the agency and the member states. So my question is, would perhaps a member state be more able to fulfill its own obligations for search and rescue, for instance, without the existence of an agency like Frontex? Moving to Sissi, another question that I have in mind. So we were talking about how to frame responsibility based on the operational plans. But I think that before addressing this question, we have to reflect also on the status of operational plans. Because from your presentation, I tend to assume that we may regard what people shared responsibility. So the assumption is that they can be regarded as international law documents, but are they what? International treaties, document which is binding between member states and international organizations. So I think this is crucial to move on the issue of responsibility. So what is your take on that? And to me, Renzo, yes, you mentioned a lot of issues related to the constitutionality of what these agencies do. You referred on the dogma of the case law, basically elaborated by the Court of Justice. So I wonder basically if this is in fact one of the most important benchmarks, because this case law is quite outdated. We can read actually these agencies in light of the theory of living treaties. So perhaps one of the benchmarks from the constitutional perspective that we can take into account is more rule of law and the protection of fundamental rights, as has been evolved very recently with the Charter and the most recent case with regard. So I don't know if the ESMA and of this kind of case where it's really to assess the agencies. Thank you very much.
There were two other hands I saw. Yeah. Do you mind coming to the microphone?
My name is Fanny Kuda. I'm from the European Data Protection Supervisor from the Supervision and Enforcement Unit, and I'm in charge of the supervision of the area of freedom, security, and justice. Frontex, Europol, UH. Now, I wanted to react to your presentation about the cooperation about Europol, Frontex, UAE in hotspots, because we actually did an on-site inspection in July in Netherlands, where we, from the point of view of data protection, our scope was the exchange of personal data and information between these agencies. So we interviewed the guest officer of the three agencies. And at least what we have been told, and we came back with the idea that each of these agencies provided support with their own tasks to member states, but are not exchanging information with them. That was made very clear to us. At least that's what we So I think that the cooperation happens at another level. If we are talking in the context of a joint operation, it's a sharing of debriefing report by Frontex with Europol. And I'm not aware about sharing with Eurojust, but it's from Europol to Eurojust afterwards. And there, I think there's, I think one of the key points you made was about what is how to define the different roles of these agencies and who should be doing what. And in that sense, I will pick up on one thing you say, because you say that you're not aware of any law enforcement agency being as scrutinized as Frontex. But my understanding that Frontex is not a law enforcement agency.
I said
According to the treaty, that's what my and yeah, and it's mainly thing of last week was Europol joint parametry scrutiny group, and the cooperation between Frontex and Europol in the field of migration was very high on the agenda. And Catherine Lebon said, yeah, we are law enforcement agency as an executive of Europol, and we have to cooperate. Frontex our ears and eyes at the border, but without really defining what should be the role of Frontex. I think that's a key issue. What is the role of Frontex as migration agency in supporting detection of cross-border crime? And so I just wanted to.
Yeah, there was another one, Julia.
Morning, good afternoon. My name is Julia Raimondo. I'm from the University of Luxembourg. I will pick up on the first question on Salvo Molosi on the role of Frontex and on whether, and this is a question for Frontex in general, whether we need more Frontex because apparently the eyes and the ears of Europe in the member states, and they help us also see what's happened on the ground, accountable, or whether we need less Frontex, because I was just reading now reports according to which there are serious incidents reports where it's clear that Frontex officers are denied to be in places where fundamental rights violations regularly occur in Greece, Bulgaria, and in other places. And also because, as Salvo was saying, maybe Frontex is per se a superstructure that is rendering the work of member states, of border authorities of member states, more difficult. When things like Putro or the shipwreck in Pylos happen, Frontex is not there because they don't have enough fuel to be there because of all these things. So, what is your take on this?
Elspeth, this is it for this round, I think, unless there are any.
I don't see any more questions online. Yes, I think we can go back. Shall we reverse the order and start with Mirekshu?
Sure.
Yeah, in fact, when I was checking, I was surprised because I started studying what's going on with Frontex. My expertise is Eurojust and Europol. And well, they are not sharing, but then Eurojust publishes this. I was also like amazed because it was like, okay, they are not sharing between agencies, but they said, okay, how many material from the debriefings of Frontex is being used to prosecute in which countries, and only Slovenia opened one case, and also I think that Italy opened another case. But the thing is that this means that in some way something is happening. I got my idea. Maybe what I tried to figure out what was happening. Maybe the states were like putting the information that was related in their states from the debriefings. For instance, Italy was adding in some database from Europe for Europol, and then they decide to open the handling code, and they were sharing it using Europol and also Europol and Eurojust, but it was based on memorandum of understandings between agencies. So it's been a little bit tricky using these memorandums, because if you check, really, they only have one disposition that says, okay, we're going to collaborate and we are going to share information. Of course, in the case of Europol, there is these handling codes that are protecting more or less information to be shared. But usually when the Europol officer at Europol basis asks to the state to use the information, they can change the handling code. So I don't know where does this exchange happen, but it happens, because then they write a report saying that they've been using the information. So how is it good? I have no explanation, and I was amazed about that. Yeah, and also who should do who should do things? Who should do the different things in the border? I don't know, and in fact when I started checking the legal basis in the treaties, Article 77, Article 73, and also Article 88 for Europol, for instance, I was realizing that, in fact, the treaties do not refer to Frontex. Frontex is a kind of measure that states are doing to make the border control work. And if you check the legal basis in the treaties, it's a little bit. It's fascinating that how can it be developed at the end. If you check the regulation, then it appears in Article 1 or 3. I think that it has the power or the competence to fight against also the crime. And it's like, okay, but I thought that this was the competence according to Article 88 of the treaties of Europol, recovering information for fighting organized crime. So I think that it's the reason of Europol, and now it's Frontex there, and Frontex is saying, okay, we're not working, we're not doing it well when we are trying to identify victims of THP, and not because it's impossible to identify them in the border because no exploitation has been done. So we can see if there are some potential victims, and then you say, okay, but your regulation says that you must fight against THP. I don't know how Frontex is fighting against THP in the border. From an effective point of view. So, these overlaps are for me are tricky. Sure. And that's why I say, okay, we must check all the regulations of the agencies and try to put some order here.
Thank you. So I will start by picking up on Salvo's comment on the nature of operational plans. And I have to admit that I, at some point, also had the same question: what should we perceive them as? How could they be classified among the sources, perhaps of international law? And I understand the struggle. Initially, I was thinking, well, if it walks like a duck and it walks like a duck, it's a duck. So maybe it's something like a treaty, but it's not. It doesn't exactly walk like that. But I guess it would just skip the issue of why they are binding and just keep the fact that states and Frontex perceive them as binding documents. Then we can just focus on the implementation and the fact that at the stage of the implementation, violations of other binding international law sources or international obligation sources arise, and perhaps we can just switch the point of attention to that part. And then Julian's question was very definitely thought-provoking as well. And yeah, I don't know. Of course, I myself don't know indeed if Frontex is helpful at the end of the day, or if it should have any Frontex at all. But I know for sure that we have to shed some light there and actually understand what's happening, so that those who can make a decision will make a decision at some point. Thank you.
Thank you, Salvo, for your question. It's something that I asked myself many times, especially when I was living in Lampedusa, no? If there should be more Frontex or less Frontex. We don't have Frontex or Frontex vessels in Italy after Sofia 2.0. When Federica Mogherini was in office, she once said that it was the first naval mission without even one vessel. So this is something that I asked myself, especially concerning Greece, and especially after the Olaf report was leaked by the Spiegel. I am in favor of a European answer to migration flows. And I am virtually in favor to a supranational agency that helps member states coordinate the answer to migration flows. And Frontex has human rights obligation. What I am against is an agency that escapes any kind of accountability, and whose agents, for some reasons, are fully immune before national jurisdiction, international jurisdiction, of course, because Azione Persona, those jurisdiction, well, lack, no? Those courts lack jurisdiction, and for some reason, the Court of Justice hasn't been able to offer an appropriate answer. Well, in my opinion, I am against this kind of agency, but the Frontex is extremely resourceful and has the highest budget. We could also use that to implement fundamental rights obligations and not only to violate them.
Can I suggest that we give our stakeholder an opportunity to respond? I think that quite a number of things were said to Mr. Tsioukas that he wants to reply to, but only 4 minutes.
Only 4 minutes.
1 second.
Well, I mean, this is very restrictive.
There was one question that Tineke Efrik wanted to ask to you before you reply. Just wait.
Thank you. Thank you very much. Yeah, thanks for giving me the opportunity, and thanks a lot for this wonderful panel. Sorry I came a bit late, but at least I also heard some provoking statements by Gregorius, which I would like to follow up on, because you said that actually you described the dilemma. Indeed, if we're not going to inform the Libyan Coast Guard, people might be drowned because of that. That also has to do, of course, with what Laura said. There are no vessels anymore to help. But I wonder, the FRO has also given an advice on Libya and said that the Libyan Coast Guard and the Libyan Tripoli is not a safe port. So I would wonder then, what is the implication of being no safe port? If you still think you can, cooperate in order to bring them people to that port. And on the other hand, if you, as you indeed said, that Hans Leijten had a very restricted definition of distress, while in the Sea Borders Regulation, a whole list of criteria are mentioned that are applicable. But if then only in a few cases distress is being defined. But on the other hand, so many assets or boats that are detected are being shared with the Libyan Coast Guard, then I don't understand exactly, what's the reasoning behind it. If that is not for distress or search and rescue purposes, why is it shared with Tripoli? Especially if the FRO also says that Tripoli is not a safe port. So, either it's distress and then you apply it broadly and you find a solution, or you say, if it's no distress, we are not going to share this information with Tripoli. So maybe you can. We still did not get the last opinion of the FRO on Libya, so it would be great to hear more.
And if I can add one more thing for your reply. Under the law of the sea, there is no reason at all why you shouldn't call on a Libyan vessel and then ask them to deliver people to a place of safety in Italy, right? So that's another twist on the twist of your dilemma.
So, still 4 minutes? Okay. So
You can have 5 now. Tineka's question was really good.
So you are so generous. Thank you. So, let me start with the very last point. Yes, I agree. You can have Libyans rescuing a vessel and then the disembarkation happening in Italy. So this could be a solution, right? This would require, of course, also the Italian authorities to agree to this disembarkation. So then, yes, we have said that it is not a safe port of disembarkation, and I think that also Hans Leitens has recognized this publicly, right? But still, the answer to the question why you are informing Libya, I mean Frontex, right, is because there is a possible, I mean, let me go to the question, okay, is it a distress or not a distress? The answer to this is that it is possibly a distress. And then coming back to the comment from Elspeth about Frontex not being a SAR actor, by that I mean that Frontex cannot declare a case as a SAR event. The only actor in the international area that can declare this as a SAR event is the Research Coordination Center. We have an obligation to report and to inform, right? But unless if you see people drowning or in a very imminent risk of life, can you start sending Mayday relays like that? I mean, that's a question as well, right? This has also to take into account that you have so many merchandise vessels in the Mediterranean Sea. And if you, I mean, there have been days where we have said 50 sightings. This would disrupt totally what is happening in the Mediterranean, and not only for 1 or 2 days, I mean the whole summer period, for example. It's not that easy. And then the last point on that, I mean, in our view, in my view, definitely Frontex should inform about these incidents, especially NGO vessels. I'm not referring now to merchandise vessels because there are difficulties there, practical difficulties, but NGOs vessels. So you ask me, there is a solution to this, disembarkation to member states and informing also NGO vessels, right? This could be a way to go. But still, I believe that, yes, Frontex is not an actor, I mean, cannot qualify an incident as a search and rescue incident. This will always stay under the current international legal framework, at least the responsibility of the national authorities. You might disagree, but I mean, I think that it's a matter of legal interpretation. Now,
you've had 4 of your 5 minutes.
Okay.
Do you want to just stop there?
I will stop here, just advocating for more EU answers, which means more Frontex. If it is a law enforcement agency or not, or a migration agency, this is an open discussion for the future. But I do trust more to have a European Union oversight in what is happening at the borders than to leave this only to the national authorities. That's the way I see it, and I think it is compatible with the primary law of the European Union. It's not unconstitutional to use this term.
Can I thank my panel enormously for a terrific presentation? And I've just gone and done what I promised I was not going to do and give our stakeholder the last word. Nonetheless, as the issues for the stakeholder were so overwhelming, and the questions of legality, fundamental rights, etc., I think that we've all benefited enormously from the whole of the discussion, and in particular also from the questions from the floor, absolutely excellent questions and so well documented. We see the fullness of the problem of the Mediterranean and why the Mediterranean, even in many UN instances, is being held out as the worst in the class on border violence. So I hope that the rest of the conference is going to be as interesting and successful as this panel. And I want to thank again the University of Barcelona and Violeta for putting this on. Violeta, I'll hand over to you to tell everybody where to go to get a cup of coffee at this point.
Thank you. Thank you very much, Elspeth. Thanks a lot. We are indeed going to Sala de Profesores, which is just across the hall, for coffee. We will be back at 5:30 for panel 2. And for those online, thank you for your patience. We'll be back in half an hour. Thank you.
Otherwise, I would have.
Yes.
Thank you, Laura. The floor
Perfect.
is yours.
Good evening and welcome to the second session of the SHARES Project Final Conference. I'd like to, first of all, thank the organizers for arranging such a stimulating event and also for the opportunity to share the session. We've already had a highly stimulating first session, and I'm sure that the second will continue on the same line, as the papers that I've had the chance to read are exceptional and very interesting. So the second panel is entitled New Technologies of Responsibility Diffusion, and will run from now 5:30 until 7 p.m. There will be 4 talks in this panel, and every speaker will have 12 minutes, I think, 10 minutes, because we're 4, 10 minutes for their presentation. And then this will be followed by some stakeholder comments. In this case, we count with the participation of Mrs. Fanny Coudert from the European Data Protection Supervisor. And after her comments, we'll also have some time for some questions and answers and a final debate. So for keeping the time, and since most of the speakers will be there in person, we have some on-site support to I think, show signs for 5 and 1 minute timings. And I think that the second presenter is meeting us online. So in that case, either Laura or myself can, on the group chat, let you know when there are 5 and 1 minute left. So without further delay, and in order to allow for sufficient time for everyone and for the questions after the presentations, I'd like to welcome the first speaker. She's Mrs. Mirna Nasrallah from Queen Mary University of London, and her presentation is entitled Orchestrated Omissions, Drones, the EU, and Frontex Cooperation with Libya in Sea Rescue, Interceptions, and Subsequent Violations of Fundamental Rights. So whenever you're ready.
So much. Thank you for the invitation to be here today to make this contribution. So I started by explaining or shedding the light that, driven by desperation, a lot of migrants and refugees set sail through earlier sea journeys in order to seek international protection. According to the IOM, since 2014, there is a staggering number of over 22,000 migrants and refugees that have been declared dead or missing in the Central Mediterranean route alone. And the number so far in 2023 stands for over 2,000, and including almost 300 children. The Central Mediterranean has been declared as one of the deadliest migration routes. And in response to the migration crisis, the European Union and member states did not remain idle. There has been some migration control responses to that. However, these responses were more focused on deterrence and containment rather than saving lives. Among these, just reflect on some, just to make it clear why our argument is more frustrated mission. So some of these responses include ignoring distress calls, negation of rescue, delay of rescue operations, reduction and then withdrawal of operational service assets, lack of coordination of rescue efforts, and they are often accompanied by like frequent disputes about the responsibility.
Sorry to interrupt. Can you also get closer to your mic because otherwise they cannot hear us online. Sorry.
This in addition to policies of closed ports and assigning of remote ports and criminalization of humanitarian rescue initiatives and the refusing of prompt disembarkation. Parallelly, the EU has been deliberately building its presence in the sky using Frontex and Frontex drones that are used to detect migrants' boats and relay the information and the coordinates of these boats to the Libyan Coast Guard, which I argue that facilitate the interceptions and return of these migrants to Libya, where they face human rights violations. So these migration control policies, along with Frontex practices, I argue that they contravene or they interfere with the human rights of migrants and refugees. And the question that I'm trying to tackle in this contribution is whether Frontex could be held responsible for omissions when it comes to search and rescue operations at sea, and whether Frontex could be responsible for complicity in intercepting in the interceptions conducted by Libyan Coast Guard. To start off, I'll first quickly examine the EU responsibility when it comes to search and rescue activities, followed by a reflection on the roles played by Frontex when it comes to the joint operations within the search and rescue regime. Then examining the responsibility of Frontex by drawing parallels with the RU articles, the articles on responsibility of international organizations. So first of all, according to Article 98 of the United Nations Convention on the Law of the Sea, there is a duty of every shipmasters to render assistance to every person in distress at sea. It imposes duties on both flag states and coastal states. As for the EU, it has ratified UNCLOS Convention, and accordingly, it's bound by the obligation under UNCLOS, which falls within the competence of the EU, pursuant to Article 77(2)(d) of the Treaty on the Functioning of the European Union, which provides for the EU's competence to adopt any measure necessary for the gradual establishment of an integrated management system at external borders. And in exercising this competence, the EU adopted several regulations as the Schengen Borders Code, the regulation establishing the rules for external border surveillance as regard to the operational cooperation coordinated by Frontex, which covers SAR activities that arise during Frontex operations, and also the European Border and Coast Guard regulation. So when Frontex coordinates border surveillance operations at sea, it is under the obligation to fulfill its task in full compliance with the relevant international law, that is including the Search and Rescue Convention and the Safety of Life at Sea Convention, and also in compliance with the Union law, including the Charter of Fundamental Rights. So while search and rescue is not governed by a common European framework, still the European Union is bound by these conventions, the SAR Convention and the SOLAS Convention, with respect in respecting these treaties as a matter of EU law when they are engaged in maritime joint operations. So Frontex responsibility within the context of search and rescue will only arise during the Frontex coordinated operations. So to examine the responsibility of Frontex, I would just shed quick light quickly on the role of Frontex regarding these operations. First, Frontex is entrusted to formulate the operation plan, ensure that it includes all the specific rules of engagement in accordance with the relevant international law, including that on the search and rescue, to ensure that the operational plan incorporates the specific modalities of disembarkation of persons intercepted or rescued. It collaborates with host member states and the other participating states. And this operational plan hold legal weight on all the participating units. Frontex also provides technical and operational assistance to member states to fulfill their obligations at the external borders, and it engages in intelligence, information gathering and exchange for its purpose, and may use on its own initiative the surveillance to collect information on the pre-frontier area. Thus, Frontex plays a vital role when it comes to the joint operations, and its mission of operational planning impacts the overall design of the EU border management. This is why reflecting or categorizing the role of Frontex as merely consultative or just like assisting member states in fulfilling their obligation would be an understatement. That said, the responsibility of or establishing responsibility of Frontex is challenging, and this is because of the lack of a specific mandate for Frontex when it comes to the search and rescue operation at sea, the interplay of executive powers, and ambiguity surrounding the chain of commands in Frontex operations. However, Frontex could be held responsible by the or by virtue of like the principle of shared responsibility that stipulates that one or more international actors could be held responsible jointly for the wrongful conduct. But the aspects of attribution is important, and during the operations of like Frontex, the wrongful conduct in question and the risk of violation is basically lying in the conduct of the European border management teams and the participating units, which are deployed alongside the technical equipment. And the issue is to determine which actor was considered acting when an agent of the teams fails to comply with the search and rescue operations, or when they facilitate the interceptions and pullbacks by the third countries like Libya. It's not as straightforward, again, because the Frontex operations operate on the premise that member states participating in the joint operations delegate human and technical resources to the host member states. Thus, the units are not organs of Frontex directly. That, however, doesn't mean that Frontex bear no responsibility regarding the SAR activities during the joint operations. Again, by virtue of Article 48 of the RU, there is the possibility of shared responsibility. But to hold Frontex responsible, the conduct in question must be attributed to Frontex and also must constitute breach of international obligations. When it comes to these obligations, like there are several norms at stake, including the duty to render assistance and the principle of non-refoulement. I'd like quickly to shed light on a particular incident on 30th July 2021, when the Libyan Coast Guard boat, Ras Jadir, intercepted a boat that was in distress from the Maltese SAR zone. Here, the failure of Malta to render rescue does not preclude the responsibility of Frontex in this regard, because Frontex not only failed to communicate with or like send Mayday alert to close by commercial vessels that were in vicinity with the distress situation, but it also could have like facilitated the interception of the Libyan Coast Guards if it has been proven, or it could be proven that on this particular incident, Frontex relayed the information and coordinates of that boat in distress to the Libyan Coast Guards, thus to facilitate the interception. There's a question mark on the use of drones in such incidents. For example, only 21 Mayday calls were issued by Frontex in the duration between January 2020 to April 2022. Although that is actually a fraction of like over 400 boats cited in 2021 alone by Frontex drones in the Central Mediterranean, and these were involving over 20,000 persons. Also, there is a question on the responsibility, shared responsibility of Frontex during the joint operations when it refuses to move out of like the geographical operational area to rescue a boat in distress that could be within close proximity to Frontex vessels. The argument that search and rescue obligations lies with member states only does not really suffice to just close the debate on Frontex responsibility when it comes to search and rescue at sea. On the other aspects of Frontex derivative responsibility, Frontex could be held responsible for facilitating the commission of wrongful conduct of member states and also of third states. This is contingent on fulfilling the requirements for that, including the provision of aid and assistance. And when it comes to member states Frontex does provide aid and assistance to member states. And as I mentioned before, like the particular aspects of during the joint operations, and it also facilitate the action by the participating units by deploying assets of member states and placing it at the disposal of the host member states and joint operation, including those on the SAR operations. It also facilitates the actions of the Libyan Coast Guard as it like facilitates the interceptions by relaying information and coordinates of boats to the Libyan Coast Guard, thus facilitating their interceptions and go back to Libya. As for the requirement on the knowledge, Frontex possesses the knowledge as it draws the operational plan of the joint operations, including rescue operations. It deploys assets and places them at the disposal of the host member states. And through International Coordination Center, it possesses the knowledge of incidents of non-rescue and interception. And since Frontex is under the obligation to ensure regular monitoring of all member state management of external borders and return through their officers, then it can be argued that it possesses the knowledge of these circumstances. Lastly, when it comes to aiding the Libyan Coast Guard, Frontex cannot argue that it was unaware of the circumstances of the wrongful conduct, as it's under an obligation to assess the situation of the said state before the intercepted or rescued persons are disembarked and forced to enter or handed over to the authorities of that state. And it also under obligation to ensure that disembarkation is not in violation of the non-lawful law. I think I'll stop here. Thank you so much.
Perfect. Thank you very much, Mrs. Nasrallah. The second speaker that we have is Dr. Niovi Vabuola, also from Queen Mary University, and she will also speaking on behalf of Dr. Teresa Quintal from Maastricht University. The paper is entitled Digitalization, Databases, Information Exchanges, and Joint Controllership Issues, and she's joining us online. So thank you for joining us this way too, and this is a hybrid session whenever you are ready.
Sure. Thank you very much for the kind introduction. And apologies I can't be there, and neither can Teresa, but both of us are online. It's just that Teresa's connection is a little bit less stable. I will just share my screen, which apparently is disabled. So is it at all possible to have screen sharing so I can share my slides, please? Thank you.
Yes, we are checking. Just one moment, please. So we stop the time for you.
Perfect. Excellent. Thank you very much. So now you should be able to see me struggling putting on my slides, but I promise these will not last long. All right. So starting, thank you very much. So as mentioned in the introduction, our paper is entitled Digitalization, Databases, Information Exchanges, and Joint Controllership Issues. And obviously, when we look into issues relating to the increased mandate of Frontex, we increasingly come across questions regarding the emergence of Frontex as a powerful information hub and its powers and tasks relating to the processing of personal data. And this presentation in our paper aims to address a key question which has to do with the attribution of roles in relation to the processing of personal data, in particular in cases of joint controllership, and how this impact on the right to personal data protection. In doing so, we focus on two strands in our research. One has to do with the Frontex regulation and the reference in Article 88 on the concept of joint controllership and the challenges regarding these concepts. And the second case study is with regard to databases and the delineation of roles of controller or processor in the operationalization of interoperable large-scale IT systems, the databases, for third-country nationals. So starting with a very few points on the emergence of Frontex as a powerful information Hub. As you will see also in our paper, we track the evolution of the rules in the different iterations of the Frontex rules, from limited provisions and information exchanges to the latest Frontex regulation, which contains a rather elaborate but also quite confusing mandate concerning the processing of personal data. There we see, and Myrna mentioned quite some stuff earlier in her presentation, how, for instance, the separate legal framework on Eurosur is being integrated into the Frontex architecture and the legal basis, but also we see Frontex increasingly having more and more data-related tasks through the deployment of operational staff and technical equipment to provide assistance in different aspects such as screening, debriefing, identification and fingerprinting of third-country nationals, but also the engagement of Frontex with exchanges with third countries in the context of joint operations and return operations. Obviously, the processing of personal data for risk analysis, including the cooperation with Europol in this context under the PEDRA program. But also Frontex is quite interested in developing and deploying new technologies, particularly on AI or on the future of biometrics or the future of travel surveillance. And this is a quite interesting thing because it doesn't happen only at EU level, but we see parallel developments also taking place at national level. And in that regard, it's quite interesting to refer to a very recent decision by the Belgian Data Protection Authority from the 14th of September, whereby which was asked to comment on a draft Belgian law regarding the tasks and powers of Frontex members with regard to the processing of personal data. And then we see that actually the Data Protection Authority criticized the draft law because actually Frontex members would have the same competences as Belgian police officers to carry out tasks relating to border control and return. And even in some cases, Frontex members would have even more rights than the Belgian police teams officers. So against this backdrop, we are shifting our attention now to the concept of joint controllership, as iterated, as mentioned in Article 88, which refers to the processing of personal data by Frontex in cases of joint operations, return interventions, pilot projects, rapid border interventions, or migration management supporting deployment. So it refers not to operational personal data, not in the context of Eurosur, but only in relation to this type of operations. And there, Article 88 states that actually Frontex and the host member state must determine in a transparent manner the responsibilities for compliance with data protection obligations, and when the purpose and the means of processing as jointly determined by the agency and the host member state, they shall be joint controllers by means of concluding an arrangement between them. As you've seen from the highlights in this article, there are a number of things that need to be considered whether they are indeed the case. Obviously, Article 88 denotes that there is a case-by-case understanding of the an attribution of roles, so it doesn't assign a fixed role to the agency. Actually, we need to look into the purpose and the means of processing. So this means that the processing would not be possible without both parties' participation, in the sense that the processing by each party is considered as inseparable or inextricably linked. And looking at that from the perspective of the Court of Justice case law, what this means in practice is that there needs to be, by both the agency and the host member state, a pursuance of purposes which are closely linked or complementary, meaning that there is, for instance, a mutual benefit arising from the same processing operation, provided that each of the parties, entities involved, participates in the determination of the purposes and means of the relevant processing operation. So the case law, the data protection case law, helps us understand a little bit what this concept of joint controllership means. However, there are a series of issues to look at. And the first one has to do with the fact that in general, Frontex and the member states as joint controllers must clearly assign the responsibilities between themselves, which is the requirement of transparency, because otherwise there will be diffusion of roles and would create a series of gaps in data protection of individuals affected from the perspective of exercise of individual rights, even liability for material or non-material damages. The fact that there is joint responsibility doesn't mean that it's necessarily equal responsibility. However, this means that there is some kind of responsibility attributed to both of them. And as mentioned, this is important both for the exercise of individual rights, but also for liability aspects. And from that, we can draw from a recent opinion by Advocate General Rantos in a case concerning Europol and the processing of personal data by Europol, whereby the Advocate General mentioned that non-contractual joint and several liability means that if the harmful act is attributable to several persons, they are jointly and severally liable to pay compensation. So it is quite important to have this very clear assignation of responsibilities. Is this happening in practice? I'm not entirely sure. We're not entirely sure, actually, because if we go and look into the Management Board decision of 2021 on the internal rules on processing of personal data, we see that in Article 10, it refers to the need for an operational plan, but only in relation to joint operations. So not all activities have to require this kind of an operational plan, for instance, in cases of returns. And in any case, as it has already been mentioned also by Cici earlier, the operational plans are... There is quite a lot of transparency to enable individuals to know to whom to refer. And overall, because of these challenges, there is to be really hands-on evaluation by the European Data Protection Supervisor and coordinated supervision, on which we understand that there is a limitation because Frontex is not part of coordinated supervision. Because of the increase of the task of Frontex in relation to data processing, there may be a role, a more increased role for the data protection officer, which of course goes hand in hand with an increase in the data protection culture of the agency, which in the past year seems to be a little bit problematic, as mentioned in several reports. So moving now to the second case study, which is the problems in the delineation of roles between Frontex and member states in the context of databases. And looking into, having an overview into the role of Frontex in the processing of data in large-scale IT systems, we see that whilst in the case of SIS and Eurodac, Frontex is listed as a data processor, so not a data controller, we see that in the context of ETIAS, the European Travel Information Authorization System, Frontex has been assigned the role of a data controller in relation to the processing of personal data in the ETIAS central system, because within Frontex, there will be a ETIAS central unit which will check whether any data that there are, whether hits against data in the databases are really hits before sending an ETIAS application to the responsible ETIAS national unit. But then we also see that in relation with the processing of personal data in the ETIAS central system by a member state, the ETIAS national unit is also to be considered a controller. Whether they are joint controllers, this is not mentioned in the legislation. If that's not complex enough, we also know from the legislation that in relation to information security management of the ETIAS central system, EU-LISA is to be considered a controller as well. So this creates some kind of confusion and diffusion of the different roles. Similarly, in the context of interoperability regulations, we see that in relation to the processing of personal data in one of the interoperability components, which is the multiple identity detector, Frontex shall be a data controller in relation to the processing of personal data by the ETIAS central unit. as with the previous example, the member state authorities which add or modify the data in the identity confirmation file, which is how the files stored in the MID are called, shall also be controllers and shall have responsibility for the processing of the personal data in the MID. So these examples aim to demonstrate the big challenge, which is how to separate between the processing by Frontex, the processing by national authorities, where the data flows become more and more interoperable and different entities may access and supplement the data set. So we have challenges regarding the separation of processing operations between national authorities and the central unit, between Frontex and EU-LISA, and challenges regarding what is the actual role of Frontex as data controller and the decision-making powers it may exercise in practice. These clarifications are very important because for the exercise of individual rights to abide with data protection principles and obligations and with supervision. And knowing that I'm already exceeding my time, finally, as this presentation has shown, there needs to be more transparency, clear attribution of roles and responsibilities, and we need more strength and supervision by following the data or following individuals instead of looking at the separate actors. Coordinated supervision in an interoperable framework should also be enhanced, also with regard to joint controllership agreements, determining the respective roles, not only on paper, but also in practice, and scrutinizing the processing operations within the interoperable system. I hope I'm only 1 minute above my time, and thank you very much for your attention. We look forward to any comments.
Thank you very much for the presentation. It wasn't even a minute, so it was actually very good. Don't worry about it, just a few seconds, not even a minute. So now I'll pass the floor to the third speaker. She's Mrs. Andreina De Leo, also from Maastricht University, and she's also speaking on behalf of Dr. Valentina Azarova. Their paper is entitled Sharing Responsibility for Financialized Migration Control. Whenever you're ready.
Okay. What's now? Hi, everyone. So my name is Andreina De Leo. As I said, I work for the University of Maastricht, and I'm presenting today also on behalf of Dr. Valentina Azarova from the Feminist Autonomous Center for Research and the Border Migration Justice Collective. Our work deals with the phenomenon that we call the financialization of EU migration control regime, which is the increasingly important role of European Union funds to strengthen border management capabilities of member states at EU external borders, such as Greece, and third countries at the EU externalized borders, and the absence of effective mechanisms to hold the European Union accountable for the fundamental rights violations resulting from this containment regime. More specifically, we examine the mechanisms leading to the system of irresponsabilization with regard to both the internal and the external dimension of financial governance, and by comparing the previous and the current financial framework, providing a concrete recommendation to operationalize a system of shared responsibilities where all actors involved cooperate to ensure the protection of fundamental rights in the implementation of EU-funded projects. And our work is based on the experience in challenging EU-funded border projects that entailed the refoulement and the violation of EU and international law by member states and third countries. With regard to third countries, we refer to a multi-year complaint process by the Border, the Italian Association for Juridical Studies, ASGI, and the Italian Association for Recreative and Cultural Studies, ARCI, before the Court of Auditors of the European Union and the Petty Committee of the European Parliament, and a complaint to the European Ombudsman in relation to Greece, filed by the Border and the Legal Center Lesbos, among other actors that contributed. So I'm now going over the 5 mechanisms that we analyze, and the first one applies to both the internal and the external dimension, while the remaining 4 only apply to the external dimension. So the first mechanisms, what we call the dilution and deflection of fundamental rights protection responsibilities, basically consist in the absence of an effective conditionality clause conditioning fundamental rights compliance with the allocation of EU funds. And in this regard, the reliance by the European Commission on member states and external actors such as third-party monitorings to ensure compliance. So for instance, with regard to Libya, the Commission has stated multiple times that it has this third-party monitoring that has the role of monitoring compliance with fundamental rights in Libya, but the identity of the functioning of this monitoring is so far not been revealed to the public. If I'm not mistaken, after a parliamentary question by the Greens, we are still awaiting a response by the European Commission on the identity of this monitoring. And while in the new multi-annual financial frameworks, both internally and externally, there are some improvement relating to clear provision, establishing conditionality between allocation of funding and compliance with fundamental rights. There are still unclarity regarding what actually the Commission is supposed to be doing when there are fundamental rights violations. So, for instance, with regard to Libya, to external funding, having Libya in mind as a case studies, the new regulation for external aid, the Neighborhood Development and International Cooperation Instruments, provides that actions resulting in the violation of fundamental rights in third countries cannot be financed. But as of today, no funding has been suspended. So it's unclear what they mean with evidence of violation or what violations they have in mind. And with regard to the internal dimension, there is this new horizontal enabling condition, which is a provision that requires member states to comply with the charter in the implementation of EU-funded projects. But for example, with regard to Greece, the Commission has found that this horizontal enabling condition was fulfilled despite evidence of widespread violation by border authorities in Greece. And the criteria that the Commission uses to determine whether these conditions are fulfilled or not are again not publicly available as of today. So in this respect, we recommend to put in place unclear and transparent mechanisms, which consist in both ex-ante, continuous and ex-post measures to effectively ensure compliance with fundamental rights during the implementation of EU-funded projects, relating to comprehensive and transparent impact assessment, the use of strict conditionality, the use of mitigating measures that are effective in the sense that now what has been used, for example, with regard to external fund is the training of the Libyan Coast Guard. And by doing human rights training, the Commission is saying that it exercises due diligence, but it's clear now throughout the years that this training have not led to a bettering of the condition in practice. So if you put mitigation measures, which are a good tool, then you also have to ensure that they actually have a concrete result. And with ex-post measures, we mean the suspension and recovering of funds when there is evidence of non-compliance. The second mechanism, so now from the second to the fifth, they only relate to the external financial government, is the use of emergency provisions to limit the involvement of the European Parliament and to evade standard procedure, for example, ordinary procurement and tenders, despite the fact that migration inflows do not fit the definition provided into financial regulation related to crisis, which refers to a situation of conflicts, natural disaster, or extreme poverty, requiring the immediate assistance on the part of the EU for the benefit of the third countries and not for the benefit of the EU limiting migration inflows. And while the new instruments for the external aid compared to the previous one betters the situation in the sense that it's not an emergency financial mechanism, which tools as an enhanced roles for the Parliament, there are nonetheless certain provisions called exceptional assistance measures that, if interpreted with the same idea of crisis, could again sideline European Parliament. And in this context, we propose to de-exceptionalize migration cooperation, ending this crisis governance. And we encourage European Parliament to fully scrutinize the implementation of the NDICI to ensure that emergency clauses are not abused. The third mechanism of irresponsabilization is what we call the Migration Development Security Nexus to conceal containment and militarization. And the idea is that there is an increasingly blurred line between development cooperation, which should have as its main objective poverty reduction, and migration management. And this departure was firstly used by the European Commission to use development aid to fund migration management projects in third countries, but it was also backed by the case law of the Court of Justice, which interprets development cooperation in such a broad way, basically saying that there is a relationship between development and migration, which could be true, but without demonstrating in the specific projects why, for example, the readmission of migrants or the financing of border management better the socioeconomic condition of the country in questions. And now with the new mechanism, the NDICI, this nexus has been formalized. Insofar as the instrument provides 10% of its funding to migration specifically. And these blurred lines was also encouraged by the Organization for Economic Cooperation and Development, the OECD, which is an intergovernmental organization which set the criteria to assess whether foreign aid can be considered development aid, basically categorizing what is official development assistance and what it is not. And it has contributed to the blurring of the lines, specifying that development also consists in the facilitation of orderly, safe, regular, and responsible migration, which then leads to consider border management as part of development. However, the OECD has recently specified that even if migration management is part of development, it can only be so when the project in question is able to demonstrate that migration management contributes to the benefit of the third countries, to specifying that activities who have their main objective, the containment of migration, for the benefits of the provider countries instead of the benefiting one, are excluded from official development assistance. But in this respect, the European Commission does not seem to do an assessment case by case in relation to the projects. So far, this specification has not yet been taken into account. And in this regard, we propose the European Commission to fully commit to the promotion of sustainable development using development aid for the long-term benefit of third countries instead of the European Union, stopping funding weak governance structure in third countries such as Libya, in which the recent UN fact-finding mission has found evidence that the authorities receiving funding from the European Union are colluded with smugglers and traffickers, and which are connected to the militia groups committing systemic abuses against migrants in the detention centers, specifying in this regard that they have substantial evidence proving that the European Union and its member states, directly or indirectly, provided the capabilities, mainly the vessels, that were used by these authorities that are colliding with traffickers and smugglers. In this respect, our recommendation is then also for the European Parliament to keep monitoring this conditioning of migration and development. The fourth mechanisms consist in the distancing of responsibility through an intergovernmental management of financial instruments. So the Trust Fund for Africa, these emergency financial instruments, was created outside the EU legal framework, which implies that the financial decisions are not attributable to the European Commission and the European Union then, therefore not reviewable by the Court of Justice of the European Union. This was remedied in the sense that the new NDICI provides that the European Commission is exclusive decision-making power, which makes the financing decision fully reviewable by the Court of Justice. But then, of course, due to the strict standing criteria of the case law of the court, only privileged applicants such as the Parliament could actually challenge financing decision, which means that they have to find political consensus to do so. So we encourage. Yes, majority. Political consensus, yes, no, I'm meaning consensus to then find majority voting. So yes, we encourage then, of course, to try to then find a majority to bring those cases. And the last mechanism is the informalization of the frameworks at the basis of the cooperation with those countries. So although the financing decisions are not binding EU law, still the projects are implemented on the basis usually of memorandum of understanding between either the EU of third countries, such as now Tunisia, previously Turkey, or at the national level through the Italy-Libyan Memorandum of Understanding. And of course, the lack of formal procedures following Article 2018 of the Treaty of the Function of the European Union makes it hard to understand how to find accountability. And in this respect, we on the one hand, recommend the European Commission to use binding instruments to structure the cooperation with their countries. And on the other hand, we recommend the European Parliament, again, to challenge in court these memorandum of understandings if it believes that in their content, they are similar to international agreements, and so they should have followed the procedure of Article 2018. And I will end with this. Thank you.
Thank you, Mrs. De Leo, for your presentation. We have a final speaker today, a final presentation. This will be given by Mrs. Alexandra Jolkina from the Free University of Amsterdam, and she will also be speaking on behalf of Dr. Saraganti and Professor Dimitri Kochenov. Their presentation is entitled Frontex Informalized Cooperations as an Example of EU Lawlessness Law, Delivering Rightlessness. Whenever you're ready.
I'm sorry for the delay. We had technical issues. So I'm speaking on behalf of Dr. Saraganti and Professor Dimitri Kochenov today, and we are going to talk about what is happening at the other side of the European external border, in particular not the Mediterranean, but the Belarus border, which has become another place where the EU law is violated and continues to be violated. So here you can see the wall, which was built in 2022 at the Polish border, which is a Great Polish Wall, built to deter migrants and refugees from reaching the European Union. I've been there, so this is my picture. This is how it looks like. So what we mean by lawlessness law, actually. So this is a term we have introduced to describe the EU deployed legal techniques. There's a wide array of legal techniques to deny non-citizens' rights that are never presented as a violation of law. And the EU-Belarus border crisis is an example of how the illegal and unlawful actions by the member states have been legitimized, not only at the domestic, but also on the European level. So basically, so there are different tools. So I have to start the word too. Durant, it's different. So starting from the EU agreements with third countries, where principal human rights implications fall outside the scope of EU law, like the EU-Turkish agreement. And also finishing with the recent events at the Belarus border, where the EU member states and also the EU-level actors use the securitization and instrumentalization of migration narratives to justify the very obvious violations of EU law, which represents, of course, a radical departure from the core EU values, in particular the rule of law. So, as you all have already seen in the media and in the political discourse, so what's happening at the border is Belarus is portrayed by the instrumentalization of migration, hybrid attack, weaponization of migration as a security issue. So why this crisis is special? This is the first time in the EU's history when several member states at once have adopted long-term, far-reaching and blanket legislative measures. So we are not talking about only practices of pushbacks anymore, but we are talking about the legislative measures, about the domestic law legalizing these practices. So what they did is that they, in their domestic regulations, have explicitly suspended the right to seek asylum and formalized pushbacks, which clearly violates the EU law, in particular the principle of non-refoulement. As a consequence, this has led to grave violations of human rights, which go far beyond simple denial of the right to seek asylum. And so the third country nationals who attempt to cross the border with Belarus have been subjected to various types of inhuman and degrading treatment, and which has, of course, resulted in deaths on the border. So here I'd like to illustrate it by showing you the Latvian example, which has been maybe not so much popularized in the mainstream media and not like the Polish or Lithuanian example. So what Latvia did in response to the growing number of third country nationals crossing the border in August 2021, it has introduced a state of emergency all along the country's border with Belarus, which is about 170 kilometers long. And it has introduced executive regulations, which is Cabinet of Ministers order, where it has prohibited the state authorities from accepting asylum claims all alongside the Belarus border, including the official border crossing points. So the Latvian legislation went further than the Lithuanian and Polish legislation because it was an absolute blanket prohibition to claim asylum, including at the official border crossing point. And the Latvian State Border Guards, National Armed Forces, and State Police were authorized to carry out pushbacks, actually, to immediately return persons who attempt to irregularly cross the border from Belarus without formal return procedures, and also use physical force and special means to ensure compliance. So by special means, they mean the use of electric shock devices, which have been used very frequently, irrespective of their wish to claim asylum. So here you can see a group of Yazidi, of people from Iraqi Kurdistan. So they have Iraqi passports, but they have Yazidi background. And Yazidi is an ethnic and national minority which has suffered a lot from the ISIS and who's been living in protracted displacement in the northern part of Iraq for around 10 years. So many of these people on the picture have been living in the IDP camps in Kurdistan. So for them, the Belarus route represents just the only way to get to Europe and escape from their very precarious situation when there's no escape. They can't return to the city they had once lived, Sinjar, because it's not safe. So here you can see they ended up stuck at the border. And what the Latvian authorities did is that they kept pushing back and forth a small group of people. So there were about 250 people during the winter 21-22 who were daily pushed back and forth by Latvian and Belarusian authorities, then gradually transferred to the closed center for detention of foreigners in the Latvian city of Daugavpils on so-called humanitarian grounds, were denied the right to seek asylum and forced to sign the voluntary return declarations and return back to Iraq by the IOM without having any opportunity to claim asylum. And after having spent several months in the forest, in the most extreme cases, 7 months in the forest. So here you can see, just to illustrate the picture, what's happening there. So here you can see in August 2021, there is a young man with a scarf around his face. So he is Yazidi. He's one of the group of Yazidi people stuck at the Latvian-Belarus border, like receiving food from the Latvian border guard. And on the right-hand side, you can see the picture It's March 2022. So 7 months later. And the man on the right-hand side, dressed in red, is the same man who were there in August 2021. It's the same border. So he is in a group of people who had spent 7 months on the border being pushed back and forth without any opportunity to go anywhere, either to Minsk or to the EU or claim asylum. So he is now back in Iraq. So what we would like to point out here, actually, I'd like to show what's happening in practice at a particular border in terms of what the European Commission was doing and what the Frontex was doing. So European Commission, we consider it the main actor of the EU lawlessness, the facilitator of the EU lawlessness at that particular border. So the Commission has been willing to sacrifice its role with the guardian of the treaties because there have been no infringement procedures or even explicit criticism of the member states involved. So despite the very obvious breaches of migrants' most fundamental rights. On the contrary, the European Commission has praised the member state authorities for protecting their external border, despite the very low numbers of people who actually tried to cross it. So there's been lack of investigation and embracing the instrumentalization narratives through a proposal to codify the concept into EU asylum law. With regard to Frontex, there are serious concerns that the Frontex officers have been involved in the human rights violations at that particular border. So in Lithuania, we have seen that the Frontex has sent European border guard teams to support border controls with Belarus, launched a rapid border intervention 2021 to assist with the growing migration pressure. So there were 100 officers, 30 patrol cars, 2 helicopters deployed. It has also sent specialized officers to conduct interviews with migrants to gather information on criminal networks involved. And at the very same time, in Lithuania, which is interesting, that the Frontex officers shared numerous internal serious incident reports documenting potential human rights violations. So that means that these officers were very well aware what's going on that particular border and were still there. So in Latvia, there were also officers deployed to patrol the border. There was a return counseling expert deployed, which raises serious concerns because, as I said already, during the winter 21-22, people were not allowed to claim asylum and pressured into signing voluntary return agreements. And yes, so there's an Amnesty International report on both Latvia and Lithuania where it is said that the human rights violations documented in that particular report appear to have taken place in areas where Frontex is operational, including at border locations where patrolling officers were deployed. So again, what we see is lack of transparency and accountability. For example, there is no information available on the Frontex roles and particular involvement in activities in Latvia and Lithuania. So in Poland, there's no Frontex. Polish authorities said that they don't need any Frontex there. So, and Frontex has been reluctant, unfortunately, to provide any detailed information about its role in collaboration with the national authorities, which raises particular concerns in light of the legislation enacted and in light of the very obvious human rights violations documented there. So, yes, multiplicity of factors is another factor which comes into account. So Frontex acting together with the national authorities or private actors, difficult to identify those accountable. So, for example, the return specialist deployed in Latvia was in principle an employee of the national authorities of the member state, which also raises concerns of the accountability. Yes, so our question is, in that particular situation, where the human rights violations at these particular borders were way too obvious and have been criticized by a wide array of international organizations, have been so widely documented. So why had the Frontex not suspended all operation activities in the member states involved? And the role of the Frontex officers who kept working in these member states and collaborating with the national authorities despite all that what is happening there. So thank you so much, and I very much look forward to your comments and questions.
Thank you very much for such an insightful presentation and for keeping the time so strictly. So we're under a minute, so that was perfect. I had some comments prepared, but I think that we don't have that much time for the questions and answers and the following debate. So I'll give them individually to the speakers so that we have more time for that debate. And before that, I'm going to open the floor to the stakeholder comments in which we can relate today. We have Mrs. Fanny Couder from the European Data Protection Supervisor, and we're looking forward to hearing you in relation to the presentations that we've just heard and the papers that we've seen. So whenever you're ready, maybe also maximum maybe 10 minutes, and then we'll see whether we can go back and forth, but trying to keep it strictly to the time. Thank you.
Thank you. I don't think it's working. Thank you very much. Thank you for the invitation to this very interesting conference, having so many interesting contributions. I will not be able to reply to each of your presentations, which deals with really different aspects of how to conceptualize actually shared responsibility in the different activity of Frontex, mainly because, I'm coming from the data protection angle. And so what I thought I could add to this conversation is maybe to share our experience as a supervisor of Frontex and the kind of difficulties we're facing because we have this concept of shared responsibility for the implementation of the European Integrated Border Management. It's clear that member states and Frontex should act in accordance with fundamental rights. But the question we are faced on a day-to-day basis is what it means in practice and how this can be articulated. So the European Data Protection Supervisor, we are an administrative authority. So we only look at the processing of personal data by Frontex, and we ensure we are tasked to monitor compliance with the applicable framework. But maybe what is different or interesting that we have corrective powers. So it can be fine, but most likely it will be, we can issue warnings, admonishments. We can also ban some processing activity, meaning or the erasure of data. So that's so we have to exercise that very carefully. As Frontex is starting to use more and more technologies, it's collecting more and more data, including personal data, and that's where our role starts. And that's also where our brain teaser starts, because then we have to assess to what extent Frontex should be held responsible for the way how they collect data, process data, and share this data, as we heard, for instance, with Europol or back to member states. As Niovi has explained, in the field of data protection, there could be different level of responsibility, from being considered as what's called a processor, meaning that it would be when Frontex would act on behalf of member states, a level of responsibility, as there's no decision-making powers. It's acting merely in quality of support. Then the responsibility, the main responsibility, will fall on the member state in that case, even if Frontex should act according to their legal framework in any case. And the other side of the spectrum would be Frontex being a controller, being fully responsible for the way how they collect and process personal data. And you have this possibility to have joint controllership in member state and Frontex acting together, as Niovi has explained. But this is actually a factual assessment. According to the case of the Court of Justice, this definition of responsibility is based on a factual assessment of each situation. So we are finding ourselves trying to disentangle this maze of multiplicity of actors that was mentioned, of different activities, and trying to get clarity on what is really happening mostly on the ground, what is the exact role of Frontex, what is the exact role of member state, and what is for which reason they are collecting and processing this data. We talk about business or public interest. Well, it's a purpose. Huh? So
it's all about for what is going, how Frontex will use or member state will use this information. I can give you the example of collection of personal information from debriefing interviews, because that's what we've been looking at in detail this year. And so Frontex is conducting the debriefing interviews for purposes of risk analysis, to produce risk analysis to understand the modus operandi on migration routes, etc. That's the main purpose. And then it's this report. It can collect as well, incidentally, information on law enforcement information. It's authorized. And then it's passed, this debriefing report is passed to national authorities who verify and check or at least do a validation check. And then it's shared with Frontex HQ and inserted in PEDRA, and then further shared with Europol. And so our work this year has been to understand. So we first did an audit in October in Frontex HQ to understand how this was being articulated. But still, we didn't have any kind of clarity on what was happening at member state, well, on national grounds. And that's where the difficulty starts, because, I mean, we are only competent to supervise what Frontex is doing, but there is also an important part of what the member state is doing. And that's why we organize as well this on-site check in Lesbos. And we went together to the Hellenic DPA, who is competent to supervise the national Greek authorities, so they could ask questions to the national authority, which were not entitled. But that's to illustrate a bit the kind of difficulty we're being faced, because we have to go together with the National Data Protection Authority to be able to have this full picture and to understand clearly what was the role of each of these actors. So it takes a lot of time, of resources, of effort as well. And I think all this effort is mainly due to two reasons. I think as we are moving from a purely national management of border to a more EU approach to border management, and we are still in between. We are not in a very clear politically and legally situation, as all the presentation illustrates. We have this inherent and built-in ambiguity actually in the definition of roles of the different actors. And Frontex role is growing. It's becoming more and more active. It went from very mere provider of support to have its own task for which it's responsible, and this will grow in the future, especially under the 2019 Frontex regulation. And this goes for returns. This can apply for joint operation, for what we call law enforcement collection of operational data. I prefer to call it like this. This has a lot of implication in terms of obligation. For instance, we're talking about debriefing interview. If we come to the conclusion that Frontex is collecting information for its own purposes, it means that when they collect information for the moment of collection, they are fully responsible for compliance. And not only with Frontex regulation, but as they're acting on the ground, national ground, also for additional national law that could apply to. So that's bringing an element of complexity. And that's what I want to say. The applicability of different legal framework, it could be different. So that's also another element to take into account. So I think talk about the opacity, and the last challenge is what I was saying. It's the joint supervision. So there is no structure, coordinated supervision for data protection authority at EU level. This could exist for Europol, for instance, which is much more structured under the European Data Protection Board, the EDPB. We have to rely on mutual assistance. So there is a ground, but we have to rely on mutual assistance, meaning that as EDPS, we have to go to the national authority and ask them to help us and assist us in the collection of evidence in the context of our investigation or on-site check. And
And that's one of the challenge because, as I say, if we don't have this coordination at pan-EU level, then we cannot fully enforce and have the full picture and have a clear understanding of the different roles. So that's one of the big challenge to organize this coordinated and joint supervision. And that's a difficulty as well because even at the EDPS, we have decided to create a specific sect. So we have a team of 7 people, which is not a lot, but it's already a start, which is dedicated to the supervision of the area of freedom, security, and justice. At national level, in most cases, there's not this kind of sectors, so, and they're also short of resources. So that's not necessarily a priority for them because of the amount of workload that they have. So that's what I wanted to share with you, the challenges we're facing in implementing actually and trying to define responsibility of Frontex and member states from the point of view of that approach.
Thank you very much, Mrs. Coderre. I think that in this panel, we've had a lot of discussion on the difficulties of attributing the responsibility to Frontex and other actors. And you were talking about this complexity of the legal framework in regards to data protection. When we're, the presentation given by Mrs. Nasrallah, she was also talking about, she offers a very rich and exhaustive work outlining both the EU's and Frontex obligations. And I think that in the panel that we had before, we actually had the opinion of Mr. Tsioukas, who was actually saying how there is no responsibility in search and rescue operations at sea. So actually, we could have here also an argument with him on debate with him on how this applies. So I think that I'm sure that there will be questions in these regards from the public. So Laura Salzano is helping us on site. So maybe since I cannot see the public, I don't know if there are many questions, but
yes, thank you, Laura. I will not be out. Is there anyone here? Yes, I see one hand. Please approach here to the microphone so that also those who are following us online. And then I have one myself. Please, go on.
Okay, my name is Anna Benbach. I work for advisory Parliament. Thank you a lot for these presentations. My question is, it's more maybe an addition, and I wish Mr. Tsioukas would be in this panel following Alexandra. Maybe you can come back on stage following Alexandra's intervention, because it's a bit, when she was talking, I was, but you're making this event very lively. And no, but it's, because of what you mentioned before, the example we have in Greece, where, you have on one side and the other side, and it's not the same operational area. But here, Alexandra mentioned, and that is something that struck me, having read also the serious incident reports from Lithuania and the different flow assessment. So here you had a close link, because the Frontex officers, and it's different from Greece. Frontex officers in Lithuania were handing in people to the Lithuanian border guards, who systematically, based on the law that is illegal in the case, was people were pushed back. So that's, here you have this link. And so that's why I would like to hear his reaction, because I think that's something that you didn't mention, the causal link, but that in this case, it's different from the Greece context. So which raises a lot of question about accountability and liability, and also the question of Article 46 as well. That's something that we could never understand, because indeed in Greece you have a practice, and in this case you have a law that was recognized as a violation, and then the ECJ case. So that's, and then even in this case, never it was said that when there was a redeployment in Lithuania, that it was because Article 46 was triggered. It was, we were told in the European Parliament that it was because there was assets were more needed in other places. That's what we were told. But maybe it wasn't true. We've been lied many times. So, so that's. But that's also one of the questions, why was never Article 46 mentioned? But maybe actually de facto it happened when the redeployment happened. But just it's a word that nobody wants to mention because it's taboo. But it raises, her presentation it's making the link between the two. And just to add one last thing, so it's more comments and more debates. One of the things that Alexandra, you mentioned as well, is this thing of the facilitator of I love it, the Commission being the key facilitator of EU lawlessness. I will use it from now on, instead of reminding them of guardian of the treaty, which is the last time I think they did something that we never had before. Last time when we had the exchange of views with the ministers from Latvia and Lithuania in the Libya Committee. Different MEPs, including Mrs. Strick and Claire Daly on our side, talked about, asked about, where is the assessment of the laws? And then Mrs. Pariat, who was there, answered, we have to see, before the Commission was saying, we need to have the laws adopted to react. And now they moved, she said, we need to see at how they will implement the law. And for me, that was a new thing, because before it was really, they wanted the law to be adopted, couldn't react. And then they are still studying the Polish legislation for ages. And they are not disclosing their analysis. But no, they didn't even say this. They just say we need to see how it's implemented. So that is, as legislator, on the other side, it's creating a lot of issues because we don't know what else. We don't have access to the analysis of the laws in any case. And now they say we need to get implementation. So as one of the institutions who has to scrutinize, it's making things more and more difficult every day. So just
Thank you so much. Are there any other questions? I don't see any from the Zoom room. So I will pose mine. So it's mostly to Andrea. I remember, I think Amandine does as well, when the NDC proposal was put forward in 2018, and this confusion between the development area and migration area, it was very well reflected in the legislative process, because it was a proposal from DEFCO, DG DEFCO, and we had the rapporteurship as the left in because yes. No, we worked together on that as rapporteurs, but it was just an opinion in Libe. It was Deve who had the report. So I'm just thinking out loud here. Could maybe trigger a challenge the legal basis help? So because the whole content, the migration-related content, we tried to put some safeguards here and there. Needless to say that we, in this direction, failed completely. We had no support from the whole chamber when it came the time. So maybe challenging the legal basis. And would you think that if the piece of legislation had put forward from DG Home instead, and have a very specific migration content, would these have had added some kind of, I don't know, guarantees that you very well presented you didn't find when working with this? No? I don't know. Thank you.
There aren't any other questions online, I think. So maybe you can all give an answer. Or whoever wants to, add a few comments, maybe 2-3 minutes per person, because we're running out of time. Thank you.
Thank you. Thank you, Amandine. I just completely agree with you. So unfortunately, the European Commission is not there as guardian of the treaties. So as I said, facilitating the lawlessness on the border. So and if member state adopts such a legislation, like it's completely abolishing the right to seek asylum, it's a basis for an infringement proceedings, right? So there's been no attempt ever to do anything about this, and even express any slightest criticism in that regard. And so it's not surprising at all that if we talk to the member state authorities, all the 3 member states involved, they see that they see the position of the Commission as support expressed to these member states, which what else we can do? So, well, my humble opinion is it's already too late. So they should have reacted at the very beginning. And if there is something, which I don't believe actually it will happen in the near future, but even if there is some criticism or any type of proceeding started. So it's already too late. So the member state authorities, they're so much used to this. And as we can see, they totally disregard the Court of Justice judgment against Lithuania, which was adopted in June 2022, so last year. So Lithuanian authorities, they do not care. Moreover, they have introduced the legislation, so in their national law, further formalizing their legal practices, pushbacks on the border, which was followed by Latvian authorities. So we can see that even the Court of Justice judgment is nothing to them. What can we talk about now? Just to put it very straight. Yeah.
Thanks, Laura, for your questions. So it's a bit complex. I do not think that it would be possible to challenge the legal basis of the whole regulation. I mean, regardless of the fact that now 2 months have expired, I think that the fact that they only say 10% and the reference to migration is very vague would not lead the Court of Justice to find that the whole regulation was adopted under the wrong legal basis if you use this test of ancillary versus main purpose. But what I think that it could be tried is to challenge each financing decision of the single projects. So showing that a single project has solely the purpose of enhancing border management, and it does not comply with the criteria that the court set in this Philippine case, where it found that you could use development to finance readmission, saying that the readmission content of the project was too vague. But if you actually prove that the whole project only is border management and that there is no link with development, there could be a way. But I think that given the recent case law of the court, they're not very inclined then on the merit to disrupt the whole system. And disrupting, giving funding to the Libyan Coast Guard or now the Tunisian Coast Guard or the Turkish Coast Guard, I think it would disrupt the whole scheme of containment, which is, since we cannot find agreement on the internal dimension, we completely externalize. So I do not think that the Court of Justice is willing to do that. So I'm a bit more inclined to think that on fundamental rights, that would be more chance. But even there, current, political situations seem to indicate that maybe the court is not willing to say much.
Not sure if anyone has a question or.
I don't know if there's any other comment in the room or if Dr. Vola would also like to say something on a final note.
What we could add is only our sympathy to the DPS for having to do the supervision of the agency under these circumstances. And we hope that our calls for including Frontex within coordinated supervision and putting, more basically coordination at EU level on this front can happen in the future. And that's all I'm going to say because it's quite getting late.
Thank you very much. Yes, we're running out of time. So thank you very much for your presentations. I would like to thank all of the speakers for them. And I know that we have had some technical difficulties, but these are some of the perks of the hybrid systems, even though there are many advantages to them too, which is to, unite all of these people together to participate in such a, thought-provoking panel. It has been very interesting for my part to read your papers, and I have some comments on them, but since we're running out of time, I'll send them to you individually. So send my impressions. And I think we've also been very lucky to have stakeholder comments or her visions, and, to be able to have such, an insightful and compelling panel. So also, thank you to the organizers of the shared conference for their very well thought and detailed organizations of the sessions. And I'm sorry that we're running, 4 minutes out of time. So also thank you for the opportunity of being the chair. And without further delay, I'll give the floor to, I think, one final.
Yes, I'm sorry, just to intervene. Maybe we could give the floor one moment to Mr. Tsioukas again, since he was called in different moments during this second panel. Just 2 minutes. Can you? 2 minutes? Yeah.
For me, it's no. Well, I had also questions, but I will not ask questions. So only about Lithuania and what we are facing. Yes, during the so about Lithuania, what happened was the following. So there was a long discussion because system reports kept coming for many months, right? From standing board officers who were really very, very puzzled. Okay, what is going on? You tell us that this is a fundamental rights violations, and we see Lithuanian officers that keep doing this, and somehow we are involved in this process. So be it indirect. So we are not doing the pushbacks ourselves. So what to do? So there was an ongoing discussion. From our office, there was a quite clear understanding that the should not be part of this. I don't know if they but the reaction internally was okay, but who is you to tell me? Okay, you advise me, but I don't have something concrete. You tell me that this is unlawful. Yes, you tell me that this is unlawful, but this is your opinion, right? But I need to have something more concrete. So what was the more concrete that came in June? The decision of the Court of Justice. So after that decision, it was not only my personal opinion that there we have an issue, a legal issue, but it is also the opinion of the Court of Justice. So at the moment that there was this discussion, okay, now maybe it's time that we take a decision, the Lithuanian government came, authorities, and they said, we don't need Frontex anymore because exactly we don't need Frontex anymore. So yes, we don't want you to be. I mean, thank you for your support so far, but no pressure. We don't feel any pressure anymore coming from Belarus. So maybe better that you remove your stuff and you use it in some other location where they would be more useful. So this is what happened. And as of then, Frontex is not around, at least not doing border surveillance activities. Okay, so factually. And then about the broader discussion, Finland is also has also adopted similar things. There is not only the Baltic countries. And this is obviously linked to the war situation that we are facing. And that explains, I think, also the European Commission's attitude to a large extent. And interestingly enough, and maybe Tineke, you could say a few things later about this proposal now for the migration crisis regulation, actually to legalize pushbacks at the EU level as well. So this will not stay with Lithuania, the Baltic countries, but if the Council adopts this, I think that they have adopted this position, what will be the impact? Right? So, okay. Thank you.
So, thank you. Yes, thank you. Yes, thank you so much. And sorry for interrupting everyone all the time. Laura? So we can now move on to the next stage. Thank you so much for sharing from there and for your interest. And again, to all the academics, I will now leave the floor to our keynote speaker,
Professor Tineke Strik, and also leave physically the podium. Okay, so we are reaching the end of day one, and we are honored and super pleased that Professor Tineke Strik could make it to be with us, to be the keynote speaker of today's session. I'm going to introduce her and then immediately give her the floor for her reflections on the topics of today, and particularly on shared responsibility, which is the center of our project. So Professor Tineke Strik is a member of the European Parliament for the Greens, as most of you already know. She has a long experience in national politics in the Netherlands and has also been an active member of the Parliamentary Assembly of the Council of Europe for several years before joining the European Parliament. She's also professor of citizenship and migration law at the law faculty of the Radboud University in the Netherlands and the CMR, so the Center for Migration Law over there. At the European Parliament, she is a member and coordinator for the Greens of the Committee on Civil Liberties, Justice and Home Affairs, so the LIBE Committee of the European Parliament, member also of the Committee on Foreign Affairs, AFET, and substitute member in the Subcommittee for Human Rights, DROIT. She is also a member of the delegation to the EU North Macedonia Joint Parliamentary Committee. I don't know if you remember all of these things, but and a substitute member of the EU Morocco, EU Tunisia, and EU Algeria Joint Parliamentary Committees, as well as a number of other memberships in other parliamentary committees and delegations at the European Parliament, which I'm not going to continue reading. But what is most interesting is that during her activities as part of the European Parliament, she has focused on migration and asylum, with a special interest in Frontex accountability, which is the matter of today's gathering, respect for rule of law and fundamental rights principles at the external borders of the European Union. She's been the rapporteur of the status agreement on Frontex with Mauritania, right? And additionally, she is among the most active members of the Frontex Scrutiny Working Group that did work actually on trying to hold Frontex accountable, politically speaking, and was the rapporteur of the report on the fact-finding investigation on the alleged fundamental rights violations that involved the agency. So we couldn't have a better speaker, I think, for the day and for the conference, and we are very pleased, Tineke, that you're here. The floor is yours.
Thank you very much. Is it on? Yeah. Thank you very much for this kind introduction. Maybe I can add one position that I had. I was 7th vice chair of the parliamentary delegation with the ACP countries. So it doesn't just to be complete. No, thanks a lot for this. And I'm also very honored to be here. And I really bear with you that you now also still have to listen to me before we can go and have dinner. So I will try to be not so long. But and of course, I looked at your marvelous guidelines. Of course, we already discussed the guidelines before when they were in a draft stage, and I think they are really excellent as they stand now. It really shows how many people from different angles and with different kind of knowledge have worked on it, because they're very accurate and also very comprehensive. And I would say we will have an evaluation by the Commission end of this year of how the 2019 regulation is implemented, how it works. And I would say this is a real gift for the Commission that I really hope that the Commission will not start to propose to reopen the regulation. I think it will only mean, worse guarantees, less guarantees than improvements. But it would be great if the Commission would start to draft guidelines, to make guidance for Frontex and also for the member states, if you think of shared responsibility and how the regulation should be interpreted. So you
the timing is really very good. And we will also definitely use it in the parliament. I'm sure Amandine will do as well, the left, and others as well. So I will indeed touch upon shared responsibility and some of your recommendations or guidelines also on democratic control. Because I think, because I work inside of the institution, it's really good, apart from all the experts on legal accountability, that I say a bit more on political accountability. So I would like to dive into a little bit, like, as it was already reiterated, that Frontex has grown very rapidly with its mandate, with its size, with its budget. And it's really good to see, does democratic control catch up with all this rapid growth. And also I want to touch upon a little bit like these hybrid elements that Frontex has, and especially this shared responsibility is really showing that it's on the one hand an EU agency, but on the other hand, it's so much intertwined with governmental elements, like the fact that people are deployed, that assets are given, that budget is being given by governments, that we have, of course, a position in the management board for governments. There are many different elements that are also more difficult for us also to exercise democratic control. So in the end, I will also say something about the relationship with national parliaments to make sure that this hybrid elements could also lead to kind of hybrid democratic control. But I think I will not mention all of them, but I think the current regulation has the most safeguards for democratic control than if you compare it to the previous regulations. It's with budgetary control, with a role in the appointment and the evaluation of the executive director, the information that we need to get, the fact that there is an expert or a representation of the parliament present with management board meetings. There are different safeguards that the parliament can use. And I must say that this democratic control and the use of these safeguards has only started to become alive with this revelation of the Balikat report. I think that's very clear. Before, Frontex was part of the Schengen Scrutiny Group, where we scrutinized also the member states, how they complied with the Schengen Border Code, and Frontex was a little part of that. That was actually it. And of course, the executive director sometimes came to the Libe committee for an exchange of views. But these revelations about the role of Frontex in pushbacks, was a kind of shockwave in the public debate, but also in the political debate. And that enabled us also to find a political agreement on how to step up this democratic control. So that led to the decision. It was in COVID time, so a lot of telephone calls in order to get an agreement that we should establish a dedicated Frontex scrutiny working group, that I would become the rapporteur and that EP would get the chairmanship of this. And that was a kind of the deal, so to say. And that the first 4 months would be dedicated to this fundamental rights impact or the assessment of how fundamental rights obligations are being complied with by Frontex. And I think before I go into our recommendations, that you can already say that it has led also to, it has sort of institutionalized better our scrutiny. Not only because of this working group that now exists, but also we get more on a regular basis documents. It's also better stored in the European Parliament itself. We have the workspace where you can find much better than before, all the documents shared. We have someone from the Libe Secretariat always there in the management board meeting, and we get some kind of summaries of it, and we get all the documents that the management board gets, and the minutes of the management board itself. No, not the minutes of the management board, but Okay, but then we only have, okay, yeah. Please, indeed add whenever or update when it's not anymore. But we get summaries from our own experts, right? So that's so things really have improved to a certain extent. But I think if it comes to information, we are not yet there. Also because a lot of documents are, perceived as being too confidential, too sensitive, even to share it with us, like operational plans, serious incident reports. So very essential documents that we would need to see in order to be able to fully scrutinize. And that's still. It was also the EU Ombudsman, by the way, who came to this decision last year, also saying that these kinds of documents should be open, at least to us, to exercise our scrutiny role. But I think now, after 2 years, we should really reflect on, are we still on that level of alertedness, or vigilance regarding Frontex scrutiny? And also, did our activities and recommendations lead to sufficient improvements of the agency? And has the attitude of the agency changed? Is there more openness, more willingness to involve the parliament? And have the main recommendations been implemented? About attitude, maybe I can use the Olaf report as a telling example. Because actually, when we were writing the report, we already we expected the Olaf report any minute. Well, it lasted still until February the year after, when the Olaf report came. There was a presentation by Olaf in the control committee, budgetary control committee, confidential, but we were not allowed to get the report. So there was only a kind of summary, a presentation, and that was it. And since then, we asked to get the report time after time. The Commission told us, no, the procedures are not yet finalized with the people of concern, so things still must have happened before. And that took until June, so it was really 4 or 5 months before we finally got access, and a lot of hearings, letters, exchange of views, because we really pushed for it, that we got access, but only the LIBE members and the COMP members could read in a secured way the report. So we didn't have paper documents, and we also still could not use it in Parliament. We could not use it in public debates or resolutions or letters, because, then you would reveal what would be in it. And also we could not convince other members of the Parliament who were not able to read the report. So it really did not, it did not help us in exercising our scrutiny role. So this is why I submitted an application for public access, because this is actually, many people think that members of Parliament have a more privileged role if it comes to documents. But actually, that's not so impressive, because, Olaf also, and everyone, reasons, if I give you access, it's public, because that's the way it goes, that then with giving someone access, including MEPs, it becomes publicly accessible. So there are no specific criteria for us. So I asked Frontex to get public access. I got a reply, a denial, saying there are no overriding public interest. I was not convincing in that there is an overriding public interest. So then I appealed again. I asked again, it was the same. And then I went to the EU Ombudsman to ask for recommendation. So then the EU Ombudsman held a hearing with the management board of Frontex. And in that hearing, you read that the management board wondered why I was in need of getting that document, because I had already read it. So in the first place. And then the other argument was, but she directed the application to the agency, but it's the management board. So that's something completely different. She should have directed the application somewhere else. And then the final argument was, but we don't have it anymore. So we we had to return the reports to Olaf, so she was at the wrong address. So and then the EU Ombudsman could only say, look, sorry, we are not convinced about this distinction between agency and management board, but we cannot do anything. You have to go to Olaf. And then I got it finally after a long time from Olaf, weeks after it was already leaked by this. So just to say that, you know, regarding openness, attitude, I did not immediately see a big improvement. And that was also the case with the appointment of the new executive director, because there the commission proposes 3 candidates. We have a hearing with all 3 of them, and then we come up with a recommendation. And the management board has to follow it or explain if they don't. So we have had a hearing, and then again, the Spiegel, after the hearing, leaked information that one of the candidates was a person of concern under another Olaf investigation. And that was about monetary administration and could be quite serious, but we didn't know. So we had hearings. We were not able to ask this candidate about, you know, this ongoing investigation and how that could relate to his or her eligibility for becoming an executive director. And so we asked the commission. We were all quite furious. So we had the hearings again. And the commission said, yeah, there were legal grounds for not sharing this with you. Until now, we did not get what the legal ground was. And also the management board, they had even held a separate meeting to discuss if they would have to share it with us or not before. And at that moment, of course, the expert of the parliament was excluded from the meeting. And they decided not to share it. So this is also quite telling, I would say, how serious they take our recommendation. Because we were not able to take all this important information into account. So in that sense, the reflex still seems to be there. So I think we still need to keep on showing them how important it is, also for the accountability of Frontex itself, to use us, to involve us in these important procedures. I must say the executive director is much more often attending meetings. He is also quite open in his answers, but promises to come back. So in that sense, it's really a different atmosphere and attitude. But as I said, this information is still too limited, the documents that we get. And I would also say that the European Parliament itself did not learn enough, because after this whole amount of attention, since then, we only had a few meetings of the Frontex Working Group, maybe 4, 5, not more, in 2 years' time. Where in the meantime, we had this Olaf report, we had a new executive director, we had more external cooperation, a lot that needs to be scrutinized. So this is really also concerning. Yeah, exactly. There was, and then what you noticed, because then it was a little bit like, why is that not happening? And there you see some political reluctance to do so. And this is why you see that we sometimes scaled up to the LIBE committee. So where we then could have hearings, exchanges of views. And maybe that's not bad, because then it's really in the open. So everyone is more able to follow it. But it says something that the scrutiny group we established for this purpose does not function well enough. And I would say maybe also that there's a kind of politicization of this democratic control. Because also in this Frontex scrutiny group, if experts are being invited, it's most of the time Frontex, the Commission, whereas we often also ask you to have independent experts, NGOs as well, and that isn't happening. So this is what I really find worrisome, because democratic control needs to be exercised by the parliament. You cannot outsource that to an independent one, because we are representing citizens. But fundamental rights, or democratic control is not left wing or right wing. It's part of our job. So this is what I really find concerning, and I think how can we avoid this politicization then about the recommendations, I will say something about Article 46, because I think that was the most important part of our recommendations. We said there should be a due diligence procedure, and you should start by applying it to Greece, because there was already so much out there. And we also said you should assess if you can stay in Lithuania, and you should stop returns in Hungary, because that was the only country, of course, for Article 46 was imposed but applied, but not for returns. Well, and regarding Greece, the FRO was, I find it interesting. The FRO was initially of the opinion you should always stay there. And even, the more violations, the better and more important it is to be there, so that you at least have ears and eyes. But I really see the FRO, has evaluated in that sense, specifically also towards Greece, because I really think that the FRO also became very disappointed in the lack of cooperation with the Greek authorities. There was already a year ago that FRO said we should apply Article 46 to Greece. But then there was the idea, okay, then let's try to do a kind of make an implementation plan, improve practices so that things become better. They didn't. And then I think it's what was not on purpose that after the pilot's shipwreck, it came again, like now it should really happen. And yeah, actually for me, this is now the moment of truth. Will the executive director take this so serious that it will have consequences? Or will it still say in the end, stick to the same automatic approach like what we have to stay there? Yeah, that this is, and time is running out because this recommendation is already before the summer. We should get clarity quite soon. On Lithuania, a lot has been said already. I also feel that because of this possible Article 46, that you then get that host member state say, no, we don't need you anymore. This is, of course, what's also happening in Greece. You're not there in the front line where the violations are happening. And yeah, then you can still question, is it legitimate for Frontex to stay there at the border crossing? I don't think so. If you read Article 46, that it's still also legitimizing or enabling these violations from ongoing. On Hungary, I don't need to say a lot on Hungary, but what you see is that also the FRO asked for mitigating measures, which I think have never been applied, like verifying if the right steps have been made, not assisting in returns of people who have applied or wish to apply for international protection. And now you see the other way around, because Frontex said to us, because we repeatedly asked stop these returns, that yes, but still, since we have suspended the operation on border management, we did not get more serious incident reports or complaints on returns. So we think it's not necessary to stop returns. And actually the other way around, it expanded the activities to the border between Serbia and Hungary, where we know that a lot of pushbacks are happening. FRO also responded to that and asked to come up with a set of safeguards, knowing that what is happening at this border. There's also kind of pilot project in fighting crime at this border. And yeah, it gives me the impression that Frontex is evading this Article 46. And in this way, with other titles or labels, still supporting Hungary at the borders. And this is what, of course, is worrying and not in line with what the European Parliament said. And another ground for Article 46 is also if the operational plan is not respected by the host state. Well, we know from FRO that with Greece and Hungary, there are many breaches of the operational plan, so that could also have consequences. Now on external cooperation, because I think this is really growing. We also, of course, have the Western Balkans for a longer period now, and these upgraded agreements enabling Frontex to also work at the common borders with non-EU countries, so not only with the border of the EU, and of course with the step now towards Mauritania and Senegal, going also to countries where there's even no European legal framework, so not the Council of Europe, like at least we have in the Western Balkan countries, or accession process where we have also additional safeguards. Regarding the Western Balkan countries, I would also say that the democratic control is very limited. We asked, and I think that's that's a minimum requirement, I would say. Also, if you look at the recital 88 of the regulation, that there needs to be an impact assessment, fundamental rights impact assessment. Actually, the way I read it is before the Commission goes to the Council to ask for a mandate. Well, what's happening with North Macedonia, and now it's happening exactly the same with Montenegro, is that it's already negotiated. It's coming to the Parliament. And then we ask, where's the fundamental rights impact assessment? And we're almost finished with the fundamental rights impact assessment. And then there you see the political pressure that some groups say, yeah, but we cannot hold this anymore. We need to go to the vote now, and it will be fine. So this is really, we have hardly any room for maneuver to really do a thorough, serious assessment. And then afterwards, when we saw the fundamental rights impact assessment of North Macedonia, it was actually more reason for concern because it was quite critical. The Commission was simply saying, look, there are many concerns, there are many pushbacks taking place, there's no asylum system, but we think the system is in place for having this status agreement. And it does not dismiss Frontex to do its own assessment before it can decide to apply, to start a joint operation with North Macedonia. So I really find it's completely dismissing its own responsibility and then leaving it to Frontex. And that also is preempting our role because, you know, if you start a joint operation, we have much of a more limited role because that's implementation already. Whereas with the status agreement, we're the co-legislator. So this is really disturbing. And these are all the things that we want to make sure that when Frontex goes to Africa, we have even better democratic control. And this is why, actually also together with the left, that we asked the LIBE coordinators to make an INI report. It's an own initiative report to be able to not to wait until, you know, the whole status agreement has been negotiated, but before also to be able to come up with recommendations towards Commission in its negotiation to take certain things into account. And this is possible also under Article 218 that the Parliament can also fulfill that. So we conducted working visits in February to Mauritania and Senegal, talked with a lot of organizations there to find out how the human rights situation is, and of course talk with the authorities, etc. And we are now almost finalizing the report, and we are very critical because the situation, I mean, this completely different legal framework, and the fact that Frontex is working under the command in this command structure with the Mauritanian border guard is asking for problems, I would say. And I also noticed that also Frontex itself is quite ambivalent and hesitant to step into such a situation. I can imagine. I really think we should also protect an agency like this in such a sensitive area, and not like, okay, we put Frontex there and then we can say that things are solved. So I don't know if it will happen, but we will come up with a lot of recommendations on also immunity and all the things that have been mentioned here as well. It doesn't preempt, of course, the consent procedure that will come later on. But at least, and I think that's the added value, it has brought the parliament in a much better information position. We really know now what's going on. And I really hope that also feeds into how are we going to deal with in the procedure, but also with monitoring afterwards what is happening with it. And now, yeah, something about what I was also, this is we also recommend that the Commission is conducting an ex-ante fundamental right impact assessment now as soon as possible. And also, if it would be implemented, that it would do an independent monitoring mission. Of course, we will have the FRO, but we think there should also be a kind of external monitoring, especially also because if you look at the limitations of FRA and the EU Ombudsman, FRA cannot, go and do its work there, what it can in the member states. And people cannot file a complaint with the EU Ombudsman if they are residing outside. It would really be necessary. And I think I don't have a lot of trust at the moment that the Commission is going to do so. So I really think that the Parliament should really also build a kind of network of NGOs and independent experts in those countries so that we are fed by ourselves and hopefully also share that with national parliaments as well. Then some things on this shared responsibility. What I find remarkable in the regulation is that in Article 7, there's a difference between border management, where it's really clearly stated that there is this shared responsibility. Whereas in Article 7, paragraph 2, you see on return a bit more hesitance. There you see that again reiterated the member states are solely responsible if it comes to return decisions, detention measures. So the regulation makes a distinction between the two. And that can leave for me many questions because on the one hand, also in returns, in border management, there can also be return decisions being made. So what regime does it then apply? And also during return decisions and procedures where Frontex has more and more role, there's a lot of collaboration also. It's in this whole process, there are many decisions, stages, etc., where the state and Frontex their activities are intertwined. So that makes it really difficult to decide who is when accountable, and also, of course, for the Parliament, what part can we actually democratically control, or when is it the national parliament? And I think until now, the national parliament is very much, outside of the spotlight. And I really think we should change that. Because if you think of how could the national parliament be in a position to control what Frontex is doing in return practices if it's, for instance, enforced return monitoring, which is actually an obligation of the member states under the return directive. But Frontex has the information, to what extent are national parliaments enabled to get that information? We get it, but it's the national parliaments that have to do it. So many of these types of questions, I think, are still open and need to be further elaborated. And the fact that it's so much subject to secrecy makes it very, very difficult. Not only Frontex documents, but also if you think of the Schengen evaluation and monitoring. You can't get access to that. And national parliaments should be able to see what's there, what their member states is accused of, how Frontex is related to that, etc., etc. So this is what I mean with this hybrid system. I think especially return, you see that very clearly. I think there's a lot that we still have to develop. And then maybe some final words. if everything is under control now, I think that I really don't think we need to reopen a regulation. Really, I think we have a lot in the regulation. We know a lot more where are the weak points, how could we improve them, and the question is, how are we going to remedy these weak spots? And that concerns, I think, the transparency, how to make sure that's in line with the case law of the Court of Justice, because the Court of Justice has also always made clear that transparency is necessary in order for citizens to be involved and to trust in the EU. It's necessary for representative democracies. So it's very much linked also to the role that we can play. In the end, I would also say, as I also said before, it's also a matter of political willingness to actually fulfill our duty to democratically control on our own as a European Parliament and together with national parliaments. And sometimes, this is my last remark, you also have this discussion with the European Commission. We just had it about enforcement, like not enforcing compliance, even if it's in the law these days. And then sometimes we have these discussions that the dual role of the Commission is making it impossible, and if you should make it independent, the decision making on infringement. But for the European Parliament, I don't see a solution for that. And this is, if I think of the next term, the rise of more extreme right, I'm not sure if in the next term there's more willingness to scrutinize agencies like Frontex. And I don't have a solution for that, but it's good that we are aware of things and that we are in time with finding solutions. I think until now, it goes pretty well. We will also have a new Frontex resolution to be adopted very soon. I think it has the main elements there, but I'm a bit afraid, and I think we will keep on needing civil society scholars for revelations, for guidelines, for all the things that you are doing to keep us also alert, vigilant, and aware of the responsibility and duty that we have as representatives of you. Thank you.
So since we're already beyond time, a little bit, I think we can take maximum 3 questions. If anyone has any, I do. Okay, Salvo. All right, Fanny. And Judy, yeah, all right. So that's a question. Right, all right, good. So please approach to the microphone and be as brief as you possibly can. Thank you.
Thank you very much again for this very insightful presentation on different things going on. I have a short question. In fact, on the last point, one of the last points you mentioned about the role of national parliaments, because I also believe that this is a strong point in terms of democratic oversight. I was just wondering what kind of initiatives in the framework of interparliamentary dialogue and cooperation between the European Parliament and national parliaments are in place to go to that direction, if any. So to learn a little bit more about that. So that's my question. Thanks.
One by one?
Yeah. Okay.
Actually, mine is really related to your comment because last week at the Europol Joint Parliamentary Scrutiny Group, someone suggested why not having a Frontex Joint Parliamentary Scrutiny Group, and then I wanted to know whether this could be the solution in your view. Yeah, that's yeah.
We also have a short question regarding Frontex fundamental rights assessment. when you were talking about cooperation with third countries. Actually, I'm only aware of Frontex own fundamental rights assessments regarding working arrangements, where Frontex directly negotiates those instruments. I actually requested access to those documents. I'm still waiting for them. So if anyone has some more information, and I was wondering whether there are fundamental rights assessments made by Frontex on status applicants. Okay, and before I give you back the floor, I will consider whether you could say something on the situations in which Frontex cooperates with CSDP missions, like in Niger. I don't know what the situation is now after the coup d'etat, but that's quite outstanding. And then the situation in Tunisia that you're well aware of. What kind of safeguards you think you would like to see in place for shared responsibility if actually we see EU cooperation going in a direction that it is going with Tunisia? Without Frontex. Or
Yeah. Yeah, that's true. Yeah, thanks a lot for these challenging questions. This first two on national parliaments, not much has been done so far. I know in the Netherlands there has been a hearing at a certain moment and with questions in Belgium and France, I believe as well. I have been several times in contact also with people from the German Bundestag to see what they could do. So everyone is a bit, or not everyone, but within these parliaments, they are also looking for ways to get more grip on it. And this is actually the state of play. I mean, that I know. Maybe Amadine or Ruben know. Ruben is my assistant, actually, by the way. Ruben. He's very valuable to me. But not so much has been done. So actually, it's also my own intention that if I have the chance to have another term, to really also go to work in that direction. And then is indeed, would the direction be the Europol example? I'm not in this joint parliamentary scrutiny group, but what I hear is not a lot of satisfactory comments, and because it leads to very big plenary meetings where everyone can say something. It's not real cooperation, I would say. And so I think if we would still then now develop something new, we'd better do something maybe less formalized, but more, for instance, sharing information. That could already be so important. And see what they can do, what we can do, some common action perhaps with hearings or letters or whatever. And Frontex, the executive director, is obliged to answer questions from national parliaments. So there is something in the regulation. But I think to learn from the joint parliamentary scrutiny group and do something more effective. Then the question. Sorry, what's the next question? Oh, yeah. Sorry, this is the fundamental rights impact assessment by Frontex. Yes, that's a very good question because I talked about fundamental rights impact assessment by the Commission. And from what I know, only that the FRO only needs to make an opinion if there is a joint operational plan already, but not prior to that. If you read the regulation. But so I'm not sure if Frontex is already thinking of making a fundamental right impact assessment prior to a joint operational plan. I'm not sure. I look at Ruben. Yeah, you should know. But But what was interesting when we had this exchange of views this week about Montenegro, and I asked Frontex on fundamental impact assessment, and they said FRO is making an opinion, and that's only the states of the status agreement. But with Montenegro, Yeah, I thought that he meant with the status agreement because there's not yet an operational plan. Yeah, exactly. Goes very quick now. Yeah. Yeah, but that's the problem. I will do it for the people online. The FRO representative says that what's the use in making a fundamental right impact assessment if there's already an impact assessment of the Commission. But that makes the content of this fundamental right impact assessment of the Commission so problematic. Because now by referring to each other, there is a whole gap. No one wants to take the responsibility by concluding, is it safe or not? So that's really a gap that needs to be resolved. Then I think your question, Anthony. Oh yeah, nee, that was the national parliament, right? Yeah. Then on to Niger. Niger is also, yeah, it's very opaque, very obscure. I don't know if they have suspended their information sharing or whatever. I'm also looking at it. Yeah. Yeah. Okay. Yeah. Yeah. Wow. Yeah. Yeah. Okay. See how much we need State Watch, NGOs, and scholars to be informed about what's happening. No, and this is really problematic. This is actually something that we should definitely have. This exchange of views. Why and how can you do that in a responsible way? And I also feel that there are a lot of risks with these risk analysis cells, this cooperation in the Sahel zone. I mean, because more and more, indeed, the fundamental rights are very much under attack. They were already, but now with this war situation, it becomes only worse. And then with Tunisia, I indeed, I foresee Libya-like situations. Because then, if we are going to pay the Tunisian Coast Guard, and Frontex will fly over this in this aerial space, they will do the same. They will share information with the Tunisian Coast Guard, and I think many have already said. I think also UNHCR that Tunisia is also not a safe port. So we have exactly the same, actually. And I also remember, because I asked also Frontex, what is actually the legal basis of flying in that aerial space of Libya? Is that on the basis of the joint operation with Italy? He said, no, this is our own self-standing ground of multi-purpose preventing entry activities, aerial surveillance. And I find that I find that also a kind of in-between thing, because, we cannot have such an agreement or arrangement with Libya because of fundamental rights. We cannot do that from Italy because that would also, lead to certain responsibility also for Italy. But then you do something like this, and especially if it leads to sharing information, leave aside this whole search and rescue issue. Then you are cooperating with a regime that is very much in breach of the basic fundamental rights. So yeah, this is also something we need to be very, very careful. My pleasure. Yeah, and now dinner. Sorry.
Thank you. So please don't go away. We will go directly to the restaurant. For our colleagues online, for those that remain, thank you for remaining up until the end. We will resume tomorrow at 9. And thank you very much for being with us online. For those in person, we'll gather right outside here and walk together to the restaurant. For the speakers only, I'm sorry. For the attendees, thank you very much for your presence today, and we will meet you again tomorrow morning. Thank you.
Good morning. Sorry, I'm slightly late. So I'm Steve Pears from Royal Holloway, University of London. I'm happy to chair this session. Thank you for inviting me. Very sorry to miss you yesterday, thanks to a toxic combination of unions, management, airlines, and border guards. But I'm glad to be here today. So I want to hand over the floor to, first of all, Maria Jose Barajas de la Vega to talk to us about one aspect, among others, of the issues of Frontex liability.
Thank you so much, Professor Pears. So my presentation explores the potential responsibility for damages committed in the framework of operational cooperation between common security and defense policy missions and Frontex. So Frontex current regulation allows the adoption of working arrangements with common security and defense policy missions on operational purposes. And thus there are currently 2 such arrangements in force. One with UNATFOR Med Operation Irini in the Mediterranean, signed in 2021, and another with UCAP Sahel Niger, signed a year later. There is a concern in this regard that the interaction between Frontex and these CSDP missions will lead to breaches of their human rights obligations. So it is necessary to explore appropriate EU law mechanisms to make Frontex and these CSDP missions co-responsible for their eventual unlawful acts. One of these is the filing of an action for damages before the Court of Justice of the European Union. But to be successful, the unlawful conduct causing the damage claim must have been committed by an EU body or institution carrying out actions within its competences, not within those of the member states. So as we've seen recently, a responsibility arising from conduct in the context of return decisions, according to case law in WS versus Frontex, is inadmissible in the eyes of the court. This is the answer, leaving aside criticisms we should do in this respect. However, this case law would not affect these scenarios I will now refer to. So think as the first scenario, the location of a vessel in distress by Frontex and a CSDP missions officers. This results in a third country's authorities with which the EU cooperates in border management, Libya, for instance, being informed by them, so the third country's coast guards head for the vessel and take the migrants and refugees to its territory, where their human rights are subsequently violated. So firstly, regarding attribution of conduct, we could argue that Frontex officers have been acting as a contact point, for the exchange of information with third countries in the framework of Eurosur, or that they had been tracking vessels suspected of being used for illegal immigration, including in the case of persons in distress at sea, with a view to transmitting that information to the relevant authorities that are competent for certain rescue operations. All of this as part of Frontex's own tasks, according to its regulation. As for the CSDP mission, we could claim that the Council decision which established it supports the exchange of information on the detection and monitoring of smuggling and trafficking networks, and that while the mission staff is doing so, it is acting following the instructions, that is the effective control of the head of mission of the EU Civilian Operations Command. Secondly, the conducts that I've mentioned must have given rise to a sufficiently serious breach of an EU rule intended to confer rights to individuals. In this sense, we could claim that both Frontex and the CSDP missions violated the principle of non-refoulement contained in Article 19 of the EU Charter of Fundamental Rights, especially since it was foreseeable that by alerting the third country, human rights violations would be committed against people on the vessel in view of the third country's status as an unsafe country. Thirdly, it must be proven that this unlawful conduct caused a damage to the applicant. In this case, the damage that could be alleged could be the one that caused the shock arising from the fear that if they were not rescued, the vessel might have sunk, as well as the anguish and suffering caused by the probably unhealthy conditions they had to live under in the third country to which they were transferred. Also, material damages such as the need for food or shelter in that country could be sought because of having been living in such poor conditions. Lastly, there must be a direct causal link between the alleged conduct and the damages pleaded. So in order to prove legal causation here, we could use the foreseeability criterion or the theory of adequate causation, since being foreseeable that the third country would violate the human rights of the applicants, informing them about the situation of the vessel they were on is an objectively adequate or suitable action for the alleged damage to occur. It would also be interesting to use here the so-called criterion of the protective purpose of the rule that has been violated, as it could be argued that with the conduct of Frontex and the CSDP mission concerned, the damage sustained is precisely the one that the principle of non-refoulement is intended to prevent. Another scenario that we could think about concerns human rights violations of the applicants committed by agents of a third country that have been trained by Frontex and the CSDP missions on European integrated border management. Here it could have to be proven again that their respective staff acted in concert in carrying out capacity building tasks that fall within their respective competences. In the case of Frontex, providing technical and operational assistance to third countries in border management, as indicated in the agency regulation, and in the case of the CSDP mission concerned, providing this same training, acting under the effective control of the EU, as I said earlier. Having established this, it would have to be proven that the human rights violations committed by agents trained by Frontex and the CSDP mission are directly attributable to the conduct of the latter. That is, to the very act of training. Only then we could understand that they have also violated principles such as human dignity, non-discrimination, the right from an eventual ill treatment that the applicants may have received from the third country agents. About the damages caused, the same harms as I mentioned in the first scenario could be claimed. The most challenging issue here is to prove the existence of the causal link between the conduct of Frontex and the CSDP mission, and the CSDP mission and the damages. The criterion of decisive influence would seem to be the most appropriate here, and it could be argued that the manner in which these EU bodies conducted the training of the third country agents had a crucial impact on the unlawful behavior of the agents trained. After all, the training bodies define the conditions under which the third country agents should carry out their border management activities, thus leading the latter to behave in a certain way. Given these two scenarios, if the Court of Justice were to determine that the cumulative elements of action for damages are met, it could then attribute responsibility both to Frontex and the CSDP mission jointly and severally. In the first scenario, in application of the principle of alternative causation, as it cannot be certain which of them would have informed the authorities of the third state about the location of the vessel. And in the second scenario, it would be as co-perpetrators of the wrongful acts committed. There is, however, an important point to note in bringing this action for damages. That is that in principle, the CJEU has no jurisdiction to decide upon matters concerning the common foreign security policy. But the lack of jurisdiction does not mean that this matter is completely exempted from the rule of general jurisdiction of Article 19 of the Treaty of the European Union. In fact, through the judgment in the case of Bank Refactor Garam versus Council, the court has ensured legal review for matters related to common foreign security policy by admitting its competence to rule on damages suffered as a consequence of restrictive measures. For this reason, it is possible to deduce that the principle of effective judicial protection will allow the CJEU once again to argue in the pending joint cases KS and KD versus Council and others, and Commission versus KS and others, that it has jurisdiction to hear an action for damages against CSDP missions as well. In conclusion, it is clear that we are dealing with potential scenarios where violations of human rights are being committed by multiple actors whose tasks are not yet clearly defined, as we have been discussing since the beginning of this Congress. This makes it difficult to argue that a particular action was effectively carried out under the effective influence of Frontex and/or under the operational control and command of the EU in the case of the CSDP missions. To tackle this risk, we made conceive relying on sufficiently specific, precise, and consistent indicia, drawing some inspiration from the case law on restrictive measures. In any case, the CJEU may adjust its case law as regards the strict conditions that action for damages must comply with and the consequent strict position on responsibility it has. A tailor-made approach by the court is then needed, taking into account the special features of human rights violations we are discussing. Thank you so much for your attention.
Thank you so much. There's so much interesting law questions rising there. So I'll turn to Elmin Amicevic and Salvo Nicolosi, who are going to talk to us about national processes of potentially holding border guards accountable.
Thank you very much, Professor Pierce. On behalf also of my colleague Elmin Amicevic, with whom I'm gonna share the responsibility of this presentation today, I would like to express our gratitude to the organizers of the shared project for all the commitment in all different phases, and to the Universidad de Barcelona for hosting this final conference, to which we are going to contribute with a presentation focusing on the potential of domestic judicial remedies in determining and allocating responsibility for fundamental rights violations occurring in the context of joint operations coordinated by Frontex. Our goal is not to claim that cases against Frontex and its staff have to be lodged within domestic courts. On the contrary, we would like to explore the potential of domestic remedies in the light of the fact that the system of shared administration is articulated in two dimensions: a European one, which is represented by the agency, and a national one, which is represented by the border guards of the host member states or other participating member states. To this aim, we would like basically to reflect on whether and to what extent this national contingent can be held accountable and what the implications are for the delimitation of competence and powers of Frontex. To address this question, we will very shortly recall the problems on the ground, in particular the fact that the system of shared administration is ill-suited to perform a clear allocation of responsibility, and this explains the existence of gaps. Then we'll move to reflect on the potential of domestic courts to fill in these responsibility gaps. And finally, we will issue some recommendations to stretch, to expand the role of domestic judicial remedies in that regard. So to begin, I think it's worth recalling that, as scholars pointed out, the European Border and Coast Guard, in fact, has not merged national border authorities into a new autonomous entity, but it has basically brought together national border guards under one single conceptual and organizational framework, under an enhanced supervision and direction at the European level. The EDCG regulation in different provisions that were also mentioned yesterday, in fact, confirms that the member states are the primary responsibility for their respective segments of external borders. And this was also reiterated by the General Court in the very recent judgment on the very first action for damages against Frontex in WS and others v Frontex decided on the 6th of September, in which in fact the court confirmed that the primary, if not the sole responsibility, lies with the member states. In so doing, actually, the court has also rehearsed a narrative which exacerbates the problems of lack of clear accountability patterns, because in fact, the General Court has overlooked the fact that Frontex de facto is involved in the implementation of decisions that de jure are taken by the member states. In the case specifically, it was a return decision officially adopted by the Greek authorities. So this explains, in fact, how fundamental rights violations occurring at the external borders of the European Union are actually a consequence, as we said, of the involvement of different actors. And as to the law, and based also on the following on the recent judgment of the General Court, it's basically difficult to find a solution in the existing system of judicial remedies at the EU level. This system is not well equipped to address situations of hybridity. So what is basically, and at the same time, we have also to acknowledge that bringing a state before an international forum, judicial forum, is even more difficult. So in this scenario in which different scholars actually reflect on the potential of EU judicial remedies and also international judicial fora, our focus will be on the potential of judicial remedies. So what kind of role can national judges and courts play in allocating responsibility? We will focus on two specific aspects. First of all, we would like to focus on EU judges as on national judges as EU judges. In particular, we would like to focus on to what extent European courts have the duty to fulfill the obligations under the treaty as European judges, in particular following the tenets of Article 19 of the Treaty on the European Union as interpreted by the Court of Justice in its stream of case law, including, for instance, Portuguese judges, in which the court confirmed that national judicial authorities are called to complement the role of the Court of Justice in ensuring an effective judicial protection within the EU legal order. And this is actually an aspect that connects with the role of national judges in using the preliminary reference procedure, which also connects with the duty of sincere cooperation. In that regard, I think that it's important to stress that all documents produced by an agency can be used, in fact, by domestic judges in order to ask clarification using Article 267 to the Court of Justice to clarify indeed what the human rights obligations, what the interpretation of specific provisions in an operational plan can be. And this is indeed a way also for national courts to fulfill the role of national judges. But apart from this constitutional setup, there are also some practical advantages on which we can also reflect to see to what extent the national judicial authorities can complement this mapping of accountability avenues. First of all, as we partly see also after the incidents in Greece and in Italy, national courts are better equipped in fact-finding activities, and in that regard, they can complement also the activities of civil society organizations or also institutions such as the national human rights institutions or national ombudspersons that in some countries have even the obligation to report to the domestic judges in case of border violence or violations of fundamental rights. At the domestic level, victims have also direct access, and this also also connects with the fact that the judicial proceedings at the domestic level can be also more effective time-wise, in the sense that they can be shorter. There is also another point that is worth stressing, which is access to public interest litigation that in some countries is available, in many countries of the European Union is available. It has been explored in the field of environmental law, but nothing prevents to use public interest litigation also in areas particularly sensitive like migration. And we don't have also to forget that, in fact, access to the domestic judicial proceedings is a pre-requirement in order to hold the member states responsible before an international judicial forum like the European Court of Human Rights, because, for instance, Article 35 of the ECHR, in fact, imposes such an obligation. Of course, some more legal and empirical research is necessary, and there are some limitations in the role of domestic judges. And in that regard, I think it's also worth reflecting on this, and I leave this to my colleague.
Yes, thank you very much, Salvo. So as Salvo was saying, there is a particular division of competencies between EU courts and member states courts that we need to take into account. So as we know, member states courts cannot rule on the damages allegedly caused by the EU, by Frontex, or by Frontex staff. And they also cannot review the validity of Frontex operational plans, status agreements, and formal individual decisions. They can and should at times use a preliminary reference procedure to consult the Court of Justice on the correct interpretation and application of those documents. So what this means is that having recourse to the national judicial authorities cannot, however important, fully close the liability gap that Sol just spoke about. But we argue that despite these limitations, domestic courts still play an important role in adjudicating on multi-actor situations. It is good to mention here also that one EU agency, the European Public Prosecutor's Office, is an exception to the rules just outlined. It is namely the national courts and not the Court of Justice of the European Union that review certain EPPO procedural acts or failures to adopt such acts. So one can think of the decision to open investigations. So here, effective judicial protection does depend on member states actually offering this effective legal protection. And in our paper, we do explain that this legal constellation cannot be transposed to Frontex given certain organizational and constitutional differences between the two bodies. But coming back to Frontex, what we see is that national courts will in principle only be able to judge on the liability of their own member state and the national border guards concerned, either in disciplinary, civil, or criminal law proceedings. And the Frontex regulation then provides that disciplinary responsibility is governed by the law of the home member state, the border guard concerned, and the civil and criminal liability by the law of the host member state. And while statutory staff enjoys immunity before national courts, it is also true that immunity may be waived, and then it is the court of the host member state to adjudicate over this officer's responsibility. So when looking at the national liability regimes, we see divergences in legal rules. And there's also the open question of how national courts actually allocate responsibility between these actors, which is something that warrants more in-depth and empirical research. So to ensure that domestic judicial mechanisms can enhance their role in providing effective legal protection, we make a couple of recommendations, which I will now briefly point out in passing. On the side of Frontex, we first state that a clear delineation and division of task responsibilities in different types of human rights obligations is necessary, both in the Frontex regulation and in operational plans, as the agency will otherwise be able to argue that a breach of an international obligation has not occurred or cannot be determined. Secondly, a proactive commitment to transparency on the side of Frontex is essential for national courts to perform their fact-finding roles. So in our paper, we've detailed what that proactive commitment should look like, and I'm also sure our colleague Dane Kovac will tell us more about that. So for national courts to be an important vehicle in adjudicating on multi-actor situations, a third recommendation is that national remedies should also be made more accessible for persons seeking judicial redress. for instance, by enhancing procedural safeguards throughout the legislative phase of the asylum legislation reform. As a fourth recommendation, the Court of Justice should consolidate its case law and the role of national judges as European judges, which Solomon just pointed out, and revise the discretionary room currently allowed for some national courts to ask for limited questions. And finally, our fifth and sixth recommendations respectively relate to raising awareness of the role of national judges to rule on multi-actor situations and on civil society to take recourse to these national instances. And here it is important to also compile comparative data on the quality and efficiency of national judicial mechanisms, and also to see what we can do in the context of EU national networks of contact points and how to involve civil society in this regard. So to conclude very briefly, in our paper, Selva and I make the argument that in light of the imperfect legal remedies at EU level in shared administration situations, national courts can play and are already playing an extremely important role in adjudicating on damages resulting from multi-actor situations, even though they cannot fully close the liability gap. So with the recommendations proposed, the aim is to further enhance the effectiveness of this domestic component, and we look forward to your questions and comments. Thank you.
Brilliant. Thank you very much. I'll turn to Jane Kilpatrick, who's going to talk to us about access to documents of Frontex.
Thank you and good morning, everyone. It's really nice to be here and to be building on the shared guidelines that we developed together at the workshop back in May. Until last year, I was a researcher at Frontex, oh my goodness, at Statewatch. I do that more often than you would think possible, but I was a researcher at Statewatch focusing on Frontex and Frontex's accountability. And in the time I was there, I definitely submitted my share of access to documents requests and saw how access to documents disappeared once the UK left the EU. And I wrote about various aspects of information control as a border control strategy. So I hope that this more practical perspective will be useful. I'm very aware in this room and on this screen that I'm not an academic, so I might have a slightly less intellectually analytical approach, but hopefully this is a useful perspective as well. So my paper that's in the Dropbox introduces some background to the right of transparency, its place in the Charter of Fundamental Rights of the European Union, and its relationship to the rights to good administration, to effective remedy, and of course to access to documents. The right to transparency is integral to democratic participation, and further to being an individual right, it is a public collective right essential to ensuring social and political accountability. So in May, I discussed the limits of Regulation 1049/2001 on access to EU documents, and in particular, problems with Frontex's implementation of this regulation and how, even within the rules, the agency manages to create many obstacles to transparency, particularly for people not citizen and resident in the EU. So I recommended then that Frontex remove the limits imposed by Management Board Decision 25 in order to extend access to documents to third country citizens and residents. There are many other issues with Frontex's approach to transparency, as we've been discussing yesterday and beginning to discuss this morning. I've written about these with Statewatch. Myself and Mariana Gliatti have written about them, and I know that Laura and Mariana have written a very comprehensive article about the inappropriate application of Regulation 1049 with Frontex. So today I'll try to focus specifically on the barriers imposed on access to documents for people outside the EU. I'll first recap very briefly the reactive and proactive obligations on transparency relevant to Frontex, and I'll then focus on Frontex's implementation of these obligations before exploring why this creates problems for people based outside the EU. And then I'll reflect, hopefully if I have time, on how a focus on proactive transparency might improve the situation. Even after having gone on about access to documents requests, that will probably make more of a difference. So Regulation 1049/2001 regarding public access to European Parliament, Council and Commission documents outlined obligations of EU institutions, procedures for access, and legitimate limitations of the right of access to documents. So it outlines practices of reactive transparency in which EU bodies must register and respond to access to documents requests within specific timescales, and subject to exceptions based on, deep breath, public security, defense, international relations, financial economic policy, privacy, commercial interests, protection of court proceedings, inspections, investigations and audits, and protection of decision-making processes. And Article 2 outlines that the right to access to EU documents applies to EU citizens and residents, though it allows for EU bodies to extend this right to people outside the EU as well. Regulation 1049 also supports proactive transparency practices, requiring public registers of documents to provide direct access to information. Frontex incorporates this regulation through Article 114 of the 2019 Frontex Regulation and Management Board Decision 25 of 2016. So Article 114.2 actually refers to making certain information available to any interested party and lists a range of documents that should be publicly available, but I would argue not yet fully available. And so Management Board Decision 25 implements Article 114 and details practical arrangements for access to documents requests. This decision requires that all applications must be accompanied by an identity document or proof of registered office. While Frontex is entitled to do this, and an ombudsman inquiry based on State Watch's complaint found no maladministration on this point, it's the only EU agency or institution to apply such a requirement. Decision 25 does refer to Frontex's capacity to allow on a case-by-case basis requests from people who are not resident or citizen in the EU. And Frontex's press office has claimed that it does so, but it couldn't say if it had ever accepted such a request. And we also know that Frontex has refused access to a document to an organisation based in Senegal when it has shared that document with an organisation based in France. So practically, by requiring an EU identity document with each request, the Management Board decision contradicts its capacity to accept requests from outside the EU. Frontex claims that in practice it receives very few requests from outside the EU, but it doesn't probe whether it's the obstacles that it itself has implemented that has played a part in reducing the number of requests. So the limits to this right of access to documents and Frontex's approach within them create a situation in which the people who are affected by the agency's work are the same people who are unable to access information about them. Frontex's operations and other activities at the EU's external borders or outside them are by their nature complex, multi-actor structures, as we've discussed at length, creating potential gaps in accountability and enforcement of fundamental rights if transparency on decision-making, roles and responsibilities is not ensured. The original limits of the right to access to documents were not designed with the operational powers of an agency like Frontex in mind, especially considering that its activities primarily affect people outside the EU or at its borders, rather than citizens or residents of the EU. Regulation 1049 protects transparency and access to documents as a necessary part of democratic participation, and Frontex's role in scoping missions in states like Senegal and Mauritania, leading to the negotiation of status agreements, demonstrates how it is becoming increasingly likely to engage the right to meaningfully participate in democratic practices, processes outside the EU as well. So in West Africa, where my research with Mariana has focused, Frontex's presence and activities are quite little known, and local civil society face a cloak of obscurity in monitoring the agency and advocating for the rights of people they support. Researchers and NGO representatives in Mali and Niger, for example, cite heavy reliance on EU-based individuals and organizations to access information as a barrier to their knowledge of Frontex activities in their own states. This reliance on another organization adds to the already significant length of time that it can take for Frontex to register and respond to information requests. The portal that it uses is very awkward. Documents and communications disappear after 15 days. And when they are granted, sharing and publication of documents are discouraged by the communication of a misplaced copyright notice. So when you add in additional communication between the real requester and the person that they have contacted to submit their request, every application can start to take a very long time, become quite complicated and quite resource heavy. And at the end of this very unwieldy process, a successful request for access to documents is still quite unlikely. 13.9% of requests were accepted in 2017, I think, but it was less than 5% in 2020. So to try and reconcile the principles of openness and transparency as fundamental to democratic participation with the fact that in some of the countries in which Frontex operates or has working relationships, rights to access to documents aren't as extensive as they are under the EU's framework. Access to documents should at least expand at the same rate as the agency's operational footprint. The right to access to documents should at least apply to citizens or residents of states where Frontex officers or officials are deployed, are present, are conducting scoping activities, or engaging in information sharing or capacity building. So I still think that Frontex's management board should update the practical arrangements for the application of Article 114 and remove the limitations imposed by Article 5.3 on identity documents. However, as this will not solve the onerous procedure of obtaining access to documents, Frontex should follow the principle of ensuring the widest possible access, complying with its obligations to properly maintain and register the documents. So the register is a central component of Regulation 1049's proactive approach, but Frontex actually only launched its register, I think in 2022, and it might have been 2021, but let's say 2022 for now, following a State Watch complaint and an ombudsman investigation, and work with MEPs to chase Frontex's commitment to create one. Sadly, many documents are still missing, including some that were previously available. And I think this does reflect a culture of secrecy that needs to be addressed. And I do have some thoughts on that, but I'll finish just by emphasizing that solving this lack of proactive transparency, access to documents for everyone might be improved while also reducing the resource demand this currently imposes on the requester and on the agency. So I'll leave it there. Thank you.
Thank you very much. So lastly, we turn to Julia Raimondo, who's going to talk to us about third state immunity under Frontex status agreements.
Thank you. And so I will start just thanking the organizers of the shared project that helped us all, and in particular me, to shape and sharpen the ideas that underlie this paper, the paper on immunities of Frontex officers in third countries that I will discuss in the next 10 minutes. Since its inception, Frontex legal framework has included increasing cooperations with third countries to ensure the effective management of the European external borders. Over the years, Frontex cooperation with third countries has taken several forms, ranging from its involvement in the implementation of bilateral agreements between member states and third countries, to direct partnership and cooperation in terms of information exchange with third countries' authorities. Sorry. Since 2016, Frontex has had the possibility to launch joint operations in third countries, where the agency team members are also entitled, under certain circumstances, to exercise executive powers. To this end, Article 218 of the Treaty on the Functioning of the European Union, the Commission negotiates these agreements, which are then adopted by the Council. To date, the EU has signed status agreements with a number of Balkan countries, including Albania, Serbia, Montenegro, and North Macedonia, and is also negotiating agreements with Bosnia and Herzegovina. In 2019, as you all know, Frontex regulation was amended and broadened the scope of this cooperation with third country to any third country, including neighboring ones. And in 2021, the Commission took this amendment into consideration and tabled a revised version of the model status agreements, based on which those status agreements should be drafted. Importantly, this upgraded model deleted the reference, to all return operations. And we can find in this model status agreement many more references to fundamental rights safeguards such as, for example, an increased monitoring function of the Fundamental Rights Office. After the Russian invasion of Ukraine, the EU signed a status agreement with Moldova based on this 2021 model. And in the meantime, all the status agreements with Balkan countries are being renegotiated. And for example, the status agreement with Montenegro, the renewed version entered into force on the 1st of July this year. At the same time, the EU is also starting to negotiate cooperation agreements with countries that are non-neighboring countries of the European Union member states, such as Senegal and Mauritania. While the protection of human rights within this framework has improved, many issues remain to be solved in law and in practice. Here I will focus specifically on two of them. One is the delegation of powers, and the second one is the extensive immunities granted to Frontex officers. When cooperating with third countries, Frontex must comply with the principle of institutional balance and with the Meroni Doctrine, according to which EU institutions might delegate their powers to external bodies only where those powers are clearly defined and subject to the institution's supervision. In the ESMA judgment, the Court of Justice of the European Union added that agencies could be endowed with specific powers via secondary legislation, but those powers cannot go beyond the bounds of the agency's legal mandate and should be circumscribed by various conditions and criteria limiting the agency's discretion. In relation to Frontex status agreements, the limits to Frontex discretion seem not clearly defined, especially in relation to the executive director discretion related to decisions concerning the suspension or termination of joint operations in third countries, but also member states, and the waiver of jurisdictional immunities of Frontex agents. Neither Frontex regulation nor the status agreements include specific criteria or procedures that the executive director should follow to take decision on waiver of immunities or to characterize an act as performed in the official functions of a border guard. Moreover, it remains unclear why Frontex executive director determines the waiver of immunities and not the head of Frontex parent organization, that is, for example, the European Commission or another neutral organ within the European Union. If we look at the European Union status of forces agreement, for example, the waiver of immunities is decided by competent EU institutions rather than the EU commander. In the UN system, it is exclusively the Secretary General of the UN that makes such decision, even regarding the immunities of specialized agencies. The extensive discretion granted to the executive director regarding the characterization of an act as performed in the execution of official functions and the very decision on the waiver of jurisdictional immunities of border guards is at odds with the principle of institutional balance and with the Meroni Doctrine, requiring a clear definition of delegated powers and clear conditions and criteria limiting the agency discretion. Turning now to the issue of immunities more specifically, all status agreements contain a provision on privileges and immunities of team members, as well as the possibility of waiving this immunity from the jurisdiction of the third state or being prosecuted before the respective home member state of the border guard consul. Those immunity generally cover all the acts performed in the border guard's official functions. Yet, the 2021 model status agreement and the new agreement signed with Moldova grant team members immunity from criminal jurisdiction under all circumstances. Now, honor to the truth, this possibility has been deleted in newer agreements with North Macedonia and Montenegro. Yet it is not clear why this differentiation was introduced and whether this will remain a best practice or not. Be that as it may, the logic behind immunities is that they should protect the interests of the organization, which should be able to operate free from external influences of the state hosting the operation. While this criterion is difficult to monitor, it has been criticized in the literature, and especially because international organizations are free to abuse it, and there are many examples. In theory, yet, this principle could limit the extent to which international organizations operate covered by immunities. Granting Frontex agents absolute immunities from the criminal jurisdiction of host members of host third states seem disproportionate, considering the nature that is merely cooperative of Frontex joint operations. In contrast to UN peacekeeping missions, Frontex is not operating in a hostile environment where the host state might block its activities. On the contrary, it cooperates on multiple levels with third states. Moreover, the large margin of discretion granted to the executive director in relation to the waiver of immunities seems at variance with this understanding, with this functional understanding of immunities of international organizations. Lastly, the possibility of being prosecuted before the respective home member states seem to limit this possibility only to border guards that are seconded by member states. In fact, any prospect of prosecuting Frontex statutory staff before national authorities seems precluded by this provision, because they don't have a member state, literally. And this creates an important accountability gap, which is not in line with the requirements of the Frontex mandate, namely that the agency must be fully responsible and accountable for any of its actions or decisions. To solve these issues, I would propose to look at preventing human rights violations from occurring and addressing the lack of available judicial redress when violations occur. Accordingly, first, before the EU signs a status agreement, there should be a fundamental rights assessment, be that done by Frontex or the Commission, and this fundamental rights assessment should be transparent and public. Second, there should be clear criteria according to which the executive director or anyone else within the European Union should evaluate and decide on the waiver of immunities. Third, Frontex complaint mechanism should ensure access to an effective complaint, to an effective remedy, and which should be effective and impartial. To conclude more concretely, the European Parliament should monitor the Commission fundamental rights assessment when those are done, and where the Commission does not inform the Parliament about the fundamental rights implications of Frontex status agreements with third countries, the Parliament could and should request an opinion to the Court of Justice of the European Union regarding the status agreement's compatibility with the treaties. Thank you for your attention.
Brilliant, thank you. And so I guess we have a stakeholder comment from Amandine Bach. Shortly.
Thanks a lot. I'm trying. We are a lot on the podium today, which is nice. I would start my comments by thanking the promoters really of the shared project. I remember when you had received the news in Brussels that you had received the funding, we were in a strategic brainstorming session with different stakeholders as well. So it has been a very interesting journey to accompany you from the start, from the very moment you received the good news till today at this final conference. And I can say this on behalf of my MEPs as well, who were at the conference in Brussels and joined today. So just, to make it clear, because often since in the program I appear as European Parliament, I'm an advisor, so I'm not a functioner in the Libe Secretariat, but I'm an advisor for the left group in the European Parliament. working in the Libe committee and advising so the different MEPs who are members of this committee and the left group in general about migration asylum issues. I've been doing this for 10 years and a half now. So I had multiple recasts, as you can imagine, because the Commission loves recasting different regulations. So I do the Asylum and Migration Pact files, but also I did 2 recasts of the context regulation. And I'm hoping not to have to do a new one. And I know you're not responsible. So, because the last one negotiated in 6 months and recitals last night were really bad decision making, I have to say. So I think it would be very interesting if all of you in the room could just, it's in-camera meeting, so you can't, but could one day be a little mouse in the room and I mean, Tineke is there all the time, but like listen to these technical trialogue meetings and political negotiations, because I think sometimes it's really shocking to scholars and lawyers, because really we are under so much time pressure, and it's a case at the moment in the pact. We had it with the last Frontex recast. So when you're looking at these words, it's not very clear. No wonder. This was, negotiated like in such a hurry because of the paramount political pressure that it is not, accidental. It's not logical. It's the cost of long of political compromise and very hasty drafting at the beginning. And the Frontex recast was really this. I had never, I think this is the file where I experienced the most pressure. And I will mention in some comments to some of your presentations today. So this panel is really a key one. I would like to thank really all the authors of the different papers, because for me, working in the European Parliament, we talked about it yesterday. We have seen a commission not acting, and even, I would say, no, they crossed another step, showing full support to governments that just passed laws that were clearly violation of the EU acquis, as we discussed yesterday with Lithuania, Latvia, Poland, North Finland. Thanks for plugging, because I hadn't seen this, or where violations are systematic and extensively documented, as we have in the case of Greece. And this morning, waking up, I saw Johansson's tweets expressing full support to Greek migration minister and two tweets promising additional money. So for me, no more, fundamental rights concerns, this is blanket support. Tunisia and Morocco are also clear examples. I think we move to, it's not only inaction, it's full support. So it's complicity. We move to something else. So, and it's not lack of knowledge of the violations. We had many meetings with Johannsson. She knows the Black Book of Pushbacks. We had 2 editions published as left group. We handed them to Johannsson. She fully knows what's going on. She fully knows that the laws at certain borders are illegal. It's just a price to pay. And so it's a political decision to support and to keep on, to not suspend funding as well. So in the face of this reality, you still have some voices in this current parliament from the left, Greens, SNP and Renew groups. I don't know what will happen in the next one, who keep calling on the Commission to act, reminding their role as guardian of the treaties, calling at almost every single Libe meeting for infringements, suspension of funding to border surveillance, as if funding is key to enable the violations to happen and to seize, you've seen recently also with Tunisia and democratic deals with autocratic regimes violating migrants' rights and the rights of their own populations. In every Libe committee meeting, you can see these dynamics from still these 4 groups. So this has become a rule of law concerns, not only in the member states or third countries, but I would say also for the Commission itself. In this context, I would say that this panel indeed, because we look at, at courts as the only place where remedies could be sought in order to address these violations. That's why this panel is really interesting. But in the recent years, we have seen increasingly on the recent case on the return of Syrians, we have seen that the courts have not fulfilled these expectations and also ruling some cases inadmissible, as was the case for the failure to act on Article 46. So that's why, I mean, and now I will go one by one on your papers. It was really interesting for me to read all of your papers. We start by order, Maria Jose. Your paper about responsibility for damages committed in the framework of CSDP, missions and Frontex is really interesting because it's very complicated. Nobody knows exactly what's going on. We have also, because with CSDP, less access to information. I think in Germany is the country where you had most debates because they tried to, I mean, they blocked at one point. So that's really the only place where this has ever been debated, I think, at national parliament level, and they were really advocacy. I mean, in my own country, France, nobody knows about this. But it's also interesting because I mean, it's one of the fears we have because you had the Meloni call for the naval blockade during the campaign, but no, it again, she made it. And, but we have the ambiguity of the new von der Leyen 10 points. I think a lot of things were not new, but then you had the point 5 where it was about talking about naval operations. So what exactly would it mean? So I think in this context, where maybe there will be new things, coming in the next months with Tunisia potentially, hopefully not safe, third country, so there are a lot of risks, and I think this is an area we should not. We should increasingly look at. And I really liked your description because it's very. I mean, for me, I used to be like, I'm not anymore. It's been a lot of years, but I like that you were really factual. You described different scenarios. You made it real. So when we work on the issues, this had resonance. And I think that it is more likely that a case could be brought based on the first scenario than the second one, because I think the second one related to training would be almost impossible. Or, I mean, we don't know. Maybe we will have illegal things in the years to come, but then they would make it legal. But I see this quite unlikely because we did check curriculum of training, and yeah, they were putting the emphasis on fundamental rights and all of this. So yeah, this is less likely. I also really like the parts because that's something I really didn't know, the parts about the jurisdiction, and your argument was really good. So thanks a lot. But I hope we won't have really horrible developments that will lead you to become one of the key voice in this. And I'll move to the second paper, Elvina. Thanks a lot. I still believe that we shouldn't give up totally on judicial remedies at EU level, but I'm really puzzled by one of the things that you mentioned repeatedly, the fact that the right to effective judicial protection enshrined in the Charter seems to be just words when we look at these court judgments. So I think it was interesting you put the emphasis on this. And for me, I mean, when I was in the plane yesterday, I read again the recent case, WS versus Frontex, and the fact that the court didn't even look if Frontex had conducted due diligence by, at the very least, checking if a return decision had been issued, for me is very problematic. They really didn't look into this, so that's. So while it's one of the mitigating measures that has been put into place in Hungary, so this is, very, very problematic to say the least, because that means, you just can, I think, a driver of a robbery or different things. I mean, you can just provide the means. You're providing all the means to conduct an illegal operation. So I have nothing to do. So that's really worrying. The same for the inadmissibility of the Article 46 complaints, because even when we have things in legislation, I mean, we see the hurdles. I think your approach to look at the potential of domestic judicial remedies is really interesting. It's deteriorating context, and thanks a lot for the recommendation. I wanted just to flag one thing regarding the first recommendation that also is in the guidelines on the need for clear delineation of responsibilities and obligation. As I said yesterday, I participated in the negotiations of the two past regulations, 2016 and 2019, and this is not mistake. have, you know. And I guess you all know it, but this is politically intended by the council to not have this in mind. And the parliament tried on many occasions to work on this. I mean, there were amendments tabled, but this has always been refused by the council, and we didn't get support. So this is really intentional that nobody can. And if, you know, I mean, I'll be moderating the next one, but yeah, I mean, that's why we are not in favor of reopening the Frontex reputation, because this can only become worse, you know, and so this is not politically wanted. Of course, member states have no interest, nor the agency, nor the commission. So have clear responsibilities. I'm about to Jane. Thanks a lot for your paper, for looking at this crucial issue of the access to documents by third country national and access to documents in general, also for the previous work for State Watch. I didn't know that Frontex was the only agency having this restriction, so I learned a new thing. But that's I believe, I mean, we are addressing this issue both Tineke in our report on the Frontex agreement with Mauritania, if I'm not mistaken, and Cornelia Ernst, who is the rapporteur on Senegal, Frontex agreement with Senegal. We did also address this. So we also had recommendation on third country NGOs being able to be part of the fundamental rights forum. It's a consultancy platform. So we had different recommendations to take into account Frontex increased presence in third countries. So that's something that we are taking on board, at least I mean, the left and the Greens. It is always being negotiated with the other groups, but we are fully aware of this, and it's really good that you stress this. And I wanted also to stress the issues of, I mean, many of the issues you raised, I mean, MEPs also face it, you know, the copyright. I mean, I had MEPs when they receive documents, like, what do? I mean, then I cannot use it. We had it even, I think it made it to the final document of the Frontex Scrutiny Working Group, that we were telling Frontex not to use this copyright anymore, but they are still doing it. I mean, I couldn't see because our latest requests were all denied for the fact that it was not specific enough, even if a lot of this, I mean, we had a long list, you can imagine us left, but then a lot were specifics, a lot were serious incidents reports or for opinions. Until today, we haven't been getting them, which is a big issue. I would say, I mean, after Legeri, there was a thing that things will change. So directly after or on his lead to the exit, the parliament got a lot of information via the Frontex during 4 months. I mean, we got like emails, we got, I mean, hidden in many subfolders. So they transmitted it. It was crazy the way we got the documents. So you really needed to want to read, and it was only advisors and MPs who had the right to do properly your job. And I would say a lot of people didn't. So you could see it when we were negotiating the documents. And and I would not name some groups, but some groups. It made it more easy because in negotiations you could say, as we could read, because you can only discuss this among people who had access, but everybody had access, as we could read in these documents, and you could see then a lot of people had read. So that's another issue. But this, we are losing. I mean, for example, I said it yesterday when Tineke intervened. I think it's 2 or 3 meetings that we are not getting minutes anymore from the management board. We are not getting the frozen opinions anymore. We used to get the full description of the serious incidents report. So we get the very extensive report, which is very good, coming from the FRO, that is presented as attachment to the management board meetings. But it is different. And I think both are complementary, and it would be useful to see the FRO opinions. So, and the minutes as well. I can understand why they are not sharing it, but that's an issue of just transparency. And I think as Tineke put it, we have to keep insisting on the fact that the Frontex Scrutiny Working Group, as it is almost that, let's call it like that, is really an issue, but it's also political. So I think we only did proper work during this period that led to this. No action was taken. Last but not least, Julia, on the Frontex status agreement with third countries. Reading your paper, I have to say that I'm very pleased because last mandate, one of the strongest thing the Commission wanted in the last recast of Frontex was to add the possibility for Frontex to return from third country to fourth country. I'm sure you would have been delighted to follow this in terms of fundamental rights monitoring. The Parliament didn't yield. This was something the SND and Renew group, we and the Greens and the left were opposed. I mean, this was clear red line, and the red lines were crossed already. So at the end, it was we, SND and Renew, because they knew they couldn't count on our votes. But yeah, these two groups refused this. I don't know next month to big commission because we make it. And that's really, I mean, guaranteed violation of human rights. Because no, especially after the judgments. So you can see, I mean, imagine in third countries, I mean, you could do whatever. I mean, they wanted the Balkans, that was clearly, I mean, Serbia, North Macedonia. But this would have been crazy. And I mean, impossibility of that's what we were saying. So I'm really glad and reading your paper and all these issues. We didn't yield. I have one question for you because since we are rapporteur on the agreements with Senegal, and when we went there with Cornelia and Tineke, Operation Hera, and you referred to it, and was operating in territorial waters of Senegal. Frontex argues that it was legal under bilateral, Spanish agreement, but I mean, I have my own doubts that this was legal because normally you would not cooperate with a country that was not neighboring, and I mean, at that time not possible at all. So I don't know if you looked into this, whether it was really in line, because my own, we had even this debate with the delegation in Dakar. I mean, my own analysis that they didn't do it. And now they use the new regulation as like, we had to stop it because the new regulation was putting conditions and having a status agreement, while the new regulation enables many more things. It has fundamental rights safeguards, but it is the first time that it enables Frontex to be active outside of the neighboring country. So, but they put it the other way around, like the new regulation is restrictive. So it's so it's a question. And then I share fully your questioning, I'm almost done, on the Commission interpretation that they don't need to do ex-ante fundamental rights impact assessment before deciding deciding to launch negotiations for a status agreements. I mean, for us, I mean, Tineke described it yesterday, this is extremely problematic because in the Frontex regulation, you can also decide not to negotiate. That's stuff before. And yeah, I mean, the fact that they don't look into this is really problematic. And they don't pretend they even take this into consideration before, so they say that they just do it after. So the practice we have seen in the European Parliament is really a tick the box exercise, what Tineke talked about it yesterday, because on North Macedonia we got 4 days before the people, and because Tineke and Cornelia insisted, and when it comes to the FRO impact assessment on that come only for, I mean, analyzing the joint operation plan, for me, from what we could hear till now, it just, I mean, aims more to ensure that there will be no causal link when on the ground between violations that might occur and Frontex staff. So the way it has been described to us by one of the firm has really been more like this. We will ensure when we talk about Mauritania and Senegal that they would not end up in this situation. So and when we ask about but then we recommend not to start, I mean, not to have an operation, and it's really not designed, at least from the description we got. So it was really more damage mitigating measure of approach and really disposal. I could read in the question of immunity is a big one. The arguments, and it's not, we heard it yesterday, but we heard it also from from other actors, even from the Commission, on the illegality of LGBTI conduct or drinking alcohol. We heard it is not in use, you know, to grant full immunity for Frontex staff. But this is something that when we heard it in the parliament for the first time, I mean, maybe it should, you know, need to reconsider whether a country deeming LGBTI conduct a crime should not be supported to intercept people who might also flee this situation. So it's, you know, the fact it's like these countries, and it was not only this. I mean, I think it was the commission who said, yeah, but you know, the rule of law situation in Mauritania. But yeah, then don't conclude an agreement, because if you're so afraid for Frontex staff, then it is really, you shouldn't be completely this country. So, and I will end here, and really thanks a lot. That's very interesting.
Brilliant. Now, you've asked me to commentate for 10 minutes, but I'll try and keep that a bit shorter because obviously I want everyone on the floor to engage, have a chance to engage in the discussion as well. So these were all fascinating papers, I thought. I'll just pick out what I thought were some of the most particularly striking sorts of issues that maybe we want to discuss, or the speakers want to discuss. So in Maria Jose's paper, I thought it was interesting the way that, well, first of all, both the first and the fourth paper, I think I had common questions about, which is, given that the General Court has now given its ruling on, you know, being quite willing to say that Frontex has no responsibility as compared to member states, you know, could we have an even worse situation from accountability point of view once you add a third state? You know, so someone else, the General Court could say is potentially responsible, perhaps jointly with member states or whatever. So does that make the accountability, at least the judicial damages accountability argument, even more difficult to bring? But there's several specific points about that paper, though. It was very interesting the way that the crossover with the defense policy played out. I mean, one of the footnotes was really interesting, I thought, in saying that the Court of Justice, the General Court of Justice, has already said that the council is responsible for the missions. So in a way, pointing us away from the solution of the Frontex case, but saying that there's also some German case law which says the opposite. And I wonder if that should be the main text and fleshed out a bit in terms of, you know, which is it and how do we apply that to these particular missions? And then the jurisdiction point, which is obviously crucial, sort of comes at the end. I wonder if it is fully separate or perhaps should be earlier in terms of the court's jurisdiction to rule on defense missions at all. The idea of joint responsibility of the council and Frontex, I thought was interesting, sort of turning the joint responsibility back where a defense policy measure was involved. But again, you have the problem that even though the EU court might say, there's joint responsibility of the council and Frontex, there wouldn't be jurisdiction to deal with the council part. Of course, you know, the Frontex part was delegated to the council, but we have no jurisdiction over them. So, you know, there is that awkwardness. And of course, we do have to wait for the Court of Justice ruling on the question of damages liability for missions. But I wonder if it was worth fleshing out where the discussions are at in the council with the issue that got deferred on ECHR accession, which is how to deal with the foreign policy points. And I think anyway, the council is probably waiting to get those judgments, but until it feels it can act. I had a couple of other points there. One was there's an assumption that there's a non-refoulement problem in terms of Libya. And I wonder if that's necessarily correct if we're talking about people in Libyan territorial waters, because they haven't left Libyan waters, so therefore are they being returned? I mean, it might seem, you know, obvious that we want to say that they are, but is that so necessarily obvious that that's how the non-refoulement principle would be going to apply? On the types of damages, I mean, is it so obvious that Frontex, if we has liability at all, would be responsible for the risk of not being rescued? I can see a much stronger argument in terms of the treatment in Libya, you know, because that would be a consequence of Frontex informing Libya. But is that so? Is the risk of not being rescued? So, you know, is there something to do with the individuals or the smugglers or something who rather are causing the risk of not being rescued? Another question I had, and it is of course awkward to bring in another set of legal rules, was whether maritime law is relevant here in terms of search and rescue responsibilities, because you know it tells us that the vessel in the best position to give aid and assistance is the one responsible for giving it. But isn't that relevant to how we assess the question of causation and accountability potentially as well? And on the training point, I think I share those doubts that it might be difficult to establish. So playing Frontex devil's advocate, I mean, first of all, I could see a counter argument that training doesn't transfer responsibility at all. It's always the responsibility of the trained people, what they then do with that training. You don't have the control that you do in the case law on CDSP missions of what happens if you're just training someone. Certainly wouldn't want to be responsible for everything my law students go on to do in their future lives. And in any event, in the alternative, well, you'd only be responsible, if you're responsible at all, if you gave training that suggested that you ought to commit human rights abuses. And as Amandine says, I mean, it doesn't look like that's likely to be the sort of training that Frontex gives. Surely they, whoever else goes with them, does tell people that they ought to comply with human rights, even if they're winking a little bit, as they say it in Libya. They are presumably not suggesting human rights breaches. So those were the points I had there. All I think fascinating. On the second paper, I think what jumped out to me, and you know, I used to argue. I mean, if you asked me 10, 15 years ago, I would have said that the recent judgment was correct because the legislative system was different, and Frontex seemed to have less responsibility for what it did, and the member states' authorities seem to have more. And I always thought that, well, the focus should be under those circumstances on national accountability. And how do you get that? Well, maybe you should amend the Schengen Borders Code. Of course, we have the opportunity to amend the Schengen Borders Code. I looked at what the Parliament voted for last week, which was completely out of order, so it's very hard to find anything. But I don't know if there is anything in there on making more national accountability for actions of national border forces. So that is potentially a missed opportunity there. But how is there another way you can get to it? Yeah, I agree that the EPPO analogy isn't great because the legislation provides for very specific roles for the EPPO. Also, it's unhelpful all the legal challenges so far have been thrown out to the EPPO, or the different sorts of challenges. And in any event, I think more fundamentally, I mean, this is administrative law, not criminal law. So, and again, there was a comparison with fair trials legislation. I don't think that helps because this is administrative law. It might be more useful to look for models in EU law of shared administration. I was thinking of pharmaceuticals and chemicals, but I know nothing about them. But then the case law, of course, the WS case law, makes it easy for us. Maybe we don't have to overthink this because the judgment refers to the Returns Directive and member states' responsibility under the Returns Directive. It also refers to asylum. And so, and of course, those are both being negotiated as well. And maybe the solution is to provide for something in that context. I wouldn't want to provide for it in visas because, of course, the Court of Justice says there's a very deferential judicial review for visas. But this does seem to me, and the WS judgment says that this is linked to the returns and asylum framework. And it seems to me that may be somewhere where the liability of border guards could be properly dealt with. Other than that, of course, we're waiting for a national court to ask a question about some dodgy actions by border guards. And perhaps one thing that could be fleshed out is, to what extent are there sort of brief references to human rights and operations of national border guards capable of being interpreted by the Court of Justice if it were ever asked to develop standards on accountability for national border guards. On the third point, yes, this was fascinating, Jane's paper. It brought me back to my time assisting Statewatch, the very beginning of the access to documents regime, when there wasn't even an online council register of documents. You didn't even know which documents existed. I suppose Frontex is in a way a bit like that. And so, the only way to find out which documents existed was to ask for the agendas. They deleted them after a year or two. So you had to keep asking for all the working group agendas. And then they said to State Watch, you're making too many applications, so we refuse to even consider your applications. So I came in, and then they said that to me. And so I asked some real colleagues to help me make some more applications. And I asked some colleagues who were maybe fictional to also help me. I think there was a Mulder and a Scully, tells you how long ago this was. And a Dr. Michel Souris, I think that was a over literal translation of Mr. Michael Mouse, helping me as well, making applications. And we did get a lot of agendas that way. But not, my point here is not just that anecdote, but are there ways around that obvious problem with that Jane described about what Frontex is doing? Of saying, oh, well, you need a residence document, even though all our work concerns people who aren't residents, or even people, you know, in other countries, going to other countries and having operations there. I mean, are there ways around it through getting lawyers or NGOs which do have residents, who do have residents in the European Union or some other way to ask for documents when you need them? Or, of course, can you fix the situation? We don't want to go back, as Almudine says, to amending the Frontex regulation. Is there some way that political accountability can nevertheless be pushed via the discharge procedure or the various other ways in which the Parliament has made life a little bit unpleasant for Frontex over the years? Is this one thing you could ask for in that process? And I think a bigger question is whether you might try and look at what I would call accountability by design, to build something, again, might be hard to do without amending the Frontex regulation, but perhaps what we should have is something built-in independent investigations where there were serious allegations against Frontex, the current model not having apparently worked very well, I would say, for that. You know, if we have independent investigations, then they could have their own framework on documents that would be available. It wouldn't be internal documents to Frontex. Have a chance to rethink it in that context. And finally, Julia's paper, I thought, also very interesting. Didn't mention the UK, of course, which may be the next third country to agree some working arrangement with Frontex. And specific issues arise there. If the UK were to dump the ECHR, what do you do with that? But of course, as she points out, some countries like Senegal and so on, of course, are not ECHR parties anyway. But that might be an interesting thing to be fleshed out. What are the human rights standards we would apply to a party that either doesn't sign up to the ECHR or used to sign up and now has deliberately left it? Again, I thought the responsibility allocation, could it be handed to a third state, was relevant here. And I did wonder, though, I mean, if we read the WS case as being specifically about returns operations, that maybe might be different pushbacks. Well, could you say the same sort of thing here, that whatever we say about missions in the first paper might be different when we talk about status agreements, given that they have tried to regulate these accountability issues specifically? One thing that came up, and again, coming back to the second paper's point about criminal analogies, yes, it may be unhelpful to, to have criminal immunity. But I don't think that sort of exhausts the question of what we want as charter remedies. Yes, it's nice to think that, cops or border guards who do bad things could face criminal responsibility, but it's not the only means of accountability. There's the sort of broader accountability of national or non-state, third state or Frontex itself, in terms of liability that we could also look at. Of course, those are problems, but they're separate problems from the criminal immunity of Frontex forces. So thanks for everyone's contribution. It was brilliant. And I'm sure there were some great questions, comments coming from the floor. Who wants to start? Go ahead. Of course. Well, does anyone want to start, or shall we ask the speakers if they want to respond to comments that I have made? Yes. So you want to reply?
Well, thank you so much, both of you, for your insightful comments. So my reactions, trying to answer to all of them. well, regarding what Amandine and Steve has said about the comparison between the first scenario and the second one I talked about, I also agree that probably the first one would be more likely to succeed than the second one. But well, at least what I try to make in this paper is that trying to show more or less that at least in theory is possible. We use criteria drawn from, for example, the principles of European tort law that I think would be interesting to transpose to these migration and asylum scenarios. Why not? Regarding the responsibility gap that might be about the jurisdiction regarding the CFSP and CSDP missions. Well, yeah, it's true that there is like not defined criteria in case law right now regarding if the council might be responsible or not. I've also looked at this German case you are talking about. But in that regard, I'd say that we have to wait until the court says or something in its judgment on the pending cases. I've also talked about the KS and KD, and especially because it's interesting. They are like dealing specifically with CSDP missions like EULEX Kosovo. So yeah, we have to be aware of what will be the outcome out there. But in my opinion, there's a chance that the court might say, yeah, we have jurisdiction for dealing with these matters as it's case law. It's broadening in these matters. So yeah, if we see its case law regarding CFSP, we see it's broadening, especially regarding the principle of effective judicial protection. So let's see. And regarding the use of the principle of non-refoulement in the scenarios I was talking about, I do think it can be applied here, especially if we look at what the expert roundtable discussed during a meeting organized by the UN High Commissioner for Refugees, saying that the content of the principle of non-refoulement includes any measure that may have the effect of returning an asylum seeker or refugee to the borders of territory where his or her life or freedom would be threatened, or where he or she would be at risk of persecution, including interception, refusal at the border, or indirect refoulement. So if we say it like in this perspective, I do think that it can be applied. And okay, regarding question of damages, I agree with you. Like this. Okay, just because the other day they couldn't hear. Oh, okay. Sorry. Oh, wait, no, don't worry. So, okay, yeah. Well, yeah, but my last comment. Regarding the training scenario, yeah. Yeah, as I said before, it's more likely to succeed, but in my opinion, given the existence of reports and allegation of human rights violations against migrants and refugees committed in countries such as Libya, the missions, we can argue that the mission and Frontex staff should have put more emphasis on training them in human rights complaint behavior. We can also use here a foreseeability criterion on dealing with the causal link in this scenario. But that's my opinion. And thank you so much.
Thank you. Just a couple of very short comments to react to both Dean and Professor Pierce. Indeed, I do believe that we don't have to give up with EU remedies, and I have to acknowledge the excellent work that civil society organizations are doing to stimulate the Court of Justice to be creative or to create new case law. there is an action for damages that is currently pending on Amudi, so let's see what will be the outcome. I'm not that optimistic, even if yesterday I proposed to end up with some optimism. But what I want to argue together with Helmi is that the shared administration works in two tracks. So one is the European one, and there we need, and in fact, only the Court of Justice is competent. But at the same time, we have national border guards, and nothing excludes that an action of refoulement is actually the consequence of the Italian-Greek border guards that works within a joint operation. So there I think that indeed domestic judicial remedies should play a complementary role and make sure that Article 47 on effective judicial protection is really applied. And I think that I can stop here.
Yeah, maybe just one reflection in general. What I heard was that multiple speakers said that the system wasn't designed for operational powers. And I think that's important to bear in mind constantly, that the treaties were designed and then the agencies kept evolving and getting more operational powers. So I think also that's important for how we conceptualize certain constitutional parameters like the Morality Doctrine or the principle of institutional balance, that we as academics come up and think of how we can apply it to the present day situations of agencies that actually perform actions on the ground and are not only taking decisions.
Thank you, Amandine and Steve, for your reflections and comments. I'll just maybe add to a couple because I don't think I had anything to contest, certainly. So yeah, the copyright issue is really interesting. I remember at State Watch, we very much appreciated the Solution Group's point about not imposing the copyright notice. I think they send it really inconsistently. So I know State Watch has written to them and said, we don't actually think that your documents are applicable to intellectual property, so we don't think this is appropriate. And they have stopped using the copyright notice when they do release documents to, I think it would be Yasha at State Watch who now makes them, because Chris can't because he's a UK citizen. But yeah, so they I think kind of by default they would issue that notice, but they don't if they, well, my perception is that it doesn't happen if they know it won't work. Yeah, and then on the refusal of requests that aren't specific enough, Frontex has also claimed to the Ombudsman in response to our complaint and other complaints that it works proactively with requesters to specify complaints. But I've certainly never seen that happen. And you have to kind of reopen an application on the portal to say, no, you shouldn't have closed that. You were meant to engage in discussion with me to reach a mutually agreeable specification. So yeah, lots of kind of procedural issues, which also, like, I think most people do find a friend or a contact in the EU to submit their access to documents requests, but it is really annoying. In short, like, it's just a very awkward procedure. You already have to have a contact who would do it for you in the first place. And yeah, I think I sort of went over kind of how it adds to the time. Time demands, the resource demands. So it's not an ideal solution, though it is a good way to get around things at the moment. Yeah. So yeah, I think I'll leave it there, but they were really interesting reflections. So thank you very much.
Thank you, for your questions. I haven't thought about the UK situation, so thank you. I will definitely think about it more. So my problem, like, I fully agree with you that the problem cannot be solved only judicially, especially when we just look maybe at criminal law. But the problem is that there are situations where those agents are immune for everything all the time, no matter what. It's not that there is a car accident when the border guard was going home. It covers everything, also when they are doing their job as a border guard. So I think that is highly problematic. But I fully agree that courts are not the only or even the best place to solve issues that pertain to the protection of migrants' rights. When it comes to the Operation Hera, thank you for the question. I think it's really a very good question. I was looking at the 2021-11 regulation, and actually it was legal, I think, because it was the regulation provided that Frontex could help the member states when they cooperate with third countries. So it was under that that Article 14. But then the question is it better now? There are people that say, yes, it's better because now we have status agreements, we know what's going on, and we have Frontex there, but do we really know what's going on? We don't have those fundamental rights assessment. So this is an open question. Thank you.
Well, contributing and responding. Is there any urgent question or comment from the floor? Is everyone anxious to have a break? Perhaps. Well, again, thank you, and that was a fantastic contribution. I'm looking forward to the rest of the day. Thanks.
Well, good morning. Thank you very much to be here. I'm Silvia Morgades Gil. I am Serra Hunter Associate Professor of Public International Law at Pompeu Fabra University here in Barcelona, 2 kilometers away. And I am very glad to be here because in the room that is on the other side of this wall, I started to learn law some years ago. So it's very, very glad to be here, and I'm very honored to be here. And thank you for inviting me, Violeta, Mirencho, and Laura. I will give the floor to our first speaker in the panel for conceptualizing shared responsibility. You already know Violeta Moreno Lax. She's a full professor of law and founding director of Border Center at Queen Mary University of London. And she's now Ramon y Cajal Professional Research Fellow at Universitat Barcelona, where she has led the shared project. She is the principal investigator. She has authored many contributions, and she's author of Accessing Asylum in Europe. Violeta, you have the floor. Thank you.
Thank you very much, Silvia, and thank you everyone online and here. I timed myself at home, it was 10 minutes. Let's see what I managed to do. I'm really sorry, but this is really work in progress. So, and this was supposed to be the first panel. So this was supposed to be like the theoretical background and so on, but because of scheduling issues and the fact that Joyce, who's joining us from the US, needed to be accommodated and sleep a little bit at her end, we decided to place it on this second part of the day. And anyway, here we are. I'm going to be speaking about shared responsibility and offering thoughts about a possible way of reinterpreting the notion in the form of what I have called integrated responsibility. So where I am coming from is the starting point that in EU law, we do not have a definition of what shared responsibility is. There are a number of factors that need to be taken into account when attempting to define what shared responsibility should be understood to be. There are overlapping perspectives between EU law and public international law that have something to say about what shared responsibility is when understood in terms of and in relation to the control of borders and access to territory. We then have a number of autonomous EU law produced elements that condition the manner in which shared responsibility should be understood. So for example, what is the link or the relationship between shared responsibility and shared competencies? Is this just like a coincidence in the terminology that is employed, or is there a legal relationship that determines the way in which the two should be articulated? And then you have a number of further complicating factors. The fact that Frontex powers, as we have been discussing throughout the 2 days, have exponentially increased without paying much attention to the Meroni principle or institutional balance or a number of other structural principles that should have been taken into account. So now the agency does a number of different things that to me are incompatible with a good faith understanding of balance of power, separation of power, or check and balances. The principle has different names. So if you are supporting and assisting, but you're also monitoring and overseeing, you become judge and party. You're doing two things that should be incompatible inter se. And then the principles of solidarity and loyal cooperation or sincere cooperation that have been reinforced under the Lisbon Treaty should be taken into account in any way we determine that shared responsibility should be understood. So how do you piece all of these different bits of the puzzle together? What I'm proposing, and it's still in the making. I mean, I need to flesh out this idea a bit more, so your feedback will be super helpful. I would propose that we put all of this together in a system that conceptualizes shared responsibility as integrated responsibility. So the beginning of the problem is that not only we don't have a definition of shared responsibility, but we also do not have a definition of cognate terms like primary responsibility or sole responsibility. These are concepts that are used in the Frontex regulation and elsewhere in EU legislation. So we know that Frontex shares responsibility for the implementation of IBM, Integrated Border Management, but then at the end of the day, moment of truth, member states shall retain primary responsibility for the management of their bits of the external border. Do we know what shared or primary mean in this context? No. And according to Amandine, this is done on purpose. So probably we're just like discussing about something that cannot really be solved. And if you look at what international law has to say about responsibility when it comes to the control of borders, international law appears to create a presumption that default responsibility belongs with states. The states are the only bodies under public international law which are plenipotentiaries that have sovereignty and that have exclusive jurisdiction for the control of their own territories and populations. So it might seem that then shared responsibility, however understood, should not really be on a 50-50 basis. Shared can be conceptualized in different ways. It doesn't need to mean or imply that you have a completely proportionate, balanced apportionment of responsibility. It could be indeed that the responsibility of states is primary, and then the responsibility of the international organization at hand, in this case, the EU and its organ Frontex, it's accessory or supplementary or supportive of that primary responsibility of the states. But this is not the end of the story. You also have the EU law dimension that comes to further complicate the picture, in the sense that we know that after the constitution of the Schengen area as an area without borders, there needed to be a transfer of controls from the internal frontiers to the external common borders of the European Union. And there are different bits and pieces in different points in the Schengen Borders Code, other parts of the Schengen Acquis and the Frontex regulation itself that says all of this should be done, not just for the interest of the member states individually understood, but for the common interest of all the member states of the European Union, and in full compliance with union law, including, therefore, founding principles, fundamental rights, etc. And then something that has already been mentioned in the previous panel, Frontex is supposed to remain fully responsible, so has full responsibility. That's another term. We have shared responsibility, primary responsibility, full responsibility, unaccountable for any decision that it takes and for any activity for which it is solely responsible. So there are all these adjectives added to the main term that have not been defined anywhere, and we need clarity. We don't need to reopen the regulation, I think, to obtain clarity. We just need a good faith effort at interpreting these terms in context and taking into consideration autonomous requirements imposed by EU primary law. One of those would be the relationship two shared competencies. Normally, competencies define areas of power that are conferred on the Union by the member states in the treaties. It's not very clear whether areas of responsibility accompany those areas of power that have been vested or that have been allocated to the European Union. If you think about, for example, asylum, there is a shared competence there, but what is understood to fall within the remit of power of the European Union is to come up with harmonized legislation to uniformize the field. But then when it comes to the obligation to provide physically, practically, refuge, temporary protection, subsidiary protection, that's not an obligation that falls directly on the European Union, it's an obligation that remains with the member states. So the relationship between shared competence and shared responsibility, I think it's there to be fully teased out. And it's not as straightforward as saying if there is competence, there is also responsibility. I think a proper understanding of the articulation between the two should avoid the opening of any accountability gaps. But whether there is a straight line between the two, I think is something to further unpack. Further complicating factors that I've already mentioned in passing are the fact that Frontex has been vested with executive powers, enforcement powers, including the power to use force at the external border, to carry weapons. Alexandra's presentation yesterday was very, very, very illustrative of the problems that this entails when these powers go unreined and without any checks and balances applied to them. There's a huge potential to infringe on not only fundamental rights, but good governance, effective remedies, judicial protection, guarantees, etc. The fact that then the agency has also been given the mandate to monitor compliance by the member states with IBM rules, I think is very problematic because it becomes judge and party. It coordinates the implementation of the same package of rules that it needs to oversee compliance with. So there is a bias to find compliance every time and to not be really eager to find deviations from those rules that it is itself mandated to help implement. So that generates problems in terms of independence, neutrality, checks and balances that go to the heart of the principles of justice, democracy, and the rule of law. So this is really no small problem. It's a structural design defect that it's not very easy to repair, but it can be repaired again without opening up the regulation. You could generate an external monitoring mechanism that sees the internal mechanisms that Frontex might have in place. And then the principles of solidarity and sincere cooperation need to be truly taken into account. Sincere cooperation has been typically understood in a vertical way to sort of make member states do stuff so that they do not preempt the European Union from fulfilling its objectives, but on a proper reading and paired with the principle of institutional balance, it also goes both ways, right? So the European Union should also behave loyally towards what is supposedly the EU common interest as interpreted in light of Article 2 and the rest of EU primary law, meaning in compliance with the principles of, again, justice, democracy, rule of law, and protection of fundamental rights. And in terms of solidarity, we know after the Lisbon Treaty that all policies of the Union in the areas of asylum, migration, and border management and their implementation needs to be governed by the principle of fair sharing of responsibility. So whatever our notion of shared responsibility, it needs to take into account the necessity of a shared apportionment of the duties that are entailed by the sharing of tasks, functions, and powers in this area. So the principle should take center stage in any distribution of tasks, powers, functions between the agency and the member states and be taken into consideration when collaboration is started with third parties, be it third countries, but also private entities like service providers in the security realm, but also shipping companies and including NGOs, right? When we discuss search and rescue at sea. And all of this needs to happen in good faith and bear in mind the funding values of the organization at all times, right? So if all of this is true, the solution is to connect all the bits and pieces together in a mechanism that I called integrated responsibility, taking into account the nature of the competencies, tasks, and functions of Frontex and those of the member states, taking into consideration the fact that the responsibilities of Frontex not only include executive and discretionary decision-making powers, but also monitoring responsibilities, and trying to confront the situation of non-transparent arrangements that have already been criticized earlier through the data protection angle, but also through the access to documents angle in the panels yesterday and today. If we recognize the character of intermeshed capacities between Frontex and the member states, we, I think, need an understanding of shared responsibility that integrates and takes into consideration all of this intermeshing that happens between the agency and the member states. It's not for nothing that we speak about integrated border management. So if we are serious about closing responsibility gaps, integrated border management should be matched by an integrated responsibility scheme that is capable of considering the implications of what happens on the ground. So the solution to comply with fundamental rights and the rule of law and the best to avoid this accountability and redress gaps that we are witnessing today, I think would be a scheme that combines elements of joint and several responsibility systems as articulated at national level in different legal fields, but also in the ARIO, for instance, that Mariana and Joyce are going to speak more about after me, and include elements of an objective responsibility system as we see in administrative law at the domestic level. And again, I think this can be done without reopening the regulation. I think there isn't really a need for more law. The legal basis already exists. If you look at Article 77 of the TFEU and Article 2 of the TEU, the EU legislator is under an obligation to adopt any measure necessary, any at all, right, for the establishment of an IBM system that is in line with the founding values and general principles of the organization, including fundamental rights. So there isn't any reason why Article 7 of the Frontex regulation should not be interpreted as entailing a presumption of integrated responsibility. It's a matter of good faith interpretation and a matter of being serious about the contextual systematic elements of EU primary law that in the hierarchy of sources should trump any conflicting views in terms of what happens at the level of secondary legislation, even more so in relation to implementation and practices on the ground. So that is my proposal. I look forward to your questions and comments, and I'm happy to pass the floor again to Sylvia. Thank you.
Thank you, Violeta. Now it's the turn of Joyce Deconi. She is adjunct professor of EU law, research fellow at the Center of Human Rights and Global Justice, and former Émile Noël fellow at NYU School of Law and postdoctoral FWO fellow at Ghent University in Belgium. She has authored recently the article Effective Remedies for Human Rights Violations in EU, Common Foreign and Security Policy and Common Security and Defense Policy, Military Missions, Smoke and Mirrors in Human Rights Adjudication. Hello. Joyce.
You can say next slide and I'll pass them.
Thank you so much. Good morning, everybody, and my apologies for the technical issues. I'm going to take a brief moment to join the chorus of congratulations and thanks to everybody involved in the shared project, the MEP support that we've received, but especially I'd like to thank Violetta and Laura for their tireless efforts and accommodating all of us and making this final conference possible. It's an honor and a privilege to be here with you today and to discuss a very topical issue. As you may have noticed from in the title and my paper, I, much like the panelists in this current panel, take a more theoretical approach to the question of shared responsibility. And I try in my paper to tie together many of the critiques and the shortcomings that we have heard discussed within the context of this conference today and yesterday. Next, please. In discussing or in advancing rather, the argument that I make in my paper, which I refer to as relational human rights responsibility, I rely on the cooperation between Frontex, the EU member states, and Hawkeye 360 as an illustration of what I call transnational cooperative governance. Transnational cooperative governance refers to a mode of cooperation where you have member states working together with international organizations or entities of international organizations, as well as private transnational corporations. Now, what is Hawkeye 360? As some of you may have heard me speak about this already, it's a US-based company that is a front runner in commercial satellite imaging. And what does that mean? It means that through its satellite clusters, it provides its clients with a continuous flow of data and satellite imaging, enhancing situational awareness. And one of the clients notably is Frontex, which means that in concreto, what happened throughout the short-lived nature of this cooperation between Frontex and Hawkeye 360 is that Hawkeye 360 on a continuous daily basis, 4 times per day, would provide Frontex with geospatial imaging and location data of the Mediterranean. This means that concretely situational awareness of the Mediterranean was significantly enhanced for Frontex and the member states. And in line with the trends that we saw as discussed during this conference, in line with the trends with what we saw in Operation Sophia and Operation Irini, location data are being used to facilitate push and pullbacks of individuals in the Mediterranean back to Libyan territory. And this without Frontex and the member states physically being implicated. So to put it differently, through this location data, which is shared with the Libyan Coast Guard, individuals are being pushed and pulled back into Libya, albeit without Frontex or the member states being in physical proximity of individual third country nationals. Now, next, please. 2 slides, actually. Thank you. Next. What this means is that clearly that there are human rights harms, namely these individuals are being returned to Libya where they are at risk of having violations of non-refoulement, be established, right to asylum, right to an effective remedy, etc. And mindful of these human rights harms stemming from the use of these technologies and the transmission of location data, the question obviously arises to which extent or who could be held responsible for these human rights harms. In concreto, we have 3 implicated actors in addition to Libya, namely Hawkeye 360, this US-based company that's responsible for the transmission of location data. We have Frontex and we have the EU member states. And this is where I get to in my paper. Next, please. When assessing this mode of cooperation, 4 misalignment clusters appear. So 4 clusters of issues appear. And what do I mean by misalignment? I mean misalignment in the sense that we have, on the one hand, a legal regime of human rights responsibility as developed under EU law, which is not aligned with factual realities. And these misalignment clusters, they feature on 4 different levels, which I'll touch upon briefly in turn. Firstly, there is normative misalignment, which points to the fact that while we have a Charter of Fundamental Rights, this Charter of Fundamental Rights, which indirectly and directly binds these 3 complicit actors, was never designed or legally designed with joint interdependent conduct of state and non-state actors in mind. So in concreto, the charter was not designed with the intention of regulating forms of transnational cooperative governance involving both member states, the EU or Frontex rather, and transnational corporations. This means what we see is that we have a set of abstract human rights commitments or fundamental rights commitments in the charter, but that these have yet to be translated in justiciable rights that can be invoked by third country nationals in trying to see those rights safeguarded. So while we have a very rich line of jurisprudence on member state responsibility with respect to fundamental rights, this rich line of jurisprudence has yet to be developed with respect to how these abstract human rights commitments relate to non-state actors. So concretely, we don't actually know how, for example, the non-refoulement principle relates to Frontex and private companies in terms of the negative and the positive procedural and substantive obligations that these abstract human rights commitments give rise to. We see developments in this direction in the Frontex regulation, but the point of this normative misalignment is that we are missing a holistic approach to how abstract human rights commitments relate to non-state actors such as Frontex and private corporations. Next, there is liability misalignment in the sense that we have a liability mechanism, but it is also not legally designed in order to accommodate forms of joint interdependent conduct. And I'll just focus for the purpose of today's presentation on the notion of attribution. Some of you will have seen me discuss this extensively, but in short, there are across international, regional, and domestic regimes, at least 6 identifiable or discernible attribution tests, which have strict variations and broad variations, and there is no definitive parameter which decides that sets or decides rather which test of attribution should be used in a given case. And I mean, the WS and others, the Frontex case has been named a number of times in the last 2 days, but here you see explicitly that the absence of a definitive rule on which attribution tests should apply is precisely what allows for Frontex to escape responsibility. So imagine, for example, as one of the presentations earlier today goes to the point of member state responsibility before domestic courts and how that could be a potential avenue. But here you would see that while a member state court could apply, say, the ultimate normative control test on attribution, it's very likely that in a concurrent or a subsequent proceeding before the CJEU, an alternative attribution test could be used. And the different use of these attribution tests could have as a result that neither the member states or Frontex could be held responsible. So the liability misalignment that I'm alluding to here is that we have all these different tests without a definitive parameter on which test applies, as a result of which courts on a domestic level, as well as on a regional and an international level, can choose haphazardly which test applies to the detriment of access to an effective remedy. In addition to liability misalignment, we see forum misalignment, and this goes to the very essence of the fact that the liability regime under EU law was never designed to deal with joint liability or joint conduct rather of member states in concert with private corporations and the EU. And so very concretely, you see that we have member state procedures and we have CJEU procedures to assess liability, but they assess liability independently of each other, as a result of which the focal point is not the right to an effective remedy, but rather determining whether these separate actors could incur responsibility. And finally, there's actor misalignment. What we see in the regulation that exists, but in secondary legislation of the EU more generally, we have all sorts of developments that go to the liability of private corporations. We have developments within the realm of Frontex and how Frontex could incur human rights responsibility. And we have this rich line of jurisprudence concerning human rights responsibility for states, but nowhere do we have a holistic approach to responsibility for human rights violations as a result of the joint conduct of these 3 actors working together. Next, please. Next slide, please. Thank you. So what we can draw from, back one. What we can draw from these clusters of misalignment is that there's two overarching conclusions to be drawn. We have, on the one hand, legal design issues that relate to human rights governance or fundamental rights governance, and we have legal design issues that relate to fundamental rights or human rights liability. Next slide, please. And so on the human rights governance side, what we see is that the EU lacks a human rights governance approach, which normatively looks at how these charter commitments translate to justiciable fundamental rights provisions for the EU and private transnational companies. And from a normative perspective, we see that there are no distinctions being drawn between, and this is goes to the presentation by Violeta, there's no distinction being drawn between primary violations, mindful of the typology of fundamental rights and the typology of fundamental rights obligations, and there's no distinction with respect to secondary violations. And this goes to a presentation from yesterday, namely concerning shared responsibility and how aid and assistance and direction and control and coercion plays into the question of responsibility for joint conduct. And on the second level, with respect to the liability legal design shortcomings, as mentioned, we have all these attribution tests. We have no set standard as to which attribution test applies in which case, following which courts are left to their own devices in terms of figuring out or deciding which attribution test will apply in a given case, to the detriment of the right to an effective remedy. Same thing with the causation test, same thing with the forum. And then there's not even, we haven't even spoken about how reparations are to be allocated between the different actors that are complicit in joint operations of this sort. So in the second part of my paper, next slide, please, I use these four misalignment clusters to inform, and these two legal design conclusions to inform this theory of relational human rights responsibility. And this theory of relational human rights responsibility demands that we develop on an EU level at least a sectoral approach to fundamental rights governance, and that we revisit the rules on liability and reparations. And I agree wholeheartedly with Violeta that this does not require revisiting the Frontex regulation as such, but I would, without developing the relation to human rights responsibility theory too much in detail, I would urge the court, insofar that I can, to further tease out and articulate this idea of joint and several liability, which is at stake not only in the WS and others, the Frontex case, implicitly in the upcoming Hamoudi case, but also in the Marian Kochner case concerning Europol, where the very same questions of attribution, unlawful conduct, and causation are at stake. And interestingly, within the context of this joint and several liability regime offered by the Europol regulation, from which we can draw inspiration, what you see is that a number of these issues that we've discussed in the last 2 days are actually dealt with, and the question of reparations is dealt with in a subsequent procedure within the context of the Europol Management Board. So one could envisage a joint and several liability regime with respect to Frontex, where it's the access to an effective remedy is facilitated for the individual third country national, and subsequent allocation of responsibility burdens, and more specifically reparation burdens, are dealt with behind closed doors within the Frontex Management Board. I look forward to all of your questions and your objections and critiques, and I hope to develop this theory further. Thank you.
Thank you, Joyce. Now is the turn for Mariana Gliardi. Sorry for pronunciation. She's assistant professor on migration and asylum law at Tilburg University. She specializes in border management and mobility control, accountability for human rights violations, and accountability for non-state actors. She is author of many articles and chapters, and also of the book Systemic Accountability of the European Borders and Coast Guard, the legal responsibility of Frontex for human rights violations, published in 2021. Thank you, Mariana. You have the floor.
Thank you. Thank you very much. Just to check if the hosts have received my PowerPoint. Yes?
Yes.
Okay, perfect. Thank you. As a first disclaimer, I have to say, I think you can already hear it. I have been sick for the last couple of days, and I had to cancel my trip. I'm very sorry that I cannot be with you today. But I'll do my best now. I cannot promise that I will be sharp. I'm still boiling with fever, but I'll do my best. So thank you all for organizing this conference. It is a great honor to participate in this very important project. And I have to say that it is one of the projects that is really trying to build something step by step. And I'm very, very happy and honored to be part of it. So demystifying shared responsibility. I decided for this contribution to embark on a quite challenging endeavor, and I decided to look into the true meaning and implementation of shared responsibility in the multi-actor reality of the external borders. In other words, I wish to answer the question, is our present understanding of responsibility and its application adequate to attribute responsibility for harm done in Frontex joint operations, and how can it be improved? Now, in the next 10 minutes, I will state the problem with which you're all too familiar. I will present key elements of the conceptual solution I have developed already during my PhD years. For those that are not familiar with my work, my PhD was on the systemic accountability and the responsibility of the European Border and Coast Guard. And I also have developed for this presentation, attempted its practical implementation via some concrete recommendations. I have to say, you may have noticed already from the other steps of this procedure that there is a certain alignment in the conceptualization that Joyce, Violetta, and I am presenting. And this happened in a completely autonomous and independent manner, and from completely different premises, and still focusing on different things and different aspects of the conceptualization. We're still coming down to the same rough lines, the same concepts, the same problematization, and very similar recommendations, which makes me think there may be something into it. So that is encouraging. And I will start from the problem. Next slide, please. Thank you. If we apply the international rules on responsibility, we promptly conclude that Frontex can incur legal responsibility indirectly for aiding and assisting in a violation. Violetta already hinted on that. And that can be done either by action or by omission. And it can also incur responsibility directly for conduct of its statutory staff or conduct of other members of teams over which and to the extent that it has effective control over them, because effective control is not a binary, does not get a binary answer, yes or no, but we can talk about the scope and the extent and the degree of effective control that one exercises. Now, at the same time, host member states or third states and participating states may also be responsible for a violation either on their own right or in relation to the violation of another actor. Now, none of the actors may deny their responsibility on the ground of the responsibility of another actor. That we know, of course, from the Bosphorus case of the European Court of Human Rights. Now, this creates a complex picture regarding responsibility that has been conceptualized by the political philosopher Dennis Thompson as the problem of many hands. Now, this problem describes the difficulty of pinpointing responsibility in cases where multiple actors are involved. And this can essentially function as a wall behind which actors may hide their own contribution and shift the blame to others. This may remind you of what Joyce called the transnational cooperative governance. This is a very good example where the problem of many hands occurs. Next slide, please. Excuse me. Now, as the solution to the problem of many hands, and again, I take you back to what Joyce said about the lack of a holistic approach. Now, as a solution to this problem, and having built on the conceptualizations of Mark Bovens and HLA Hart, I propose the nexus theory. Now, this theory suggests that the problem can be solved if we look at responsibility not as a linear relationship between the conduct of an actor and the harmful result, but as a nexus. And this is the best way I could visualize it for myself. Instead of looking at establishing the responsibility for each actor separately, following this linear relationship, so from the actor to the harmful result to the damage to the allocation of responsibility, we address all the responsible actors as a collective. Now, in the nexus, all different responsibilities meet and interact to produce a harmful result. Therefore, the responsibility, like the outcome, is a collective one. Now, next slide, please. This theoretical construction of the nexus helps shape our understanding of responsibility in many hands situations. Now, according to the nexus theory, when the problem of many hands arises, not one actor is entirely and independently responsible for the outcome, which outcome is rather the collective result of the interlinked responsibilities that take place. It is in the nexus that the separate responsibilities meet and interact through the cooperation of the different actors. And only when the responsibilities meet can the harmful result occur. Next slide, please. Now, to transfer it to the practice of courts and policymaking, we can transpose the nexus theory into the normative framework as joint and shared responsibility. Now, since no single actor is entirely and independently responsible for the outcome, the actors should be ideally jointly responsible. If we look at EU law, and since we're talking about an EU agency, we first need to look at the normative foundations of joint responsibility in EU law. The treaties themselves do not contain any secondary rules on joint responsibility of the EU and its member states. It's this vagueness that Violeta was talking about. However, joint responsibility is not foreign to EU law. The Court of Justice has dealt with joint responsibility under mixed agreements, stating that in the absence of derogations to the opposite, the EU and its member states are jointly liable for the fulfillment of their obligations towards third states. Now, this is contractual liability. This practice, however, does not give us enough evidence to predict what the Court of Justice will say if it will treat that as a general rule and afford the same solution to non-contractual liability. And the latest evidence we have from the action for damages against Frontex is not very encouraging. Now, the scarce attempts of the Court of Justice to deal with non-contractual liability of both the EU and its member states, even before the latest Frontex case, have been inadequate, to say the least, ignoring the liability of the EU and resulting in decades-long procedures for the applicants. We have the Kampfmeyer jurisprudence, which is based on the implicit assumption that the national authorities are primarily liable, with the EU only incurring subsidiary liability. This is still a step further than the court came to in this latest judgment, where they just ignored any idea of subsidiary liability. So it makes the jurisprudence that we have so far, the case law that we have so far, it makes the liability of the EU secondary. In practice, it is not addressed. Now, rejecting the possibility for the EU and its member states to be jointly liable for the damage under the same forum, that is, right? Now, this essentially results in blame shifting and substantial accountability gaps. The concept of shared responsibility is also found in Article 7. We heard extensive analysis of it from Violeta. Despite its promising title, shared responsibility, the article is not specific about attribution of responsibility. And we can thus conclude that even though joint responsibility is not foreign to EU law, the EU legal framework does not provide us with stable answers as to its exact content. Therefore, we may turn for guidance to the relevant international law. And our guidance there, of course, is provided by the ILC draft articles on the responsibility of international organizations and the articles on the responsibilities of states. Now, through applying the relevant rules, and I already mentioned in the beginning, it may prove quite common that more than one actor, be it a member state or international organization, is responsible for the same wrongful act. This can be the result of double or multiple attribution of the same act to several actors, or it can be that several rules of attribution apply simultaneously. For instance, direct responsibility of one actor and indirect responsibility of another for aiding and assisting, which is the most common scenario in Frontex joint operations. Now, therefore, according to the UN Special Rapporteur on the responsibility of international organizations, if an internationally wrongful act can be attributed to one or more states or international organizations, the actors involved are jointly responsible. Now, the parallel responsibility of more subjects of international law is covered under Article 48, paragraph 1. And I know that I have only superficially touched upon these rules and their relation with the nexus theory, but I have to move on to the application, discussing, thank you, some specific recommendations for its implementation. So, how can we implement the nexus theory? And these are just some ideas. I focus here on the recommendations, on some of these recommendations that are related to the European Border and Coast Guard regulation. Firstly, I look at the scope of Article 340, paragraph 2 on the non-contractual liability of the agency, which needs to be interpreted as extended to not only cover damages caused directly by the agency or its servants in the performance of these duties. This is what the court did in the latest judgment, but also include liability resulting from aid and assistance and damages occurring outside the performance of formal competences. It's de facto powers. Now, in an ideal world, this would be done explicitly in the legislation, but it's not necessary. It can be a matter of interpretation. Now, the concept of shared responsibility, I'll come to my second recommendation, as I said, is found in Article 7, paragraph 1. Now, despite its promising title, as I said before, the article is not specific. So this article should be implemented to add a clear distinction, or I should say clear direction, rather, on the implementation of shared responsibility that is in line with the International Law Commission articles on the responsibility of states and international organizations. So an in compliance interpretation with the international framework. And this could include rules determining the ex ante attribution of responsibility and a presumption, a rebuttable presumption, that the different actors in joint operations shall be jointly responsible unless the exclusive responsibility of one party can be proven. And this is the part of the rebuttable presumption. So my suggestion is that we work on a basis of joint responsibility. This would be the presumption, and only exceptionally move from it if actors can prove that there is exclusive responsibility. So I come to the third point, the third recommendation. It is also pertinent to introduce due diligence procedures for the activation of Article 46. And this is something that we have been talking for years. Even the previous executive director of Frontex has been pushed towards this direction. We still need to see concrete and applicable due diligence procedures, effective ones, concerning suspending and terminating operations in case of serious and persisting violations. Again, in an ideal world, this would happen in the regulation itself. However, political observations, political considerations suggest that if we touch Article 46, things might get worse. So we may choose, or the legislators may choose to not do so. And finally, we may never have a complete and holistic picture of accountability. We're talking about a holistic system if we do not improve and combine the non-judicial forms of accountability. And this includes primarily following the recommendations of the Frontex Scrutiny Working Group, which are not yet fully implemented, introducing necessary amendments to the regulation to ensure the follow-up of individual complaints by the EU Ombudsman and the review by the court, strengthening the role of the Fundamental Rights Officer in practice with concrete commitments as to the resources and operational capacity of his office, setting up a robust system of external monitoring involving the European Parliament, the EU Ombudsman, the CPT, and national human rights institutions and ombudspersons. And these are just some of the ideas, but I really want us to reflect on the recent recent example of the collaboration of all these supervision and monitoring mechanisms and all these non-judicial accountability mechanisms and the success they have had so far in essentially leading to the resignation of the executive director. But this is just, we're not just talking about one person. They have led to a complete rethinking of the role of Frontex and the attention we give to the agency. I mean, it is quite telling that when I started my PhD, I had to start every presentation with explaining what Frontex is, and now we're holding this conference. So thank you very much, and looking forward to the discussion.
Thank you, Mariana. Now it's time for comments made by Thomas Molnar, our stakeholder. He's legal research officer in the EU Fundamental Rights Agency. He worked in various ministries in Hungary in the field of international and EU migration law. He has also been a part-time adjunct professor of international and EU law at Corvinus University of Budapest. He has published widely and is author of the monograph, The Interplay Between the EU's Return Acquis and International Law. Thank you, Thomas.
Many thanks, Madam Chair, dear Silvia, for passing me the floor. Good afternoon, everyone. First of all, let me express my gratitude for the organizers for having pulled together this wonderful initiative called Shared Project, and in particular this final conference here in charming and beautiful and inspiring Barcelona. So it's a very nice location. I think the Genius Lotzi is with us to elevate our minds and to engage in very thought-provoking discussions. Having said that, and still inspired by the insightful and rich papers of the three authors, let me formulate some reflections on the current issues or some of the issues they put out, which are clustered into 7 points. I hope I'll make the 7 points, given that we are a bit running behind the schedule and I want to stick to the time frame. First, to start with a prelude, it's like legal quantification. We have this famous term, shared responsibility, which is used 4 times in the Frontex regulation or EBCH regulation, next to the ban on Article 7. 3 recitals also refer to that, but it's also there implicitly elsewhere in the text of the regulation. For instance, in the return context, Article 50 stipulates that the participating member states and the agency shall ensure that the respect for fundamental rights, principle of proportionate use of means of constraint, and the dignity of the returnee are guaranteed during the entire return operation. So it's another way, and we'll find other examples for this implicit, a bit more hidden formulations of shared responsibility without the express term. And this example also shows that this notion, whatever it means and covers, shared responsibility is also linked to fundamental rights, not just operational powers, but it's something that both actors, the member states and Frontex, must also do in the fundamental rights protection and promotion. Thanks. And regarding the other term, primary responsibility of member states to manage their external borders, this primary responsibility is used twice. and yeah, so that's what we have if we quantify, and of course it's not enough. As the three authors have rightly pointed out. Issue number 2, getting the legal dogmatics and terminology right. So against this background, what does shared responsibility mean in this context? I mean, for me, it's like a shapeshifter notion, which is of course very poorly codified or drafted, and that's why it found a way, and we know now the sausage making process, and that was some sort of a constructive ambiguity on behalf of the co-legislators to use that. But I conceive it rather in the meaning of competence, duty, or obligation, shared competence, shared duty, shared obligations, than in the context of consequences of breaches of obligations or because of wrongdoing. So when I see this term as positive law term in the text, it's like it refers to primary rules, meaning related to substantive obligations of different actors, and not secondary rules in HLA hard terms. So in my understanding, which echoes the established legal terminology, responsibility is assigning blame for causing harm. This is the realm of secondary rules. The way the regulation uses, it's not in this meaning of secondary norms, but it's like, again, shared duty, obligation, or power to act. So this is something to be clarified, and the joint guidelines also call for that. And even if, I mean, it means this shared duty, obligation, power to act, this term also serve as a proxy or mirror, since the shared and intertwined nature of member states and Frontex border management duties equally translate into shared / joint or other non-individual, so some collective forms of responsibility in case of breaches of the law. To what extent these, let's say, match fully, it's another question. But I think we can use shared responsibility to inform our thinking about other collective or joint forms of responsibility. And seen in light of member states' primary responsibility, shared responsibility most likely doesn't mean 50-50 percentage, but less on Frontex side. But the dividing lines are blurred. But what is then Frontex shared in this constellation? Can be quantified like 20%, 30%, or can we just define that, or does it really matter at all? Questions. Number 3, taking primary rules seriously. I mean under that the following: that as a prerequisite of going into the questions of responsibility, so in the meaning of secondary rules, what follows in case of breach. The point of departure or the preliminary question is to identify and define the precise contours and content of Frontex human rights obligations. And this resonates to Joyce's claim that, I mean, sometimes we take it a bit light. Yeah, fundamental rights apply to all actors, member states, and Frontex, but I think she has got a very valid point in saying that positive obligations and negative obligations might apply a bit differently vis-a-vis non-state actors than states. Is by nature that EU as an unidentified political object, sui generis entity, is different from states. So I think we should, as lawyers, know from the outset what are the exact primary obligations on Frontex. What are the fundamental rights as primary norms, the breach of which then incurs Frontex responsibility as an entity of an international organization called the EU. So what is non-refoulement, for instance, right to asylum, and right to leave in these discussions? Maybe yesterday was also discussion on that, but I think this is something that we should also put into the mix, not just non-refoulement, or prohibition of torture, other forms of treatment. So we should first identify these, and once they are applicable, then we can move to responsibility issues. And number 4, and this is now responsibility, the power of international law, the power of the articles of responsible international organizations, and articles of state responsibility. I fully agree with all 3 orders that the EU's responsibility for violations attributed to Frontex needs to be studied also within the framework of these 2 draft articles. Borrowing Mariana's words, integrating both EU and international law approaches within a common environment is needed to unveil schemes of possible responsibility and to avoid fragmentation and to allow complementarity and cross-fertilization. And taking this purely public international law angle, it's also important we can't spare this exercise of specifically focus on the applicability of these two sets of draft articles to human rights violations. Since seen as a public international lawyer, the underlying logic of the draft articles is a bit different. The injured party is usually a state or international organization, whereas here it's an individual. And also there are some other structural differences vis-a-vis international rights law to the rest of public international law, which should be factored in. And I do believe, and this is the communist opinion, that these two draft articles do apply to human rights violations, but this should be made explicit. So in the arguments, I think it shouldn't be just implied, but to have rigorous legal argumentation, it should be made clear. So against this backdrop, do we need a completely new set of legal concepts or doctrines to hold member states and Frontex responsible when they act in concert in joint operations? I think public international law already offers a sophisticated and detailed enough legal conceptual framework for allocating and invoking responsibility of states and international organizations. So this can be used as a point of departure. Just think of joint responsibility, which has been discussed by the authors, and it implies at least it does not prevent joint and several responsibility, which would be, of course, the desired way forward, but also indirect forms of responsibility, like derivative forms and complicity, including aiding and assistance. And when it comes to aid and assistance, what is a bit, I think, forgotten is that there's an aggravated form of complicity in both sets of draft articles. Since in case of violations of peremptory norms of international laws, so-called usefulness norms, where, for instance, prohibition of torture belongs to, no state or international organization can render aid or assistance in maintaining that situation. So it's when we look into the draft articles, it's not just the well-known articles around 14, 15, 16 articles, these articles, but the aggravated form of responsibility also is also relevant in this regard. Just think of cooperation with Libya. So I think it's an extra argument to say that if you share information with Libya where these use commerce violations take place, you also trigger this aggravated form of responsibility under Article 42 of ARIO and Article 41 of ARCIBA. I'm just taking it away. So I cut a bit shorter. Next to the ARIO and ARCIBA, some special treaty regimes and their special responsibility schemes under international law can also be used as a source of inspiration. And I also found a reference to that in a footnote of Mariana's piece. This is the UN Convention, for instance, on the law of the sea, UNCLOS, which has an Annex 9 regulating the participation of international organizations in UNCLOS, which also addresses questions of responsibility. So in case of an international organization, when the member states and the international organization itself do not communicate clearly the division of competences between them, the injured party under UNCLOS can sue them both or all, and it triggers joint and several responsibility of both the organization and the member states. And given that the EU is part of the UNCLOS, then this already applies. So in the law of the sea, we have a concrete existing public international law special regime where joint and several responsibility applies to the EU. And beyond ARIO and these lex specialis international legal responsibility regimes, another intellectual source of inspiration is the guiding principles on shared responsibility in international law, which is, of course, an academic exercise, but it provides guidance on these questions of shared responsibility of states and organizations for their contribution to an indivisible injury to third parties. So here, there's an extra element of when there's this indivisibility. And I think the next theory and other concepts speak to that. You can't, I would say, disentangle the different strands of responsibility, but should be taken as a collective one. And the guiding principles refer expressly to migration. So this is something you might also want to study. Number 5, this is even less than 4. What are the avenues to build up and further develop joint or shared responsibility in EU law? And now I refer to this term in the meaning of liability. I mean, what Mariana offers regarding joint responsibility of member states and the EU under mixed agreements is an avenue which is worth further exploring, especially in the context of Frontex status agreements with third countries, where both Frontex and member states are duty bearers vis-a-vis the third contracting party. So perhaps this is something that can be inspirational. And the question, what role for the CJ-EU case law on joint liability of EU and member states for non-contractual damages in shaping or informing the concept of shared responsibility for management? I mean, criticism was quite clear about the scarce case law, the not really convincing way the EU court has been shaping so far joint EU liability. But there's something. So this is just the question whether this direction, this case law, should be developed or more, let's say, effort should be made in this direction. We also know that the action for damages was not originally conceived as a human rights remedy. So some scholars, of course, say that it's limited. It's let's say, reach and relevance is limited, and we've seen this very strict and rigid interpretation the General Court took in WS and others, although it can be subject to an appeal. We'll see whether the lawyers will take this step. And there's another pending case referred to by others, it's Hamoudi and others versus Frontex, where the cas de figure, the scenario is different, and I think it's even more promising. It's not a return operation, but pushback at the agency, where Frontex, I think, was closer to the acts and it's more intertwined with member states' action. We'll see, but it presents an opportunity. And another avenue, what about the preliminary questions? As far as I know, no national court whatsoever has ever turned to the Luxembourg court for a preliminary plea, which is quite strange in this milieu. Take the example of the return directive. It has been subject to more than 30 rulings by the EU Court of Justice. Most of the rulings have been triggered by preliminary questions by national courts. But for the Frontex regulation, which is really bulky, lengthy, it's a labyrinth. No. So maybe this is also for us to push national judges or to create a conducive environment for them to empower to go for such questions. Okay, I will stop with the 6th point, which is the last one, the elephant in the room, how to enforce and adjudicate these responsibility claims before which international, regional, or national judicial fora. One form can be using parallel avenues, and that was the case with WS and others, where applicants directed against Frontex before the EU court, but at the same time, the same applicants sued Greece before the European Court of Human Rights, and there's still a pending case, the SAA and others versus Greece, and we'll see perhaps via this channel applicants will get redress. Then what opportunities the EU accession to the ECHR will offer, since I think this should be discussed more in depth, the future ECHR accession by the EU and the use of the correspondent mechanism, which allows for joint responsibility of the EU and member states. True, this is a voluntary scheme, and that's been also criticized, but suing jointly the EU and member state before the ECHR remains still an option. So the applicant can sue as many contracting parties as he or she wants. So it is to be further explored, although the important limitation that it only kicks in after the exhaustion of domestic remedies, including law. Then what about UN treaty monitoring bodies? It might sound blasphemy. Hey, this guy is stupid. I mean, UN monitoring bodies can't examine the actions of international organizations, but it's a question of strategic litigation, how you present the case. And given that UN monitoring bodies are more flexible and prone to legal creativity, perhaps they can just hint on passant something on the responsibility of the cooperating Frontex staff or the agency, even in cases where you try to sue a member state. So I wouldn't leave it out of the mix. So I stop here. Maybe one last point from number 7, change the law. I fully agree with the recommendations by Mariana. One more thing is to give effect to Article 263, Paragraph 5 regarding action for annulment. What's this Paragraph 5 about? It's an authorization, meaning that founding regulations of EU agencies may lay down specific conditions and arrangements concerning actions by private parties against agencies' legal acts. So it will not require changing primary law, only Frontex regulation, to expand individuals' local standing by activating this authorization in the relevant treaty provision. Thanks for your attention. Sorry for using the time.
Thank you very much, Tamas. I'm sure that all the presenters have reactions to these comments. I will only, I'm going only to add 2 comments or questions that are common for all of the presentations, and I will give the floor in order to react to these questions and comments. First of all, I want to remind that last 13 September, President of the Commission said in the State of the Union discourse the following: with the pact, we are striking a new balance between protecting borders and protecting people, between sovereignty and solidarity, between security and humanity. I was wondering, what do you think on where we are now, on the side of sovereignty or on the side of solidarity? We are facing now a move towards, I don't know, perhaps solidarity, towards sovereignty. We have always been on one of these sides, and we are facing now a move, a shift towards the other side. And the second comment, or it's kind of a provocative question, but I think it's something that we need to think about this. All of the presentations have stressed the consequences of a multiplicity of actors in blurring responsibility in border control or management, border management, and place the stress on the individual. But do you think that third country nationals are subjects of EU law when they become subjects in the post-Hirsi area? And in case of remote control, what is the connection link between them and EU law? Because perhaps we do not have effective control, we do not have territoriality, so we need also to stress this connection link with EU law and EU law regarding fundamental rights. I give the floor to the presenter in the order that they have spoken. First, Violeta, thank you.
Thank you. In the interest of time, I'm going to be very brief. So, Tamas, thanks a lot for a very rich set of comments. I'm going to ask you for your notes, if you don't mind. I took my own, but I think yours are going to be much more comprehensive. On the point regarding aggravated aid and assistance, I think that's a very nice avenue that I personally did not think about in terms of the possibility of engaging Frontex responsibility. I mean, together with Maria Julia Giuffre, we discussed this in a paper some time ago on contactless forms of control, and mentioned that the sort of approach that the Court of Justice, the International Court of Justice in the genocide case has, where they make clear precisely these points, but we were thinking about applying it to Italy because we were exploring forms of cooperation between Italy and Libya. But there's no principled reason why you couldn't apply the same thing to an organ of an international organization, considering the primacy of Jus Cogens rules above everything and anything. So that's, I think, an avenue to explore. I'm not sure how UN monitoring bodies would react to a potential filing of a case that would target Frontex. I mean, a different thing would be if you would target the multiplicity of actors involved and exactly. No, I mean, maybe if the case was filed against member states, cum Libya or Tunisia, you know, I mean, those having ratified the ICCPR, for example, or the CAT, perhaps, you know, as an afterthought in an obiter, you could have the CAT committee or the Human Rights Committee saying something about assistance provided by the European Union and Frontex. So, I mean, it's an avenue worth maybe exploring. And on Sylvia's point about the connection to European law in extraterritorial situations where there isn't really a territorial bond between those affected by the action and EU rules. I mean, again, my perspective on this might not be widely shared, at least not by the Commission, the Member States, or the Court of Justice, but I think it's still reasonable in the sense that the EU, it's not a state, so territorial constructs about responsibility should not be transposed to how we think about the fundamental rights obligations of an international organization. The Charter of Fundamental Rights requires simply that EU law governs a specific situation. And obviously Frontex as an organ of the EU either acts under EU law, and then the Charter of Fundamental Rights obligations would follow and track that action, or it doesn't have power. And if it still chooses to act, it will be ultra vires, right? But I don't think there is any intermediary position for Frontex or the European Union to act outside what is required by the whole of EU law. And the Charter of Fundamental Rights is primary law, so it cannot really be eliminated from the picture, not even through status agreements and immunities and all the rest of it. Those are still subjected to the primacy of the treaties and the Charter. Steve here has written about this as well quite a bit. So if you want to know more about this position that we share, then maybe during the pause. But I don't think we can transpose territoriality paradigms that apply to, say, Article 1 of the ECHR according to Strasbourg, which I don't think, I mean, anyway, we can discuss this more, but it cannot be transposed to the European Union just like that. And Article 51 of the Charter would require applicability of fundamental rights anywhere that is the EU would act through its organs and agents, and any situation governed by EU law would require governance of the Charter of Fundamental Rights principles and provisions. And I'll leave it here.
Thank you. Joyce, do you have something to say? You want to react?
Yes. Thank you for the indeed very rich comments. I fully endorse pretty much all the comments by Tomasz. And if anything, I just want to tease out or nuance a little bit one of the comments made. The questions that seem to be arising within the context of this conference in the 2 days that we've had together go to the heart of how we should allocate, right? And this point made of 50-50 allocation between the EU member states and Frontex. I'd like to push here a little bit and go a little bit deeper and use the distinction made by Violetta in her work between primary and secondary obligations of fundamental rights. And here, this, I think, crucial would be here to make the distinction between a primary norm violation of non-refoulement, let's say, and that be attributed to the member states, and then acknowledge, mindful of the functional speciality of Frontex, that, for example, rather than a 50-50%, Frontex would be held responsible for aid and assistance or direction and control or coercion even, so that it doesn't become a question of they share 50-50 in terms of primary responsibility, but instead we start thinking about it in terms of what I, again, would like to note as relational responsibility, namely the interaction between the two and how those interactions result in a single rights harm. if that makes any sense. I completely endorse the comments about a strategic litigation. I don't think the WS and others v. Frontex case should deter anybody from continuing, both with respect to the action for damages, and I completely endorse the idea that preliminary references could be a very interesting way forward in forcing the court quite literally to express itself on joint liability and joint and several liability. Because I think if we look at WS and others v. Frontex, especially in that case, what happened there to me seems to be that the general court just didn't want to pronounce itself on questions of joint responsibility. It very adeptly evaded the question by focusing instead on connecting acts that had nothing to do with Frontex. And then with respect to EU accession, I mean, I delve into this extensively in my PhD, and I'm hopeful that, you know, the monograph, if it ever happens, will address this as well. But I think EU accession indeed would be a very, very fruitful path to discuss and develop these notions of joint responsibility. In terms of the striking the right balance, I'm going to be critical, and I hope I don't see who's in the room, so I'm not sure how outspoken I can be. I think the striking the right balance between sovereignty on the one hand and solidarity on the other hand is a smokescreen. I don't think that it's either or. I think, if anything, we're just focusing more and more on externalization, securitization, to the detriment of solidarity, and to the detriment of solidarity, and sovereignty is not even necessarily a thing that comes into play anymore. And then finally, on the question of TCNs or third country nationals being subject to the EU law, and this question of extraterritorial jurisdiction, Violeta, you know, she developed it extremely well. And I think very simplistically put, the difference between the Charter and the ECHR and traditional human rights instruments is that we don't have that territorial constraint. And I think it's crucial. And I think the right people or the wrong people at the right levels are perfectly aware of this. And this is why you see post-Hirsi-Jamaa how we went from physical assets in the Mediterranean, where we have physical proximity between border guards and third country nationals, how we went from that to the use of aerial surveillance, how we went from aerial surveillance to drone surveillance, and then how we went from drone surveillance to satellite surveillance. So if anything, I think the right people or the wrong people in the right places are aware of the fact that cutting the physical proximity dilutes or decreases the chances of the Charter of Fundamental Rights actively being triggered. That said, I completely endorse what Violeta said, namely that the Charter of Fundamental Rights simply does not have that physical territorial constraint, as a result of which, as soon as we're implementing EU law in to any degree, it would be triggered. And insofar that Frontex is acting ultra vires, it too still would be held by these provisions under the Charter. I hope that addresses some of the concerns or the questions that our presentations raised. Thank you for your attention.
Mariana, please, very brief, please.
Very brief. I understand we're running out of time. So first of all, I'm very grateful to Tamás for so thoroughly looking into our work and coming up with these comments. I will take them on board when developing the paper more, but I would like to have three brief comments on three of his points. First, about the conceptualization and what we mean and what the regulation means with shared responsibility. Yes, indeed. Mostly when the regulation uses the term, it is meant in the sense of, as THL Hart put it, role responsibility or responsibility as task, according to Bovens, and not as liability responsibility or responsibility as accountability. What you said about what Tamás said about assigning blame for causing harm, that is indeed true. The point that we're making, and I'm saying we because I hear Violeta arguing the same direction, is basically that these two cannot not be connected. We cannot say that someone has competence but not responsibility for that competence. So very concretely, the suggestion is to connect Article 7, so competence responsibility, to Article 340, so liability responsibility. And this is supported basically also by Frontex when they say that we only have a coordinating role, we don't engage directly. This is an argument on liability responsibility based on their competence responsibility. Second point, about using international law as a source of inspiration. This sounds very radical to EU lawyers sometimes, but we need to, I see Joyce laughing, you have the same struggles trying to explain it to EU lawyers, yeah, I understand. So we have to really accept that we exist in a multi-layered legal order, and EU law is part of this international framework. EU law is part of international law as well, but this goes the other way as well. So it is not only that the area that the articles on shared responsibility can be used as a source of inspiration for the Court of Justice, but we have to realize that the ARIO are not stable, are not written in stone. They're still developing. They're developing on the basis of customary law, which is developing as well on the basis of the case law of the court. So the court right now, and if we're talking about EU legislators as well, they have a unique opportunity to develop the international law in this perspective. And I think this is the way we should be discussing with the courts, with our national courts as well in this direction. And lastly, about strategic litigation, I could not agree more that WS and others is not the end of the journey. It's only the beginning. And there are more of these cases to come. This has just opened the door for more cases to go through the admissibility stage and more into the substance. On the 11th of October, we have the case that Thomas mentioned of Sea-Watch, and that is a pullback by Libya, where the European Border and Coast Guard is accused of facilitating the illegal interception. This is just the latest step. And the hearing is also the last step before the final judgment. So I'm very curious about that. And Violeta, your theory about contactless control may have been ignored for years by the European Court of Human Rights, but you may get a response from the Court of Justice. And just the final thing about strategic litigation, or the thing about strategic litigation, is that it works both inside and outside of courts. So worst case scenario, if nothing works, if all these cases come through and they fail and they file no responsibility of Frontex under the framework of the Court of Justice and its existing case law, then at least we come up with proof and an example, a very concrete example of what we're talking about the lack of accountability and the need to change our legal framework. If that's our worst case scenario, then so be it. It's still a success. So thank you for now.
Thank you for all your reflections. We do not have time. I'm very sorry for more questions. If you have questions, you can email directly to the presenters, and we have to go to the next step of this final conference. Thank you.
For the invitation at this important conference. Open Arms is one of the NGO that is working in the Central Med since 2016. In these 8 years, we rescue more than 70,000 people, and it is very important results for us. Okay, we have 5 minutes, but it's important for me to report the attention on what is happening and what happens every day in the Central Med. And 10 minutes ago, I received a message from Sea-Watch. Sea-Watch is another, as we know, is another important NGO that is operating with a boat and with airplanes in the Central Med. And they witnessed deported by so-called Libyan Coast Guard. It happens today. They reported that the boat of the so-called Libyan Coast Guard crashed into a boat that was in distress, and 50 people on board fell in the sea. They were rescued, by the so-called Libyan Coast Guard and go back to Libya. So every day it happens facts like this in the Central Med. Okay, I prepared a speech, but I just want to go straight to the point of the paper because we constantly, by our activity, we constantly report the lack of coordination by the MRCC. Lack of coordination means not only the Italian one, but the Maltesian and the Libyan one. Lack of coordination means also the lack of sharing information about a distress case. So when we receive a notice of a distress case by other NGOs, by the Alarm Foreign, we are not able to know what happened of this boat and on the people on board. The last case happened yesterday. We received news about 150 people and they totally disappeared because we don't know what happened. We know that they were navigating to the south coast of Italy. Probably they were close to Calabria coast, but we don't know what happened. So today we asked to our Italian deputies to ask for this information to the Italian Coast Guard, because when as NGO we ask this information, they don't answer to us. So yes, when we talk about sharing information, we are not at the same level, because if we ask for information, nobody answers to us. I only I'm cut a lot. I'm trying to cut a lot, but it is important for us to report that there is not a common definition of a distress case, as we also heard yesterday. But for us, it's clear that an overcrowded boat is a distress case. So we want to be able to intervene, and we want to be considered as an asset able to intervene. Instead, during the last 5 years, we were always constantly considered by the European and Italian institution as criminals, as people and boats and NGOs to stop. Last fact happened yesterday. Yesterday, because I'm from Italy, the Italian government left a very important European table because of a crash, a fight with the German government, and it is because of the role of NGO. So I think it's very important to put the attention on, yes, we are discussing about international law, but the fact is that one of the main actors that is operating in the Central Med, that are humanitarian organization, are accused every day to be to work with the traffickers and to be traffickers. Okay. Sorry, I have 2 minutes more, and okay, I want also to report in this conference that because yesterday you talked a lot about the national government laws and the international government laws, yes, but in these months, in these first months of 2023, the humanitarian vessels has to respond at a very important Italian national law, that is the 15/2023. And we are after the first rescue, we are addressed in a very far port. It requires 4, 5, 6 days of navigation. And when we reach the port, they asked to us if we deviated or not our route. If yes, we are stopped, as happened to Open Arms last month. We stopped in the port of Carrara, that is in the north of Italy, for 20 days. And we paid 3,000 euro. only because we rescue the 150 people and without any coordination. So I'm sorry because I just put a report some points, but it was important for me to report what happens every day and which are the main problem we face is every day, every month. Now we are operating in the SAR 2, the SAR zone 2. It is 25 miles from the coast of Libya. We departed yesterday in the morning. So yes, we received a lot of alerts, like I told you about the 145 people. And we hope to rescue more lives because at the moment there is any other assets able to do it. Thank you.
Thanks, Valentina. I was reading again the chapter 9, and actually you just gave the face of the chapter 9 from the guidelines. So I invite after really just read these 5 paragraphs. So without further ado, I will give the floor to Mr. Grigorios Tsioukas from the SRO office.
Thank you, Martin. I promise to follow the instructions. So I will try to be telegraphic. Titles. So more case law we have, the more this will make my professional life easier. So go for it. It gives clarity to everybody, and I keep the positive. I mean, talking about the recent general court decision, I keep as positive the fact the admissibility part of that decision. Positive. Second, more Frontex. I am favoring having more Frontex than less at the EU external borders. It's not only that we have more technical safeguards, as including also democratic oversight. I'm referring now to the scrutiny of the European Parliament, but this is what gives us the possibility to talk about border management at the EU level. If we didn't have Frontex, now we couldn't have this discussion that we are having today. If we had only national border authorities dealing with the situation at the borders. Third, very important, I totally agree with the guideline on criminalization of humanitarian work. I think this is something that needs to be highlighted. And linked to this, I believe that talking about SAR operations and SAR-related activities, informing NGO boards about sightings would be a positive signal. Totally support this idea. Something that I believe in the guidelines is a bit missing. It is there, but not highlighted, is the need to have a national independent monitoring mechanism system. I mean, the one that is being discussed now. It is there, not there, but not as a separate point. I mean, personally, I would like to see a separate point on that. I believe this is very important also talking about this accountability gap. Then again, external independent oversight on what Frontex is doing. I'm also in favor of that idea. I mean, I have next to me Damas. I mean, I know that probably this would require a change in the mandate of the agency, but and I don't know to what extent this is feasible or in the current context, but definitely the Fundamental Rights Agency will play such a role. That said, I still believe that we do need international mechanisms as well, like the Fundamental Rights Office. And if we could, let's say, push for such internal mechanisms also in the context of national institutions, national border institution structures, I mean, it would be again a positive development. Same about complaints. Yes, I agree with the conclusion that the current complaints mechanism is not so effective. Quite often the complaints that we receive relate to, let's say, reception conditions, right? And then, of course, we say this goes beyond Frontex mandate, and then they are not admissible. So what happens next? That's a good question. Now we cannot do much, but ideas like involving maybe the European Ombudsman, institutionalizing maybe a transfer of that complaint to the national ombudsman. So these are a few ideas. Now about transparency, again, I believe that if operational plans were made public, this would also help understand who is doing what, right? In this context of a joint operation, to what extent Frontex is responsible, to what extent member states are responsible, so who is in charge? I mean, if I tell you that the member state and the national authorities are in charge, you will not believe me. But trust me, it is the case. But you have to see the operational plan to understand how it works. Listening to the argument about ultra vires, quite often what I receive from member states when I try to make an investigation is that, okay, you are exceeding your mandate. This is not something for you. This is national competence. Yes, but it is related to border management. Of course, it is related to border management. Of course, it is the context of a joint operation, but it were our staff working there and not Frontex staff. Frontex was not present, so we don't have anything to investigate here. So this is the reality that we are facing. At the same time, I must say that I do understand a bit of secrecy when it comes to decision-making process, right? Take, for example, the fundamental rights officer opinion. So we have an opinion, withdraw from Greece, okay, suspend operation in Greece. To understand why Frontex, they need some time to digest, they need some time also to make their negotiations with the Greek authorities. So it makes sense, operationally speaking now. I know you have all kind of legal objections, but operationally speaking, it makes sense. Now, debriefing, I would like to introduce this idea of fundamental rights intelligence. What is debriefing? Debriefing is about collecting intelligence, right? Yes, you might have problems with the collection also of personal data, and here Pani can say more, but let's suppose that we solve this problem, an assumption, using this mechanism, this activity also to collect fundamental rights intelligence is important. And what practically, what I'm referring to now practically is that many of the serious incident reports that we have investigated came through the debriefing interview. So the Frontex officer who received some information and they passed it to us. Otherwise, we wouldn't know about this. So, and just for your reflection, cooperation with third countries. I think it is important. Yes, I'm not referring to Libya, obviously, and I'm not referring about having disembarkations, but training, it was discussed this morning, or training, I don't know if you can call it training, but having exchanges, so talking about the cave, fundamental rights, border management. So, I mean, are we expecting not to have any kind of cooperation with any third country? So there I would be a bit more reluctant to accept this argument. It's different to send standing corps officers in Senegal. I would never be in favor of such an idea, right? But having a liaison of a Frontex liaison officer there, is it that harmful? I would say one needs again to make the distinction what is the activity. And the last point, and I hope that I am, so the very last point is more like, 2 points. The one is on integrated responsibility, and I wanted to ask you, because we didn't have the time, and also the nexus theory. Okay, I understand the administrative and the non-contractual liability dimension, but does this apply also to criminal liability? So are Frontex staff responsible for national officers that are beating up people in terms of criminal liability? So, and I think this is also very, very critical. And now, from this last point, what I see, and this is more like a political, let's say, observation, I see a big gap, which is growing even bigger between the political realities, the political will of the governments, and the legal framework. So the very moment that here we talk about fundamental rights, the principle of non-refoulement, at the very moment the government in Sweden was invited by the opposition, which happens to be also the left opposition, in part of the left at least, to send the army because integration policies have not succeeded in Europe. The very moment that we discuss about fundamental rights, the British Minister of the Interior last week or a few days ago was saying something, correct me if I'm wrong, that the current international legal framework on international protection is totally outdated. So, and this is what we are facing, and we have to keep, and it's not by accident that nobody wants to open the regulation, nobody wants to open the discussion, because we all are afraid what will happen after the next European elections. Thank you.
I will pass the floor to Fanny, who said she was giving a bit of her time to Gregorios. So, thanks, Fanny Kuder from EDPS.
So, regarding to these guidelines here, I want to say that I really appreciate the fact that there is a dedicated chapter to data protection, actually. Because I understand, and from all the discussion we had today, I understand the field of migration, the right of data protection is something new area, a bit unexplored. Nobody really paid attention so far to data protection. I really feel like a newbie, I mean, say in this world. And I can understand, because I mean, we're discussing pushbacks, right to life, torture, so issues which are very serious. And so talking about data protection seems a bit trivial in that sense. But as Frontex starts using more and more new technologies, we have heard about surveillance being more and more sophisticated. We'll be building this interoperability framework in order to screen third country nationals. And here what's happening, so the surveillance will rely more and more on processing of data. And I think it's Joyce who said that, and I think that that's a core issue, that by using more technology, we're cutting the physical proximity in a way that's unable to reduce the possibility of being charged from HR violation. And so this is why I think in the long term, data protection might become more and more relevant in that sense. And this brought me back to a question that I'm asking myself, since we've been participating to the ETIAS fundamental guidance where we are to not only data protection authorities, but also we are with FRA, we have with the FRA of Frontex, there's a consultative forum of Frontex as well. So bringing together different expertise. And the question I was asking myself was, what is how we should articulate the right to data protection in the architecture of third country national rights protection? Is data protection a standalone right serving a specific chapter, or should we think about data protection more as a gateway for the protection of other rights? I think that it will be both, but I think what we will need to do, and that's what we're trying as well to do, is to conceptualize how actually the processing of personal data is serving all the purpose in the sense of interference into all the rights, and how this is reducing the possibility of third country national to exercise their rights. And this is a concept which is present under the data protection framework and the concept of data protection impact assessment, where this is something to be developed, but where we normally ask controllers such as Frontex or responsible for the perceived personal data to think what is the impact of collecting and processing these personal data on individual. How will this impact the enjoyment of other rights? So I think that's a challenge for the year to come, to articulate data protection in this broader protection of the country national rights. And I hope that once we manage to get there, the EDPS might be listed in this chapter you have on strengthening non-judicial accountability. Together as one additional mechanism of accountability, actually, in the field of migration, and where we could work together with the Ombudsman, the Parliament, the FRO. I see that the EU Committee for the Prevention of Torture, FRA, or National Human Rights Institution, which are all mentioned in this chapter. And that's why this example of the ETIAS Fundamental Right Guidance also means like kind of a laboratory where you have data protection, have you to work with fundamental rights agency officer. And how do we combine our expertise together to get to a higher level?
That's funny. Now I will give the floor to Dr. Thomas Molnar from the FRA.
Thank you, Madam Chair. I'm Amandine for the floor. I'll just stick to the 5 minutes. To start with, chapeau, really heartfelt congratulations for all who have been involved in putting together this very robust joint guidelines. It's a comprehensive inventory, a very rich and thoughtful a set of suggestions, which provides a beautiful snapshot of the issues, the shortcomings, and the points for improvements as of now, as of September 2023. It has 75 points. This is a lot. It's really robust. And it's divided into 12 building blocks. So it has as many sections or building blocks as stars in the EU flag. So it's a perfect number. So if there has been some hidden, rationale, well done. It's really a perfect circle in this regard. One or two suggestions which are of a technical nature. Of course, after having read through and the document and the nature of the document also implies that policymakers and legislators are targeted. But I think the question of who are the addressees should be more explicitly there, or maybe it is worth including something that all these guideline recommendations go to X, Y, Z targeted actors, change makers, just a suggestion. And sorry to put my nose in that regarding the title, just a humble suggestion. For me, these are rather recommendations than guidelines. The level of abstraction at times is not that detailed. I mean, those who wants to make a change can just read and then follow the guidelines. So I would go for joint recommendations on operationalizing shared responsibility. So it's something, but this is just my personal remark. And as regards the content, I would like to make one point. Thus far, we've been rather discussing how to make Frontex accountable. All the discussions centered around Frontex and to bring it to the daylight from the perspective of legal proceedings and accountability. I would like to flip the coin and pinpoint a little bit the asymmetry between fundamental rights safeguards at the EU and the national level under the EBCG regulation. So what I would like to now discuss is a bit related to what Grigorios mentioned. I mean, we of course all know that the EBCG consists of both the member states authorities responsible for borders and returns on the one hand, and Frontex as their EU level counterpart. But if we comb through the EBCG regulation, it's clear that it sets out more fundamental rights obligations with respect to Frontex compared to actions undertaken by member states. So there's a certain asymmetry, and although legal policy developments under EU law after the EPC regulation point to a gradual alignment of national and EU level fundamental rights obligations, see the latest functional communication of EU IBM or the revamped Schengen evaluation monitoring mechanism, the asymmetry is still there. Why? There are some general provisions that apply to both Frontex and member states, like Article 1 on the scope, or Article 3 on the integrated border management, and even some parts of Article 18, which is the general fundamental rights safeguards. But the concrete and more detailed measures to protect and promote fundamental rights are only envisaged for Frontex. And I have some examples. For instance, Frontex must adopt fundamental rights strategy and action plan, and not the member state under the EPC regulation. Frontex must draw up a code of conduct on several matters. It's not an EU law obligation for member states. Frontex must constantly assess the fundamental rights compliance in all of its operational activities. It's not foreseen explicitly for member states. And Frontex must recruit and deploy at least 40 fundamental rights monitors, which is not, there's no corresponding obligation for member states. So we see that the EPC regulation doesn't sufficiently operationalize the corresponding duties for member states. And in the work of the Fundamental Rights Agency, we observed that this divergence between the safeguards at EU Frontex and the national level is prone to have adverse implications to fully upholding rights in practice. 3 examples. First, fundamental rights monitoring remains uneven. For Frontex, it's there and its legal obligation, but there's no obligation under EU law for member states, and currently there's hardly any national level border monitoring mechanism, except for Croatia and Bulgaria. Second, in some member states, the officers that Frontex deployed didn't patrol critical sections of the border that they could witness alleged fundamental rights violations. So it's again an unwelcome situation. And third, the third countries may get conflicting messages at EU fundamental rights law standards. If we compare, in case of bilateral deployments by member states for third countries, these are not subject to the same fundamental rights guarantees as those reflected in the status agreement or working arrangements that govern the cooperation between Frontex and third countries. So Senegal, Mauritania, they face different levels of fundamental rights guarantees if they deal with individual member states or with Frontex as an EU entity. So the recommendation I stop here should be that if the EPC regulation is reopened, and now we know the evaluation is going, the Commission will come up with its communication by the end of November. So if it's reopened, then consideration could be given to approximate these fundamental rights safeguards, which are applicable to member states with those of Frontex. So elevate for member states, including the obligation to have a fundamental rights strategy and action plan, and also to have an EU level obligation to carry out fundamental rights monitoring at borders. Thank you very much.
Thanks, Thomas. I will give the floor now to Dr. Madeleine Gerlich from UNHCR. You have the floor.
Hello, everybody. Do you hear me?
We don't see you. We hear you, but we don't see you. No, I feel
If you have, okay, I'm not able where I am perhaps right now to turn my camera on. I'm very sorry, although not for you. Maybe you're better off. No, it's really a pleasure to be here with you today virtually, and let me really from UNHCR's side thank the leaders and participants in the shared project for their work on this initiative. It's a particularly important work that's been undertaken here to promote respect for rights in practice in the context of border management. I think it's extremely timely and has great resonance, not only in the European Union, but globally. The draft guidelines are in many ways unique. It's the only text of its kind, of which I am least aware in terms of its comprehensive, its rights focused, and its practical content. So in this final panel, looking ahead to next steps for finalizing and distributing it widely, I have 8 very brief points, which I'll try to deal with in less than a minute each because I've been given 7 minutes. And I'd like to put these forward as suggestions for consideration and discussion, some relating to process and some related to content. So firstly, the title of the document refers to the guidelines' joint nature. So starting from this and noting the very participatory nature of the process that have generated them, I'd like to ask if there are ways we can broaden further the base of support and build a sense of ownership for this document. Is there scope, and this is perhaps a question for Gregorios, for us to engage Frontex more actively in its rollout and implementation, at least via the Fundamental Rights Office or the Consultative Forum? Is there scope for us to engage partners as co-signatories or as observers in some way? Is there scope for us to seek more engagement or endorsement or at least acknowledgement from EU institutions or perhaps even champions if we're ambitious amongst member states or member state institutions? And I think particularly of national human rights mechanisms or ombudspersons as potential partners here. Secondly, on the legal character of the document, I think it's important to be clear and unequivocal about its non-binding character, not as a weakness, but rather as something on which we can capitalize. We're in an era now where there are significant limits on scope for stakeholders to push for legally binding texts. But at the same time, we see the way in which non-binding instruments are increasingly recognized as having an important role, and the global compacts come to mind here at international level, as informing and needing to be taken into account in the interpretation and application of binding legal obligations. Thirdly, I'd like to suggest we consider, and perhaps this has already been considered, that in the framing and presentation of this document publicly, we ensure that it has a concise and very powerfully drafted introduction that explains clearly its purpose, its intended audiences, a point made also by Thomas, and the ways in which it can and should be used, including for the purposes of strengthening accountability and respect for rights in practice by various stakeholders and readers. Some further points on detailed aspects of the text. I think the section on an integrated responsibility framework is particularly interesting and holds great potential. Perhaps it would be important to look at ways in which this idea can be anchored institutionally and legally going forward. Enshrining it in legislation might prove challenging, certainly in the short term, but perhaps there are ways we can promote discussion and reflection on this idea in relevant fora, raising awareness of it and pave the way for its further development and taking it forward. And fifthly, on judicial protection, I think this section is particularly valuable, but I'd like to put forward a very practical idea also for the participants in this project. If there's scope, we might want to consider to create an online tool or kind of portal or interactive website where those alleging violations of rights on issues related to the guidelines could register or log their claims. This could be anonymous if needed, and of course is without prejudice to formal judicial or administrative or other remedies, but it could help in gathering data and providing insight into the volume, the nature, and the character of allegations of rights violations in the course of integrated border management. This could also perhaps, if it's an online tool, be something that could provide information and referral, legal advice, support, and other valuable resources for people affected by rights violations. Linked to this, the section on national courts. I think this is an important part, and I note the guidelines refer to these being available for gap filling when EU mechanisms are not adequate. But I'd like to ask, is there scope for us to promote their more active use? Reflecting the logic of subsidiarity and making full use of domestic remedies, perhaps it's important for us to see if the engagement of domestic judicial institutions can be promoted and individuals help to use national courts where they might have jurisdiction and there's scope to bring legal proceedings in criminal or civil law to enforce shared responsibility. On cooperation with third countries, second last point, this project has looked very extensively, of course, at the role of the EU, but I wonder whether we might consider also ways to engage also other regional entities. And I think particularly of the African Union, but other African regional bodies perhaps also, whose countries lie along routes that lead towards the Mediterranean and EU borders. We have strong human rights arms in some African regional institutions, which could be engaged in discussion on the issues raised in the guidelines, perhaps to promote greater awareness of the need for standards to be observed in the EU's international cooperation and dialogue. And then finally, I just want to suggest the possibility of establishing a fixed future review date for the guidelines. I wonder if it might be possible for us to look at proposing a moment in the future, say in 1 or 3 years, to take stock of the impact of the guidelines, What have they been used for? What can be done at that point to draw lessons learned and to strengthen, further implement, or use them and the findings and insights that their development and their implementation has brought. Thanks once again, and I'm looking forward to any questions or discussion. Thank you.
Thanks a lot, Madeline. With this, we have the first round of stakeholder. I'll open the floor for questions. I'm going to check online, and then actually I'm going to hand to Violetta to keep moderating the Q&A because I have unfortunately to take a plane. So with Tineke, yeah, please raise your hand for the ones in the room, and I will leave Violetta to moderate the Q&A. And thanks a lot really to all of you for your intervention. And know that we have a series of upcoming different moments as proposed also by Madeline. I look forward to these upcoming moments as well. And I'll yeah, let Violetta keep the moderation, but just raise your hand in the room if you have some questions.
Okay, don't be shy. I think there were a lot of very interesting elements for us to reflect on as the main drafters of the guidelines. So I don't know if any of you have felt particularly compelled to react to any of the points that our stakeholders have raised. If you would like to say something about that. Ah, yeah, sorry, Salvo. Okay. Can you come to the microphone? Thank you.
Thank you very much. Actually, I would like to follow up on some of the further suggestions about addressing the national dimension. So how can we, in fact, bring this project more to the national dimension? So I think we had a fruitful discussion over all these phases, but we have institutional, so we have Frontex, so we have different other institutions, stakeholders that operate especially at the supervision level, of course, academics. Perhaps I was really reflecting on the fact that we don't have practitioners from the ministries or competent national border guards. What do we know about their perception? What do we know about when they can complement the EU dimension? What do we know about the limits and the potential they have? So perhaps indeed for the future, this can be a point taking into account.
Thank you very much, Salvo. Cici has another point raised.
Actually, I was thinking about Dama's recommendation about the fact that not many of the guidelines, actually no guidelines were addressed to states. But I was thinking, I was wondering if you actually think that guidelines on member states' responsibility or third member states' responsibility should be added, or whether everything is already could be seen as covered, considering that we are just trying to get Frontex involved in this. We're trying to get the point Frontex's responsibility to share, I guess, mainly. But yeah, I was wondering if you think it's necessary to add that, or whether the relevant rules on the DRC mainly would be sufficient to that end. Thank you.
Can I just collect a further couple of questions? Because I mean, we're also running short of time. Are there any other comments or questions from either the audience here or online? If not, I can take it back to the panelists. I just wanted to thank them all on behalf of all the partners of the Shared Project for engaging throughout the life of the project, and especially during these 2 days. With the drafting of the guidelines or recommendations, we'll see. We didn't want to preempt, so we didn't target any specific stakeholders because we wanted to keep the document as broad as possible and to include elements that will be there for everyone. So there are
things that hopefully are going to be useful for NGOs and civil society, things that are going to be useful for EU agencies and entities, also for UNHCR and other international organizations. Hopefully the member states, they weren't our main target, but it's true that perhaps that part of the document could be reviewed. I thank Madeleine for her suggestions on having maybe a portal. I mean, we will need to raise funding, so we'll invite all the researchers present here and online. If you would like to pursue this further, it would be very good. I think to generate a record of violations and gather data on the volume and nature of allegations, and then perhaps filter those to the relevant entities that can provide remedies would be very, very helpful. I don't know if the EDPS would welcome that, or the EU Ombudsman, or maybe the FRA, but maybe this is something that we could look into. In terms of having a fixed date to review the guidelines, that's also a very interesting suggestion. I think considering the fast moving target that integrated border management and Frontex activity has become, this is something surely to bear in mind. And perhaps having thematic chapters. I mean, considering that we have like 12 blocks, we didn't think of the stars, but that's a very good point. Perhaps there could be like thematic chapters where each of these building blocks could be delved into and become its own set of specific guidelines. So, for example, data protection, there are only like big brush elements that have been included, which we thought were very important. And there is scope for further development. So maybe that's another thing that we collectively as a research community could think about, and take the shared responsibility work further into these different complementary directions. I'll give back the floor to the panelists for one final minute on general reflections and perhaps taking up the comments from the floor. And then we will give the opportunity to the chair of the LIBE committee, who is with us today, Professor Juan Fernando López Aguilar, who is going to be closing the conference and the shared project actually today. So maybe I take it in the order that you're sitting. I give the floor to Tamas and work my way back.
Thanks, Fiola. Very telegraphically, Salvo, I think it's good to involve, for instance, National Border Guards academics for some references. For me, they serve like the bridge between academia and they have more strategic thinking, but also to ensure that national authorities, those who are actually border guards, Sis's question, I think given that there's a self-standing chapter on cooperation with third countries, which is already lengthy, without making it like a Christmas tree approach, I think it would be good to reflect to the applicability of ARCIVA in that specific context, not just in general, but also because of the cooperation schemes a bit more specifically as well. And yeah, that's going from my side. And over to Claudius.
Thanks, Tamas. To start with Madeleine, of course, it would be very difficult for me to endorse the guidelines officially and publicly for reasons that you probably understand. But definitely, I hope that I have contributed to your work as much as possible. And then my last comment is that, yes, I have tried to show that in the field, no matter how people feel about it or what is the perception, the general perception in the field, I try to show that the reality is that the boss are the member states and the national authorities, and it is not Frontex. So if there is no national component dimension in the exercise, then something is missing, something fundamental is missing. That's why these are very good guidelines, and it's very fine that they are addressed to Frontex, but European Border and Coast Guard is not only Frontex. European Border and Coast Guard is Frontex and the border management authorities and the Coast Guard authorities of the member states. So if we don't address such guidelines to this component of EBCG, then we are missing something fundamental. Thank you.
two comments. So about the need, your comment about to involve domestic level as well. I think there's also a role on an effort to be done, as I was mentioning yesterday, at the level of supervisory authorities. So the ombudsman, we mentioned, I think earlier, to work with a EU level together with national level, or DPS, I mentioned, we try to work also with national protection authority. For example, this visit to the hotspot in Lesbos, which allows to not only to have a broader view of the full view of the processing or the activities, but also to put under control not only EU agencies but also national authorities, especially when they are working together. And the only way to do it. And so there was a question about from the audience, online audience, about whether we could leverage surveillance technology being developed for also to monitor violations of human rights, and whether this could be done in conformity with data protection. So I'm sure we can find a way, but that's I cannot give a definitive answer, right? This made me think actually to the debate. I was at a conference in Madrid 2 weeks ago, the EDEN conference, about law enforcement and data protection. And there was a panel on body cam, on the use of body cameras by police officer. I think this is the same kind of issues we would be facing in that context. And there's a lot of body of research about that. And there's a way to use this technology not only for surveillance purposes, but also to monitor a violation. To respectful.
To Valentina, and then I'll go back to Martin.
Yes, I don't know if I have a properly answer to the question, but I just want to stress the fact that it is a very important tool. And during I will share it with our colleagues of other NGOs for sure, because I have the same question of the you, so I don't have an answer, but it will be important for us to share with our colleagues and also to adopt it as a advocacy instrument when we talk about with our institutions. So thank you for the invitation, because I don't know how to answer to your question.
Madeleine, the floor is yours for the final reflections.
Thank you, Violetta. Yes, I'd just like, in response to Gregorius's point, just to acknowledge the really important and substantive contribution the Fundamental Rights Office has made. But just, I guess, to ask whether there's scope for us at least to raise awareness within Frontex's structures and perhaps even the management board of this project, and to have some kind of dialogue about the issues that it has brought to light. But in addition to that, I just think, to close the discussion, that it's a very important point that Gregorius has made, that we are really talking here, of course, about the importance of finding ways to promote respect for human rights at borders more broadly. The acquis, the Charter, and international legal obligations, of course, apply to many actors, and we see very serious challenges to their implementation every day at different EU frontiers. So this is a wider enterprise that we're all undertaking, and I think this work needs to be seen as a very important contribution, but clearly there's a great deal more for all of us to do, and this just underlines the importance of the work of this project and that of many stakeholders who've contributed. Thank you.
Thank you very much. I'm now going to give the floor to my colleague, Professor David Moya, and we are ready to welcome the chair of the LIBE Committee, Professor Juan Fernando López Aguilar, who is going to be giving the closing statement to this roundtable discussion and the 2 days that we've spent together in the final conference of the shared project. Thank you very much, everyone, for joining us for the roundtable, and I give the floor now to my 2 colleagues. Thank you.
Well, in my condition as a director of the Observatory of Public Law, which is also supporting the celebration of this conference, I would like to say here, particularly to Professor is Professor Lopez Aguilar from Constitutional Law. We have been reading attentively all his production, literary production. I would like to thank him in his other hat as political representative in the European Parliament. I would like to thank him for the effort here. Sure, it's been a long journey in a very intense week, isn't it? Lopez Aguilar is a member of the European Parliament with the Socialist Democrats, as you well known. In the past, he served as the Spanish Minister of Justice and a representative of Las Palmas in the Congress. Professor of Constitutional Law, as I mentioned, and Jean Monnet Chair of European Union Law. I would like to underline his more recent, since 2009, chairing of the LIBE Committee, the Committee on Civil Liberties, Justice and Home Affairs, and member of the delegation of the ACP Joint Parliamentary Assembly. Not going into all the long list of responsibilities. I might just say two things. First, which is more relevant here probably, is the fact that he is rapporteur on crisis and force majeure legislation, piece of legislation in the framework of the new pact of asylum and migration, which is making these days, especially regarding some questions he's going probably to comment now and give us the last information and an inside point of view. The second thing I would like to underline, it's more close to my heart, is that we were following all his strong involvement and personal involvement with the proposal for humanitarian. I still I think it's in the chorus of the proposals, and I think it's a long-lasting goal to achieve. But this is in a more personal way. Remember all his efforts to push it forward as a matter of justice and advance of the system. Thank you very much.
Thank you, David. Thank you, Violeta. Thank you for having me. Thank you for your commitment, for your work, for the thorough analysis and the caring attention that you pay to the kind of work I've been carrying out for the last 15 years, 14 actually, in the European Parliament in the fields of liberties, justice, and home affairs. Use the encompassing, overarching, heaviest workload when it comes to law, policy and lawmaking in the European Parliament for sure, at a European scale for sure. And as it is my turn to share with you some kind of concluding remarks, I'll try to be of added value to the academic, thorough analysis and certainly criticism that you have been putting on the status quo. First of all, take it for granted. I am a fighter against that status quo. I find it completely unacceptable. The status quo as it is by now, that's why we've been trying so hard, we've been working so hard for the last 3 years at least, in order to bring about some change for the better. And believe me, I have not thrown down the towel yet. It's not an option. You have representation and political capacity, whatever kind, you have a political responsibility and accountability for the matter, whatever kind. It's not an option to give up. Believe me, it's a whole lot of work. It's a hard work. So I'll try to make the long story short. First, I've been chairing the LIBE Committee some years now. It's the Committee of Liberties, Justice and Home Affairs, which entails from a wide range of issues, entailing from fundamental rights, data protection, for sure, to security matters, going through criminal law in the making, procedural guarantees, for sure, but yes, also very important, both policy and lawmaking in migration and asylum-related issues. We have been trying hard to fulfill the mandate and the promise of the Treaty of Lisbon, which entered into force along with the Charter of Fundamental Rights 14 years ago. exactly the year when I first landed in the European Parliament, 2009. And for the first time ever, that mandate to put in place some European common approach and legislation on migration and the European common asylum system has been much overworked on. But it's not been an easy task. Surely you know, surely you're aware that migration and asylum used to be expression of the sovereign competencies of nation states for centuries. Was expression of sovereignty of member states for too long. And believe it or not, it's still taking a whole lot of work to make member states understand that that is no longer the case. That ever since the Lisbon Treaty entered force with the Charter, they are not the only ones to deal with migration and asylum related issues. We're both professors of constitutional law. Every professor of constitutional law knows in Spain that migration and asylum are listed in the exclusive competences of the state, as opposed to the what we call autonomous communities, which is the Länder auf Deutsch. In Article 149, paragraph 2, right after the basic core of fundamental rights and duties of the citizens, it comes migration and asylum as a national competence. It's a competence, an exclusive competence of the member state. So believe me, it's been a whole lot of work to make them understand that the European Parliament has grown to be not only a legislator when it comes to criminal law making, civil law, but also when it comes to migration and asylum issues. And yes, we have delivered. We have put in place, at least we've tried, we have put in place a migration package consisting of at least 8 pieces of legislation and an asylum package consisting of at least 9 pieces of legislation. We have tried to put in place a European common asylum system, but it's still not working, still not there. Now, of course, we have been complaining, we have been time and again raising debates on the status quo and complaining about the lack of compliance for one thing. So again, to make the long story short, after all of these years, the European Common Asylum System shows 2 flaws, 2 main flaws. One, of course, is non-compliance. For one thing, despite infringement procedures, despite rulings of the European Court of Justice, there are still member states reluctant to realize that EU law is binding law, according to primacy and direct effect. For one thing, we could extend that criticism even to the international humanitarian law, much too often when it comes to search and rescue or safe disembarkation. But second, there's a missing link in the European Common Asylum System, which is a violation of the principles on which the European Common Asylum System is supposed to be built on. Shared responsibility and solidarity. Shared responsibility and solidarity. Article 80 of the Constitution of the European Union. And there's still the missing link, it's solidarity. Missing link, solidarity. The lack of solidarity is a recurrent complaint by member states, particularly for sure those which are often named frontline member states, meaning leaning to the Mediterranean, not only to the Mediterranean, also to the Atlantic. That's the case of Spain, the Canary Islands, where I was born, where I belong. Certainly, both Mediterranean and Atlantic are the ultimate expression of this lack of solidarity. Recurrent complaints by Spain, Italy, Malta, Cyprus, Greece, of being left on their own, particularly the islands, for sure. Indian islands, Pelagic islands in Italy, the Canary Islands. Where is Europe? Where is Europe? Where is Europe? That is the outcry time and again, even in the plenary, for sure. What is Europe going to do about it? Where's the European scale of response? So the situation goes that despite there are rules, time and again we have seen the EU Commission at times hand in hand with some ruler in some member state, flying somewhere. Lately, Lampedusa, a so self-called EU team. What kind of a fantasy is that? Don't ask me. EU team, namely Ursula von der Leyen, President of the EU Commission, Giorgia Meloni, Italy's Prime Minister, and Mark Rutte, which is the Netherlands Prime Minister. They went to Tunisia, again to somehow try out a patchwork, try to come up with some immediate response to some recurrent crisis with a kind of rhetoric that I have myself criticized as melonized, because we have seen Ursula von der Leyen severely melonized in these later days. So the situation is completely unacceptable. Never a strategy, never a far-reaching sight, and of course, never an architecture. So the thing is that when this mandate of the European Parliament and the Commission got started, we somehow, and of course, some of us, European, which believe in the EU, Europeans, MEPs, and particularly the progressives, I find myself a progressive, a leftist progressive, which also means something, as I'm about to explain. We try to get from Ursula von der Leyen in the investiture vote commitment to bring about a new balance between responsibility and solidarity. So the Commission came with 5 regulations, which in 2020 were interpreted as a step forward, or straight step forward. Why so? Because we're talking about regulations, which are somehow making a synthesis of many directives of different times, different data, some kind of new impetus, simultaneously bring about new balance with regulations, which are binding legislative acts, particularly binding for the member states, and also legal grounds for the persons, the human beings, to seek for redress, for judicial protection, all the way from the judicial systems of the member states to the European Court of Justice, which is open to every citizen, even for foreigners when it comes to implementation of EU law, which affects them. So we started working out this new balance, and believe me, it's been absolutely time and energy consuming. It's been extremely hard, extremely difficult within the European Parliament, because of the European Parliament happens to be the only directly elected institution in the EU architecture. It's a pluralistic body for sure. There are 7 political groups. We progressives were not the majority. It's been too long. We are not even the #1 political group in the House. It's been too long. It's been the PP. But you must certainly know that there are 3 far right groups right to the EPP. So that is quite a challenge to come to some form of compromises. That is the way we work within the European Parliament. Cross-party lines, negotiating with each other, trying to come with a balance. How did we do that? Adopting what we call right from the outset the package approach. It means that we are convinced that this time we're going to make it right, and we are not to accept that this new status quo is going to be split into pieces according to the cherry-picking strategy of the EU, of the Council. What is usually called in Spanish, práctica del salchichón, the salami practice. In Spanish is you cut into pieces a certain piece of work so that you put something before with the allegation or with the alleged idea that you will be picking back the rest of it further up on the road, which will never happen. So we didn't accept that. We've been working hand by hand, all the negotiating teams, and facing together the Council. We adopted the first agreement striking some kind of a balance between shared responsibility and solidarity, which I, of course, fight for, is binding obligatory solidarity in situations of emergency and crisis. That means unexpected, massive, sudden arrival of irregular migrants, and particularly after search and rescue operations with prima facie international protection granted, ordered by the Commission, executively by the Commission. So it's been a whole lot of work. But certainly, you know, too, need to dwell on that. Certainly, you know, too, that migration and asylum are by far the most divisive issues in the European political landscape when it comes to the Council. Extremely divisive. I regularly represent the European Parliament as chair of the committee in the Council of Ministers of Justice and Home Affairs. I was a minister myself once. So I knew how was it like, but believe me, it's been getting worse and worse, deteriorating much. So now I can share with you just bluntly that in my not only my perception, my empirical conviction by now, the Council is the failed link in the EU architecture, because the European Parliament still behaves at times as a European institution. The European Court of Justice still behaves as a European institution, but the Council has ceased to behave as a European institution, believe me. In the Council, there is, believe me, there is a scene of contradictions live. Interest, national interests in contradiction live, one after the other, with no European scale of view, with no European hiring up, not in the least. Mutual intolerance of national interests expressed with no concessions to compromises, more and more so. That is the explanation, the ultimate explanation. So many legislative files that have been adopted by the European Parliament first reading and trilogues are lingering and procrastinating even for years, That is why we adopted the package approach, in order to put pressure on the Council. And believe me, being so divisive, the balance which is to be struck between shared solidarity and shared responsibility and binding solidarity is extremely hard. It's proving extremely hard to reach, extremely hard. But we're still there. We agreed with the Council a so-called roadmap as regards to the calendar, so that we might deliver before the end of this mandate of the European Parliament, which is, of course, running fast to the final track. Elections are in June 2024. The clock is ticking and time is essential, and we are not there yet. 3 years of tug of war with the Council. 3 years, we're not there yet. It happens to be that the ultimate Gordian knot is my crisis regulation, which, of course, when it came out from the European Parliament, was about solidarity, binding solidarity and relocation programs. Of course, the Council has somehow poisoned the legislative file that we adopted with their own input, which is, okay, you're obsessed with instrumentalization. Let's get instrumentalization on board. Okay, you're obsessed with derogations, extending the time frames of the return procedure, of the border procedure, of their asylum procedure. You want all extensions at hand so that you get margin of maneuver. Okay, we agree. So that you get you on board. But when I get you on board, then the other guy says, "Oh, that's unacceptable for me." And I have seen that live for years now. I will never go along with that. So it seems that the Council is coming close to make up its mind, whatever it is. And then there will be some running months for us just to break a deal. That is what the trilogue is about, sure you know. That is the European lawmaking. It's extremely sophisticated and tiresome, cumbersome, hard to explain, but still we're supposed to make sense of it. We're supposed to do whatever at hand to come to the end of every legislature with some added value, with some delivery. And at this stage, I can only add, and I'm coming to my closing remarks, I can only add that at this stage, I have set the council, putting pressure, all the pressure I can, I have set the council time and again that should this mandate of the European Parliament 1924 come to an end with no delivery on this matter, that would be not only extremely discouraging, as I try at times kindly to put it, will be a major blow for the European Union project in all. It would be a major failure, if not a catastrophe, for the European process in itself. Because if after all these many years that the Lisbon Treaty has been in place, has been effective, force, and the Charter has been enforced, we are not capable of coming to some kind of a common understanding of what shared responsibility is, what solidarity is. If we are not capable of bringing some light to this recurrent cry out of where is Europe every time we see all these embarkations coming from the west coast of Africa or from the other side of the other coast of the Mediterranean. And we didn't have any other idea than procrastinating in the wrong strategy, which has proved a failure. So obviously, if we are not capable, after all this energy and time-consuming work that we have put into it, to bring about the regulations as adopted, then what is to be expected of this thing in the foreseeable future? Not only because the forthcoming presidencies are Hungary and then Poland, which are the champions of insolidarity in this regard, the champions. I mean, Hungary and Poland have said it loud and clear. Over my dead body, you will bring some migrants of yours to my territory. It will never happen. And still they can be minorized, because that is the binding decision making of the European Union. We can build up a qualified majority by minorizing Hungary and Poland, no matter how much they cry that they will never take it. Well, it can be done. It can be. Let's see what happens next. Rulings, the European Court of Justice, infringement procedures, fines, and rule of law conditionality regulation too, for sure. But then the point is that at least we have to bring about some result in this mandate, and we are working real hard on it. And the final point I make is that surely you are concerned, you're worried about fundamental rights considerations. So are we. So are many of us. Not everybody in the European Parliament. It would be simply childish to picture that before you. Surely not the case. Surely not the case. In the European Parliament, you hear, wow, racist, jingoistic jargon day in and day out, for sure. But there's still a majority. And of course, with the progressive, we care about fundamental rights considerations. And we're bringing that in many fields of actions, particularly in this, external borders management, the so-called integrated external border management. When it comes to scrutiny on Frontex, when it comes to scrutiny on Europol, we exert parliamentary scrutiny in Europol. We care about the fundamental rights mandate, and that is the kind of added value that we have tried to put into the updating of the regulations of the relevant agencies, which are supposed to contribute with some added value with to the member states, particularly in search and rescue operations. And we have enhanced the fundamental rights mandate. We put a lot of pressure, causing the resignation of former Frontex director. There is a new director in place who has committed himself, is a man very strongly so to improve the situation of Frontex, to improve its commitment with fundamental rights, the so-called situation room, the surveillance, the operational dimension, and of course, putting in place the promised fundamental rights officers and monitors, for sure. We do care about that also when it comes to legal pathways, humanitarian visas. That's also a fundamental right consideration. Of course, it's not only about mourning all those who die in the attempt of setting foot on the shores of the European Union. It is also about opening up an alternative option for them not to be enslaved for life with the illicit trafficking of human beings and smugglers for the sake of giving it a try, whatever the cost, even at the cost of losing their lives. And of course, and I finalized, we are much committed to put in place, and that is the mandate of the European Parliament too, that was also my fight, a EU search and rescue framework. Because it is only obvious that many of the tragedies that we have warned regularly, dramatically, theatrically, the European Parliament, many of the tragedies and the casualties that we claim to be sorry of could have been spared, could have been avoided, prevented, if only the national coast guards would cooperate better, instead positively instead of negative. To me, it's a clear example. The tragedy in Pinos, not that far ago, was this year in February. Terrible. Handboats went to the bottom of the sea. Kids went to the bottom of the sea. Why so? Because the Greek Coast Guard got notice that they were aiming Italy. They were heading for Italy, and their strategy went, okay, you're heading Italy, then you're Italy's problem. You're not mine. Let it not be mine. So that I can not only take the responsibility of saving your life, but I also take the responsibility of sparking you, of granting you some status, of processing your requests, of feeding you up, of giving you some daily shower, of providing you some medical care, and then what else? If you're heading for Italy, okay, head for Italy. It'll be Italy's problem, not mine. We have to put an end to that negative understanding of so dysfunctional and so incompatible with the EU scale of the issue. So believe me, final point, there are many of us who are trying to bring about a new look towards migration. Many of us who are fighting the negative approach to migration and asylum related issues, which claim that they're a menace, a threat to our security and to our identity. Many of us who are trying to bring some positive approach towards migration as a fact. Migration is not a menace, not a threat, it's a fact. It's always been there. But many of us who are trying to fight the idea which is very installed in the Council of Ministers of Interior. Believe me, I have seen it live many times. I have disqualified as a dystopian many times, that best option, migration should exist. Second best, as some migration does exist, at least do whatever to keep it out of our sight. Pay whomever. Whomever is in charge in Libya, we pay him. Whomever is in charge in Tunisia, we pay him, so that they not make it here. That's a complete dystopia, doomed to fail. I know that it's not easy, and I know that I'm not sharing with you a very positive or optimistic assessment, but in the end, believe me, there are many of us who are trying to be up for this fight and bring about some positive change, and if possible, possibly bringing it before the end of this mandate. Some step forward that will not be of your liking, for sure. Maybe it won't be neither my liking, but at least will be some improvement of the situation we had when we got started this mandate of the European Parliament. That would be good. Thank you for your attention.
Thank you very much for your overview. Present moment and all the dossiers involved. And the question about which is very important. It's the migration. So I will open up a very short, limited time opportunity to raise some questions or some reflections. So,
Raise hand. Yeah, of course. One year ago, we adopted our first reading agreement, first reading, adopted the 5 regulations, all of them. And it was good news that day. It was good news because the balance, in my view, was more than expected. I was pessimistic when I got started. In the end, I was saying, listen, not bad. Now it'll come the council for sure. Then it'll be it'll be worse. But then we'll try to improve the council's general approach, which is always like night and day as to the parliament's first reading. It's not the first time I see something of the kind. The council has a very different logic as the European Parliament. I try to put it very graphically. In the European Parliament, we still behave as Europeans. The council, they have ceased to behave as Europeans. They are only compensating national interests among each other. Don't with this. You give me this, I give you this. That's it. No one thinks European in the council anymore.
Thank you very much for the overview. I have 2 questions, one technical, one political. So on the technical side, the dossier you have on the crisis regulation was supposedly going to be separate from the instrumentalization of regulation. But my understanding is that the member states are pushing to merge both.
Very much.
The problem is the Schengen Borders Code also was going to be incorporating an instrumentalization provision.
Yeah.
So what is the situation now? Is there any way the parliament can resist and keep the things separate? Because I think it would be better to keep them separate. Second question, if no agreement is reached in this mandate of the parliament, what do you think can happen? Because I mean, obviously the next parliament would probably be more to the right. So what is your forecast of what can happen if we don't reach an agreement in this legislature? Thank you.
Yes, third point.
Thanks a lot, Mr. Chair, for this fascinating, very uplifting and passionate speech. I feel listening now. And maybe I'll try to respond. My question concerns the recently adopted search and rescue plan resolution in the Parliament and its follow-up. Of course, it only 1 or so have passed since its adoption, but I'm just curious whether you can see any improvement or what kind of follow-up is given to the implementation of the search and rescue resolution.
Thank you so much. Any other point being made? Any point of interest? Any further comment? No, I thank you. Thank you for the points you've raised. As to the first one is, yes, we adopted our first reading, and at that point, I'm so sorry. I'm so sorry. I'm going to. Because I was reloading. I'm sorry. I didn't turn it off. I just reloaded. And the thing I wanted to tell you is that when it got started, it wasn't easy to combine efforts on the ranks and files of the Parliament. There are some views which are really progressive, and some other which are more reluctant, more national oriented. But in the end, there's still, as I put it, there is still a European breathing majority in the European Parliament, despite of course the multiplication of anti-European seats, of Europhobic rhetoric is there. That sure is already there in the Parliament and on the rise. But still, we managed to combine a good compromise. And yes, we knew that despite our position is first joint strategy, common approach. We're really stuck to the point. And second is a reasonable bet for the combination of shared responsibility and binding solidarity, including binding solidarity relocation programs, which are to be put in place by the Commission via delegated act with the help of a EU coordinator for relocations. It's a new institution that would like to see in place, despite that was the idea of the European Parliament. Yes, of course, we have seen in some years now how the position is like, how the Council is like, and I intend that the Council of Ministers of Justice and Home Affairs. Yes, of course, there are many in the Council who are not willing to accept by no means binding relocation programs and trying to find some alternative. That is why, of course, I can figure out that in the end, at the end of the day, there will be some form of, I could refer to some form of credible, effective solidarity, which should not be solidarity a la carte. That is the kind of compromise I can figure out. Some credible, effective solidarity, so that those who are not willing to accept relocation programs within their own territory, there will be at least contributing solidly, credibly, via some other means. As for the time being, they are claiming that they will be paying some €1,000 for every migrant that would not be willing to accept. Let's see how is the final balance. And the bad news is that they are insisting to merge crisis with a so-called instrumentalization file that was actually initiated by the Commission some year and a half ago. After the so-called weaponization of migrants by rogue state Belarus, led by rogue ruler Alexander Lukashenko, which inflicted a kind of damaged state of mind in the Baltics, which I have, of course, experienced myself a number of times. I have visited those countries, I have visited their retention centers. Well, for one thing, we're talking about small numbers. As compared to the Canaries, it's nothing. First starting, they claim to be overwhelmed by some hundreds. I say, there's not a weekend the Canaries wouldn't have some thousands. Not a weekend. The Canaries, you may have 2,000 in a weekend. What would you do then? Go hysteric? Ask us for Latvexit or lead to an exit? Or what would you do then? Would you challenge the whole system for some hundreds? So the thing is that they have managed to link with some other concerns around the council, namely Croatia, Austria, with contradictions among them. After all, but still they have managed to build up a coalition for merging with instrumentalization. That is completely in contradiction with the negotiating mandate of the European Parliament. So as for now, the European Parliament stands together not to accept it. Besides, there is a file on instrumentalization, which has been allocated actually to a far-right Polish MEP. But the thing is that the instrumentalization file has not proceeded properly because the Commission failed to annex the binding implementation, impact assessment on fundamental rights. Supposedly that impact assessment is due October the 6th, and supposedly the instrumentalization file could be resuming its legislative procedure with the committee chair October the 9th. In my view, that would be a better option. Of course, I'm not in favor of instrumentalization. It's some kind of a fabrication of a concern. I do object, but anyhow, it's Commission's initiative, precisely at request of those who were feeling like weaponized by Lukashenko. And in so much as there is argument within the Council about it, the Commission is leaning to concede, is willing to actually to concede to the principle. So it could be somehow handled in this other initiative, is the instrumentalization directive, not within the crisis regulation. So I'm trying to resist. Besides, because I have no mandate for negotiating instrumentalization, I have no majority to negotiate on behalf of the European Parliament on instrumentalization. So that is a challenge. That is a challenge because the Council has actually built up a compromise within itself, making concessions to those who are obsessed with instrumentalization. Not easy to combine within the Council, not even with those who have a better reputation of pro-European member states, not even within the so-called founding member states, not even between Germany and France. There are contradictions between them. There are contradictions between them. So in order to build compromises, they're making concessions on instrumentalization and making concessions on derogations, which are not in the mandate of the European Parliament. So it'll be a fight. It'll be a tug of war, but I insist that the time is kicking. Then you raise the question directly of what to expect if we fail. That would be real good news, real bad news. I mean, you may go cynic. I mean, at times, of course, you may assume that for the Council, it would be that bad. It wouldn't be that bad. A complete European failure to build up the European scale of response, because it would mean we are on our own. We are, again, national sovereign member states. We are the ones to decide. We are the ones to expel them. We are the ones to violate international humanitarian law. We are the ones to refuse safe disembarkation. We are the ones to close the ports of southern Italy. We are the ones to bring NGOs to the bench, put them to trial, and try to get them convicted as accomplices to the smugglers, which is the rhetoric of Meloni, by the way. So you may go cynic and say, hey, that is the strategy. I can see that. But I insist there should be some other way to come to a better outcome. There must be a way to come to a better outcome than that simply failing and leaving it up all to the member states again, like it was in the first place. So we're trying to insist, make some step forward, although it won't be extremely satisfactory or won't be extremely beautiful, but at least some step forward, which still keeps the European flame on fire. somehow. And then because in the short run, that would be a major blow, because I insist next presidency is Hungary and then comes Poland. That would be a complete year in which there would be no talk of it. It wouldn't be not even the agenda, not even in the agendas. If we fail here, if we don't take the opportunity and the great expectation that was aroused somehow by the Spanish presidency, then we'll be missing the whole point and of course the whole lot of work that we have put into it for the past 3 years. And then search and rescue. We are insisting so much in changing the rule here. We are trying to engage Frontex in the search and rescue operation. Engage the fundamental rights enhanced mandate on search and rescue operations. And we're trying to bring the European Commission to put in place the European search and rescue framework, which doesn't mean superseding the national efforts, because there is Guardia Costiera, there is Guardia de Finance, there is the Greek Coast Guards, there is, of course, Salvamento Marítimo in Spain. There are national individual efforts, but still they have to be combined together. Instead of some kind of, which is at times the rhetoric, some kind of maritime operation with a military component, as if you could prevent people in despair fleeing from lack of hope with some kind of cruisers or some kind of battleships displaced in the Mediterranean. That is completely, it's nonsense. That is complete nonsense. So we're trying the best to bring this change, but still some of the follow-ups, which are the mandates of the European Parliament, are pending. At least that we keep the legislative files on the road, on track. There are 5 files, 5 regulations. The largest is the so-called RAM, which is Asylum and Migration Management Regulation, which is the largest piece. It's supposed to supersede the so-called Dublin III, which is a regulation. What is Dublin? Ultimately, in summary, is the rule that allocates in the member state of first entry the responsibility of handling the asylum request and taking care of the asylum seeker and whatever international protection seeker. So it gives place to the recurrent rhetoric of name and shaming the secondary movements, name and shaming secondary, which is a recurrent argument in the Council of Ministers of Justice and Home Affairs. Member states blaming each other for secondary movements. Denmark says, "Hey, listen, I got these people, and they entered through Spain. Why did you fail to keep them in your territory? What are they doing in my territory? You are responsible to keep hold of them." That is a complicated matter, but that is the largest piece. Then there comes Eurodac screening, which are obsessive for the council because they are the so-called security pillar. Eurodac and screening are the security pillar, and the council is very much interested. That is why we blocked every negotiation on those files until they make up their mind in crisis, because crisis was about solidarity in the first place. I know that now there's solidarity, there's derogations, and there's instrumentalization. That'll mean a challenge for the negotiating team I lead, for sure. That'll be a challenge. But I can only reassure you by saying that the European Parliament has been opposing that idea of the Council for years. Let's see how it goes when it comes to the final end. We will have to compromise some way or the other. And I insist, final point, the result won't be my A plan. The result won't make me happy. I take that. The result won't be my liking. I take that. At least I want some improvement as to the situation that we've had so far. If that happens, then at least we have somehow made our share. Thank you.
Okay, right. So thank you very much, Professor Lopez Aguilar. Thank you very much to David Moya for hosting. And thank you all very much for staying until the end. We are ready to close. I would like to thank everyone for their contributions. Lunch is ready. We're going to go to the restaurants around the corner here in the faculty. Please follow Mirenchu, Laura, or myself, and we'll get you to there. If you would like to leave your luggage here, this room is going to be locked and reopened after lunch. So you don't need to carry your luggage with you to the restaurant. So thank you all very much also to the people who remained with us until the end online. The proceedings are being recorded. There will be the recordings available at some point soon next week on the IDP website. And watch the space for the guidelines and the paper's final versions being published soon. And that's it. Thank you very much all. Safe travels for those who are not staying for the lunch, and for those who are, please follow us up after the end. Thank you all very much. Yeah, and those who are online, bye now. Thank you very much.